Tabling of documents. Introduction of government bills. Déclaration des ministres.
Statements by ministers.
Rapport de délégation.
Reports from interparliamentary delegations. Presenting reports from committees. The Honourable Member for Yukon. Pursuant to our mandate under the standing order, I have the honour of tabling in both official languages the 37th report of the Standing Committee on Procedure and House Affairs on memberships of standing and standing joint committees. If the House will consent, it is my intention to move a concurrence of the report later today.
Dépôt de projet de loi.
Introduction of private members' bills. First reading of Senate public bills. Motions. The Honourable Member for Yukon. Mr. Speaker, if the House will consent, I move that the 37th report of the Standing Committee on Procedure and House Affairs, tabled in the House today, be concurred in. Does the Honourable Member have the consent of the House to move that motion? Agreed. The House has heard the wording of the motion. Is it the pleasure of the House to adopt the motion?
Adopted.
Adopted.
Presenting petitions. The Honourable Member for Renfrew, Nipissing, Pembroke.
Mr. Speaker, I'm pleased to present a petition signed by campers who stayed at a Windsor campground, the riding of Windsor-Tecumseh, and the petitioners call on the government to ensure that campgrounds with fewer than 5 full-time employees will continue to be recognized and taxed as small businesses. And Mr. Speaker, the campground owners were the canaries in the coal mine when it came to passive taxation of income on small business. And now we see it spreading across all facets of small business. And the people who are going to be hurt the most are the people at the lower levels of income, the people who are going to lose their jobs, the people who won't be able to afford groceries, and the people who don't have doctors because doctors are saying they're going to close up practice if they're close to retirement or move out of the country.
The Honourable Member for Nanaimo, Ladysmith.
Thank you, Mr. Speaker. I stand once again with many signatories in coastal communities calling for the federal government to legislate a solution to the long-standing problem of abandoned vessels on all 3 of Canada's coasts. Bill C-352 is my legislation that we, in the absence of the government proposing its own legislative remedy, we're calling on Parliament to adopt. It would designate Coast Guard as one-stop shopping and the first responsible agency. It would work with local governments and provinces to create incentives for people turning in their abandoned vessels, therefore preventing the pollution and oil spill risk, but also working with local salvage companies to work on the product stewardship and fiberglass recycling that might be one of the nuts we can crack around getting a solution. If the government were to accede to the signatories in this motion, they'd be in very good company. We've got resolutions of support from local governments from Vancouver Island in the west to the island of Newfoundland in the east, and next week the Union of BC Municipalities Executive is recommending to its Convention of Local Governments that they also endorse my legislation to solve the abandoned vessel problem. Thank you, Mr. Speaker.
Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker. I rise to present 2 petitions this morning. The first relates to an ongoing human rights case in which a Canadian, Saeed Malikpour, is being held in Iran, sentenced initially to death and then commuted to a life sentence for charges that appear to be, they are related to his creating a website, and he is not someone who should have been ever jailed at all, and is a case being upheld by Amnesty International. The petitioners call on Parliament to urge our Minister of Global Affairs to intervene on Saeed Malikpour's behalf and appeal to the government of Iran. The second petition, Mr. Speaker, relates to the issue of passports, such as the ones since February of 2012, that have not required proof of citizenship, including photographic identification. A large number of petitioners from throughout my riding raised this issue and urged that this matter be remedied. Thank you, Mr. Speaker.
The Honourable Member for Patry-Labouchere. Thank you, Mr. Speaker. Today I am presenting a position in the House that deals with the initiative of a constituent in my riding. The purpose of the petition is to create an immigration ombudsman My constituent feels that she was treated unfairly for the immigration request for her spouse. They've been a couple for 10 years. She's unable to have her spouse arrive, and regardless of all the procedures in place, she has not been able to achieve any results. We're hoping we will receive a favorable response from the government. Petitions?
Thank you, Mr. Speaker. I am tabling a petition today from 4,363 petitioners, which are drawing the attention of the House to the current situation in Venezuela. They draw attention of the House to the three following things: the censorship of media coverage of human rights abuses, the imprisonment of many leaders such as Leopoldo Lopez, Daniel Ceballos, and hundreds of students without the due process of the law, and the killing of unarmed citizens in peaceful protest, the armed lawless paramilitary gangs, the use of tear gas on the public and on elected officials. They are asking for two things for the government of Canada to do. They're asking for the freeze of financial assets of the government of Venezuela, including its commercial and refinery accounts, until the Maduro regime allows the democratic will of the people to prevail. They are also asking for the freeze of assets of the officials currently holding federal office in Venezuela and the revocation of any Canadian visas they may have until the Maduro regime releases political prisoners. Thank you, Mr. Speaker.
Presenting petitions, présentation de pétitions. Questions on the order paper. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, Mr. Speaker, I would ask that all questions be allowed to stand at this time, please.
Is it agreed? Agreed and so ordered. Orders of the day.
Government orders, government bills, Senate. Second reading of Bill S2, an act to amend the Motor Vehicle Safety Act. Mr. Garneau moves that Bill S2, an act to amend the Motor Vehicle Safety Act and to make a consequential amendment to another act, be now read a second time and referred to the Standing Committee on Transport, Infrastructure and Committees. Debate and the Honourable Minister for Transport.
Merci, Monsieur le Président.
Thank you, Mr. Speaker. Today I would like to introduce Bill S2, the Strengthening Motor Vehicle Safety for Canadians Act. The safety of the travelling public is of paramount importance to Transport Canada and to this government. Road safety is an issue that touches every Canadian in some manner. Many of us have either been directly involved or have loved ones that have been in some form of vehicle collision. Collisions and the associated injuries, death, and cost to society are tragic. However, to a great extent, they are preventable. Helping Canadians avoid tragedy on our roads is the motivation for pursuing the continued improvement of motor vehicle safety. We believe that the Motor Vehicle Safety Act, its associated regulations and standards, are key reasons why progressively fewer people have been killed and injured on our roads, despite the fact that more people are driving. Improving the motor vehicle safety regime is part of our commitment to the safety of Canadians.
The Vehicle Safety Act is to address safety issues related to vehicles on Canadian roads. The proposed amendments to the Motor Vehicle Safety Act will provide the government with new and better tools for making our roads safer. Mr. Speaker, the Canadian Motor Vehicle Safety Regulations are applicable to all vehicles designed to operate on public roads, from motorcycles to heavy trucks. They also apply to some off-road vehicles that are occasionally driven across or along the sides of roadways or on trails. The federal government uses the Motor Vehicle Safety Act and its attendant regulations to regulate vehicle and equipment manufacturers and importers, and to instill confidence in our stakeholders, including the provinces, territories, interested public organizations, and the general public. Mr. Speaker, the government has been heavily involved in improving and delivering vehicle safety for many years. The Motor Vehicle Safety Act came into effect in 1971. To keep the Act current and effective, it has been updated at various times throughout the years. As innovations and technologies continue to evolve, there remains a continuing need to improve the Act to ensure it remains current. La loi règle...
The Act regulates the safety requirements that apply to new and imported motor vehicles and to new motor vehicle equipment to reduce the risk of death, injury, and damage to property and the environment. The Act enables the development of regulations and safety standards for new and imported vehicles, for new tires, and for new equipment used in the restraint of children and disabled persons within motor vehicles. In addition to creating robust regulations, the increasingly rapid advent of innovative vehicle technologies requires that the legislative framework be agile so that it does not inhibit the adoption of new safety technologies. Canada risks losing ground in this very important market unless we take the opportunity to add some flexibilities to the Act. Continual improvement and adaptation to the environment helps keep Canadians safe. That is why we are proposing further changes to the Motor Vehicle Safety Act.
To the Motor Vehicle Safety Act were tabled in the House of Commons for the first time in June 2015 as Bill C-62 to address safety gaps. The bill attained first reading before Parliament was dissolved. With a few additional provisions, the bill was introduced to the other House as Bill S-2. It has completed its process there and is now being brought before this House. While there are a number of proposed amendments that I will outline, the most significant ones have to do with motor vehicle and equipment recalls. Generally, the major vehicle manufacturers and importers have a good history of addressing safety defects in Canadian vehicles. However, if a situation arose today with a vehicle, tire, or child seat where there was clear evidence that the product contained a safety defect that could put the safety of Canadians in jeopardy, and the company did not agree and wasn't voluntarily issuing a recall, there would be little that could be done except to take the company to court. This would result in delays in addressing safety concerns. As such, it is proposed to amend the Act to authorize the Minister of Transport to be able to order a company to correct a defect or non-compliance in a vehicle or equipment if the Minister considers it to be in the interest of public safety. Under such an order, there will be three options available for companies to correct the defect or non-compliance. The first option available to companies would be to repair the vehicle or equipment. The second is that the company could replace the vehicle or equipment with a reasonable equivalent. Finally, the company could choose to reimburse either the repairs costs to the vehicle or equipment that have already been undertaken, or the sale price of the vehicle or equipment less reasonable depreciation.
In addition, the bill includes the power to order companies to pay the costs of correcting a defect or non-compliance in a vehicle or equipment. These provisions can have a significant impact on safety. The combined order powers is mindful to avoid a potential situation where the owner of the vehicle does not have the means or does not want to pay for the correction of a defective or non-compliant vehicle. Such situations would place an unreasonable financial burden on Canadians and potentially place other Canadians at risk should their fellow citizens be unable to undertake the necessary repairs. Provisions have been drafted to help ensure that manufacturers would be responsible for costs pertaining to the repair of known safety defects. To help ensure that new vehicles or equipment with safety defects or non-compliances don't reach Canadians, the bill also contains a provision for the Minister to order companies to ensure that defects and non-compliances are corrected before the vehicles are sold to consumers. This measure will help keep vehicles with safety issues from being driven on Canada's roads. These order powers complement the existing power to order a company to issue a notice of defect or non-compliance. They address a key gap in the motor vehicle safety regime that will, once passed, help ensure that vehicle safety issues are corrected.
Beyond these powers, other powers will be introduced into Canada's motor vehicle safety regime. Vehicles on Canada's roads are incredibly sophisticated machines with complex and proprietary computers and software. Their complexity is only going to increase in the years to come. This complexity could make it challenging to obtain information related to defects or collisions, or verifying compliance with the Motor Vehicle Safety Act. As such, this bill includes the authority for the minister to order companies to conduct tests, analyses, or studies on a vehicle or equipment, and to require them to provide those results to Transport Canada. This new ability to order additional studies will be very valuable to help determine details around safety issues. As part of the proposed amendments, there will also be a requirement for companies to provide a contact person within the company that we can reach out to for information and to verify compliance with the Motor Vehicle Safety Act. This requirement would help in the establishment of clear lines of communications between companies and Transport Canada. Même si Transport Canada jouit de bons rapports.
While Transport Canada has good lines of communication with the large manufacturers and importers in Canada, which will continue, complete reliance on these informal mechanisms is risky. Formal, clear lines of communication will help in ensuring and increasing the safety of Canadians. The proposed changes to the legislation will also increase the ability of Transport Canada to verify compliance with the Act and identify and analyze defects and collisions. The bill clarifies where and how Transport Canada's inspectors may access sites in the discharge of their duties. Bill S2 also adds the ability to require the presence of persons who may be questioned on matters related to an inspection and require that all reasonable questions be answered. These proposed changes will help ensure that our inspectors get the information that they need to help ensure that companies are complying with the Motor Vehicle Safety Act. While the authorities, requirements, and tools already discussed will help to ensure the continued safety of Canadians, there remains a gap in terms of enforcing the Motor Vehicle Safety Act and its regulations. Currently, the Act has only limited enforcement tools to encourage compliance from companies. If a violation is suspected, Transport Canada notifies the company and later follows up to monitor that any corrective action has been taken. If corrective action has not been taken, the only current option available to the department is criminal prosecution. This is time-consuming and costly for industry and the government, and in some instances may not be fully appropriate for a given violation. As such, the proposed changes introduce an administrative monetary penalty regime that will help encourage compliance from companies as an efficient, effective, and less costly alternative to criminal prosecution. Companies will also have the ability to appeal an administrative monetary penalty to the Transport Appeal Tribunal of Canada. The review process will examine if the company or person has committed a violation under the Act, and if so, whether the penalty that was levied was appropriate. In specific cases, actions rather than fines may be more appropriate or have greater benefit for Canadians. such as a safety promotion campaign or changes to a company's safety culture.
This tool, known as consent agreements, will create that authority. These agreements will authorize the minister to negotiate a mutually acceptable agreement that will result in enhanced motor vehicle safety for all Canadians. These agreements will be registered in federal court and published. Once published, they would have the status of a court order. Together, the addition of administrative monetary penalties as well as consent agreements will dramatically increase the enforcement options available under the Motor Vehicle Safety Act. The proposed additions to the Act are, however, not exclusive to the enforcement and compliance regime. As noted, vehicle technologies are advancing at an ever-increasing pace. This is particularly an issue as the automation and connectivity of vehicles increases and as new environmental technologies are further examined and developed. As these new technologies emerge, there may be benefits in terms of safety, innovation, or the environment. However, sometimes our regulations may not be able to keep up with these changes. As such, it is proposed to adjust the interim order and exemption provisions of the Motor Vehicle Safety Act to help ensure the flexibility to support these innovations while concurrently maintaining safety for Canadians. An interim order allows the temporary suspension or modification of an existing regulation while a permanent regulatory change is being developed. It can signal to industry and Canadians that a regulatory change is in progress, but allows for the early implementation of such advancements. It is proposed to amend the interim authority to extend the period of such an order from 1 year to 3 years to allow sufficient time to complete the formal regulations and allow the earlier adoption of new technologies that can benefit Canadians. In addition, it is proposed to make the current exemption process more efficient. This will support the adoption of new technologies or vehicles. The proposed powers will authorize the minister to grant an exemption from current standards in instances where it will support new safety measures or new kinds of vehicles and technologies, but not compromise the safety of Canadians. Exemptions would be available to companies that apply for them and can demonstrate that the safety of Canadians would not be compromised. The exemptions would be made public, ensuring a transparent and fair process. Ces mesures contribueront à assurer que la loi.
These measures will help to ensure that the Motor Vehicle Safety Act continues to protect the safety of the driving public while not hindering innovation and technologies that can also benefit Canadians and their safety. This powerful suite of much-needed changes to the Motor Vehicle Safety Act will increase the tools available to government and industry requirements while still keeping the focus on the safety of Canadians on the road. As you are aware, the other chamber amended the bill, amended it to add certain additional protections for dealers. We believe these changes were well-intentioned and they were useful in bringing to our attention some concerns that dealers had about the impact of recalls on their industry. I thank our colleagues in the other chamber for their efforts. However, we also believe that these provisions, as presently constituted in the amended S2, go beyond the authority and the purpose of the Act, which is to protect the safety of the driving public, not to manage contractual financial matters or the relationship between dealers and manufacturers. Such an amendment, were it to remain in the legislation, may create imbalances between dealers and other purchasers, one having advantages over another. It could also generate legal challenges when it comes to enforcement authority over dealers. As well, it could cause unintended consequences, such as leaving no recourse for manufacturers when they do not meet their obligations. These types of issues could potentially have consequences on the commercial relations and agreements that dealers have with manufacturers. The amendment also does not take into account that there are other mechanisms to protect the commercial interests of dealers. Again, I recognize the changes introduced in the other chamber were well-intentioned, and they are an example of the healthy back and forth that takes place between our two chambers. We believe it possible to address the concerns of dealers while avoiding the unintended consequences I've mentioned. We know that dealers care about safety and will want to work with our government and with parliamentarians in modernizing the Motor Vehicle Safety Act so that Canadians win.
For rapid action on the part of the elected officials to move Bill S2 forward. Canada's ability to more fully address its oversight role and its ability to properly assess the safety aspects of new technologies depends on the success of this bill. Mr. Speaker, I look forward to the bill going to committee and the study of its provisions, including the implications and consequences of the proposed dealer amendment. I support and vote for the committee to undertake a thorough analysis. I look forward to testifying in front of the committee with departmental officials and working with parliamentarians to strengthen the Act and make the roads safer for all Canadians. Thank you, Mr. Speaker.
Questions et commentaires.
Questions and comments.
Member for Carlton Trail, Eagle Creek.
Thank you very much, Mr. Speaker, and I want to thank my honourable colleague, the Minister, for his remarks, and I do look forward to working him throughout this next session on some of the different pieces of legislation that we will be having before us. But as it pertains today to S2, as the Minister noted, Mr. Speaker, similar legislation, C-62, in fact, almost identical legislation, was introduced by the former minister in June of 2015. But upon review, we do note that S2 differs from C-62, specifically with some new provisions in Section 16. And I'm wondering if the minister would expand on the differences between C-62 and S2 and provide us with a little bit of rationale.
The Honourable Minister of Transport.
Well, I thank my honourable colleague for a comment, and in fact she's right. As I mentioned, Bill C-62 was originally presented by the previous government and had a large number of measures which are good measures that are in S2. Where we differ is that we did introduce a few additional points. One is the power to negotiate consent agreements, which I spoke about, the power to enter into administrative agreements. We think this is a better flexibility as opposed to having always to go to court, which is a long and expensive process. Thirdly, broaden the duration and scope of an interim order power, and this is aimed at trying to provide flexibility to those manufacturers developing new technologies where there may be a requirement to be flexible on regulations that concern safety in order to allow them to develop these new technologies. And finally, broadening the scope of exemption orders and allowing ministerial approval. And this is all aimed at trying to provide additional flexibility, particularly for the manufacturing sector, where they're developing new technologies, but have to still comply with safety regulations. So I thank the previous government for Bill C-62. I think the vast majority is and we're not really changing any of that, was well conceived. Unfortunately, it only got to first reading, and we're carrying on with it, and we hope that there will be a speedy adoption of this bill for the good of Canadians. Thank you.
Questions and comments. Questions et commentaires. L'honorable député de Trois-Rivières.
The honourable member for Trois-Rivières. Thank you, Mr. Speaker. And I'd like to thank the Minister for his speech this morning. I will soon be able to react to what he's had to say. And we want to study this as quickly as possible in committee because it has to do with the safety of all citizens. This bill has very interesting measures. My question has to do with the last audit on motor vehicle safety done by the Auditor General. I'm not really talking about gaps, but certain questions for the department. For example, there were significant cuts in collision testing, something that the government and the minister sees as part of its current practices. Do you think this doesn't go counter to the very spirit of the bill we're looking at this morning? My question is simple. How can the minister both value the measures in this bill and the cuts that have been made in his ministry over the recent years? The minister, I'd like to thank my colleague for his question. And we have been following the Public Accounts Committee. That committee made recommendations, and we are reviewing them. We know that road safety in Canada is something that is extremely important. The member mentioned testing to see what happens in the case of collisions. And I'm very proud that we have facilities in Blainville which allow us to carry out these tests, not only for cars, but also for children's seats. And as you know, in the 2016 budget, we added $5 million to continue enhancing the equipment used in testing, especially for cars that are now being developed. We need things which have instruments outside, because there is the possibility that a car could explode when it runs on batteries and other forms of fuel. We have to make sure that they're safe. So we're going to increase our visibility and our evaluations of vehicles. And for us, this is a priority. Motor vehicle safety. Questions and comments? The Honourable Member for Hamilton West.
Mr. Speaker, and I'd like to begin by thanking the Minister for his speech this morning. In his review or overview, he spoke about the Minister's ability to move forward with the correction of defects. And so I'd like the Minister to expand on this and speak about why this power is important and how it will relate to ensuring safety for Canadians.
The Honourable Minister of Transport.
I thank my colleague for her question. And yes, specifically, and I did say it in my presentation, at the moment, the law as it stands only obliges manufacturers to issue notices of defect. It does not oblige them to take any further steps. I'm glad to say that in the great majority of cases, manufacturers go that additional step of going through the recall process and, in fact, repairing the defects at no cost to the owners. And that's a very good thing. However, they're not obliged to do it, and there are circumstances where they may decide to contest an assessment that's been done by Transport Canada that points to what we consider to be a safety defect. So this law, which is very similar to what's in the United States, provides those additional ministerial powers in cases where there may be a difference of opinion between the Government of Canada, Transport Canada on safety issues, and the manufacturer to compel manufacturers to take action, including issuing the recall and also fixing it at no cost to the person who bought the vehicle. And also in certain cases where we don't have the capability to do all the analysis because of proprietary technologies that's in the car, we can also order manufacturers to conduct certain tests in order to establish, while respecting the proprietary nature of the technology, in order to establish whether in fact there is a safety defect. We think that these are powerful tools that are required to ensure the safety of Canadians.
We have time for a brief question. Questions and comments. The honourable member for Battle River Crowfoot.
Thank you very much, Mr. Speaker, and thank you, Minister, for bringing us the update and on this bill. Also for referencing the Public Accounts Committee, which I chair. We have brought forward the recommendations that you cited, and we look forward to the strategy and the timelines that your department has. But my question, you said that, or Mr. Speaker, the minister stated that the way I understood it, that he didn't necessarily support the Senate amendment. And I'm just wondering the ability of being able to work this through quickly, as he said he wanted to do when we aren't, or when you are not, or when they are not necessarily supporting the Senate amendment. The other question that I would just quickly have is, because safety and vehicle safety and transportation is such an integrated industry with the United States, how does this legislation relate to the legislation that the United States is presently under? Is this advancing further, or is it fairly equivalent to the United States?
The Honourable Minister of Transport in 60 seconds or less, please.
Okay, very quickly. Thank you for the question. I think it's very close to what's in the United States. There are a few wrinkles that are a bit different that we feel were important for Canada, but largely it's as it is in the United States. And with respect to the Senate amendment, their intentions were very good intentions, and it pointed out that dealerships do have certain preoccupations. However, Bill S2 is the Motor Vehicle Safety Act. It is focused on safety. It is not focused on the relationship between dealerships and manufacturers, many of whom have confidential agreements between them on what to do in situations like this. So, yes, we are aware that dealerships have preoccupations. We believe that it can be addressed. We're going to refer this issue to committee, and of course the committee is in its sovereignty free to decide how to do it. But we think that it's important to point out that the Motor Vehicle Safety Act is primarily focused on safety and not the financial relationship that exists between dealerships and manufacturers. Thank you.
Resuming debate, the Honourable Member for Carlton Trail, Eagle Creek.
Thank you very much, Mr. Speaker. I am pleased to rise and speak to Bill S2, an act to amend the Motor Vehicle Safety Act and to make a consequential amendment to another act. This bill was introduced in the Senate by the Leader of the Government in the Senate on May 11, 2016, referred to the Senate Standing Committee on Transport and Communications in October, and 1 month later, the committee reported the bill back to the Senate with an amendment. The bill passed third reading in the Senate as amended on February 2, 2017. So it has been in the queue for some time. In fact, I recall being on call every evening of the last week of the last session, prepared to debate this legislation introduced in the Senate. This issue is important. Whether via public transit, personal vehicle, foot or bike, nearly every Canadian relies on roads to get around and or receive the goods and services they need on a daily basis. A trip to the grocery store may feel routine to the drivers and passengers, but millions of hours of work have gone into designing the technology and innovations that power the vehicles we travel in. As with anything that has thousands of moving parts, and despite the best of intentions, occasionally systems don't work as they were designed to. That's why Canada needs a robust regulatory regime that ensures Canadians are informed of risks and the vehicles that are a safety hazard to the driver and passengers, as well as other road users, are repaired or taken off the road with haste. I'll discuss the content of the bill further in my remarks, but first I think it's important to note that beginning in November 2015, the Auditor General began a 10-month examination on the efficacy of the processes at the Transport Canada Motor Vehicle Directorate. His report was published on November 29th and is worthy of further study. The overall message highlighted a number of issues, and I quote from the introduction. Overall, we found that Transport Canada did not develop motor vehicle safety standards to respond to emerging risks and issues in a timely manner. We could not always determine how the department used evidence and research to develop or amend safety standards, end quote. I will discuss the Auditor General report in greater detail later in my remarks, but for now I will just note that the measures included in S2 will have no bearing on many of the structural problems uncovered by the AG in his fall report. By and large, auto manufacturers voluntarily initiate recalls. In 2015, 5 million passenger vehicles were recalled in Canada. That's 5 million vehicles recalled out of just under 24 million licensed vehicles in Canada. In fact, between 2010 and 2016, manufacturers issued at least 318 recalls for which Transport Canada had not received any complaints. Most of the time, when an issue is identified, whether by the manufacturer or Transport Canada, the manufacturer begins a recall. The manufacturer gets in contact with each impacted vehicle's owner, and the vehicle is repaired at no cost to the owner. It's almost routine. But on occasion, a difference of opinion exists between Transport Canada and a manufacturer. Right now, the Motor Vehicle Safety Act limits the role the Minister of Transport can play in issuing notices of safety defects and criminally prosecuting manufacturers when a potentially dangerous flaw is found. The reality is the last time a Minister of Transport criminally prosecuted a manufacturer was nearly 25 years ago in 1993, when Transport Canada took Chrysler Canada to court over defective tire winch cables. The case was dismissed in 2000. So criminally prosecuting manufacturers has not proven to be an effective or efficient way to ensure compliance with the Motor Vehicle Safety Act. Since that last prosecution 23 years ago, manufacturers have voluntarily issued thousands of different recalls. So what does this legislation do, and how does it make our roads safer? Sections 10.5 and 10.51 amend the Motor Vehicle Safety Act to provide the Minister of Transport with the authority to order a recall and order companies to correct the defect at no cost to consumers. I think the intent is pretty straightforward here, but the process outlined certainly is not. The Minister must, before issuing any order, make a preliminary determination on the basis of testing, analysis, inspection, examination, or research that the Minister considers appropriate. Then he or she must notify the company in writing and publish a notice of preliminary determination and invite persons to make comments in writing. Here is where the ambiguous language shows up, and I quote, "The Minister shall not make a final decision that an order is necessary unless the Minister has taken into account information that he or she considers relevant," end quote. It begs the question, how else would a Minister make a decision other than taking into account information that he or she considers relevant? I do find it surprising that the Minister can make a decision based on information that he or she considers relevant, which may be anecdotal, rather than on repeatable testing and facts. Once again, nearly 5 million vehicles were recalled last year in Canada, so it's not as though manufacturers aren't generally being proactively cautious, and this tool will not be used with any frequency, if ever. Since sections 16.01 and 16.1 give the Minister of Transport the power to impose financial penalties on companies up to a daily cap of $200,000 depending on the offense. Additionally, this section grants Transport Canada the authority to oppose non-monetary penalties on companies referred to as compliance agreements to promote acquiescence with the Act. Furthermore, this section gives the Governor and Council the discretion to prescribe by regulation the total maximum payable for a related series or class of violations. Overall, Section 16 is straightforward. If monetary and non-monetary penalties are properly applied, they can have a positive impact in promoting compliance with the Act. Section 10.4 of the bill increases the number of notices that a company must send to consumers once a recall process has been initiated. The issue that has been highlighted in the Senate about Section 10.4 is that parts or the technology to fix a defect are not always available, and a date for when a repair will be possible is not immediately known. Theoretically, companies would be required to send a new notice every time that a new timeline for repairs has been established. In the case of Takata airbags, where millions of cars were affected and the company had gone bankrupt, estimates on when new parts would become available were changing every day. A manufacturer would theoretically have had to send out an updated notice of recall on every update. As consumers start getting multiple letters advertising yet another day for when new parts or a new fix will be available, there is a real risk that these notices will begin to be ignored, and the number of vehicles that are brought to a dealership for repairs could drop below the current 78%. Section 15 of the Act gives Transport Canada inspectors significant new powers. Some of these powers are quite surprising for what is considered technical legislation, so I'll quote directly from the bill. For example, the inspector may enter on or enter through or over private property without being liable for doing so and without any person having the right to object to that use of the property. Examine any vehicle, equipment, or component that is in the place. Examine any document that is in the place, make copies of it, or take extracts from it. Use or cause to be used a computer or other device that is in the place to examine data that is contained in or available to a computer system, or reproduce it or cause it to be reproduced. Remove any vehicle, equipment, or component from the place for the purpose of examination or conducting tests. So to summarize, an inspector can enter into any private property so long as it is not a private dwelling without being liable for trespassing. Inspect any vehicle or equipment, copy any data from a computer, and remove any equipment for further testing. All this to verify compliance with the Act rather than to verify non-compliance. The difference is significant. Verifying non-compliance implies that the inspector is following up on a series of complaints from consumers or an investigation taken up by Transport Canada engineers. Verifying compliance implies that Transport Canada can conduct inspections without having to demonstrate cause for doing so. In our justice system, where the presumption of innocence is the foundation of all, the burden of proof is on the one who declares, not the one who denies. The Act also gives the inspector strong authority to order testimony at manufacturing plants, and I quote, "Every person there shall answer all of the inspector's reasonable questions related to the inspection, provide access to all electronic data that the inspector may reasonably require." End quote. This gives an inspector the power to interview not just managers and the owners of a facility, but the line workers without their union representatives present. Whether the information collected during these spot interviews could be used during a prosecution is not defined in the Act. Reasonable is also a loose term that should be better defined, beyond getting to a less ambiguous definition. If there is a disagreement between an employee and an inspector over what is reasonable, who will settle that dispute? Section 8.1 of the Act gives the minister the power to order a manufacturer to conduct specific tests on their products to verify compliance with the Act. Transport Canada will never have the same resources and know how manufacturers have to test their own products. So this section partially rectifies the asymmetry of information. The problem here is that you can't ask for something if you don't know it exists. So while requesting a test is good, it is a lot like fishing. There are no guarantees. Section 13 gives the minister the power to suspend an existing regulation for a period of 3 years or less, if it is in the interest of public safety to do so, or if this exemption will promote innovation that will make vehicles safer. I believe lengthening the amount of time the minister can suspend a regulation from 1 to 3 years will give companies more time to experiment and test new processes. This is overall a good thing. So what is missing in this legislation? This bill does not cover important replacement parts like windshields, brake lines, brake fluids, or replacement airbags. These areas are covered in the United States. So I am surprised that they are not a part of the legislation we are discussing today. Earlier in my remarks, I referenced the Auditor General report on the Motor Vehicle Safety Directorate at Transport Canada that was released in late November of 2016. The report noted that Transport Canada gives disproportionate influence to manufacturers when writing up regulations or when looking to amend existing regulations. This is important because broad public consultations on safety-related issues do keep our roads safe. Unfortunately, S2 does not enshrine a requirement to consult beyond manufacturers. Considering S2 spells out in incredible detail what steps the minister must take before ordering a recall, I'm surprised a similar process for setting new and amending existing regulations can't be enshrined in law. The Auditor General also found that despite years of research regarding the need for stronger booster seat anchors, as booster seats now weigh more, Transport Canada did not implement regulations that follow the findings of their research because it would be, in this case, detrimental to trade. There is no purpose in having Transport Canada conduct years of research on a safety matter if we will only implement it after the United States does. S2 won't address this problem. Section 4.42 of the Auditor General report noted that Transport Canada possesses incomplete data on collisions and injuries in the National Collision Database because provinces are not providing the information. Furthermore, Section 4.43 notes that Transport Canada does not have access to data from insurance companies, hospitals, police, and others involved in vehicle safety matters. So they are missing information that could help inform future vehicle safety priorities. Neither of the issues concerning data quality raised by the Auditor General report will be fixed or even partially addressed by S2. Finally, the Auditor General noted that the Motor Vehicle Safety Directorate had experienced budget compressions in 2016 and subsequently did not have a long-term operational plan for its activities. For example, the budget for crashworthiness testing was cut by 59% for the 2016-2017 fiscal year. At the same time, funding for 6 regional teams situated in engineering departments in universities and colleges that were charged to assist in outreach activities on vehicle safety also saw their funding cut. These regional teams will no longer be able to feed information into the regulatory decision-making process, which the Auditor General had noted was not functioning as well as it could be. Yet despite these cuts, the department chose to announce the construction of a $5.4 million outdoor crash barrier at the Motor Vehicle Testing Centre in Budget 2016. Try and square that circle. Given that the budget allocation for testing had been significantly reduced, the Auditor General questioned the rationale for proceeding with the project. Whether this item would have been included in Budget 2016 if the Auditor General had not started his evaluation is unknown. In conclusion, Mr. Speaker, while Bill S2 will help advance vehicle safety, I believe there are clear omissions. I do hope that the government will be willing to consider amendments to approve this piece of legislation and motor vehicle safety in Canada. Finally, I do note that per U.S. statistics, less than 5% of all motor vehicle injuries and fatalities can be attributed to vehicle maintenance and vehicle safety-related defects. While a good start, more attention needs to be given to addressing the other 95%. Thank you, Mr. Speaker.
Questions and comments? Question et commentaire. The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. And I'm a bit surprised in terms of how the Conservatives are inclined to approach this bill. When we take a look at the principles of what it is that we're actually going to be debating today, we have a government that has recognized how important vehicle safety is in all of our communities throughout our country. We have a minister that has really taken it very much head-on in regards to trying to provide legislation that is going to protect consumers while at the same time make our streets and roads a safer place. And enabling the minister to have more authority to do so is the principle of the legislation in good part. So my question to the member across the way is, why would the Conservatives not understand the benefits of seeing this legislation ultimately passed so that we could in fact have safer roads, more accountability in our automobile industry, and a minister that has the authority to make some of the changes that are necessary that our consumers want to see, let alone making our streets a safer place for all.
The honourable member for Carleton Trail, Eagle Creek.
Thank you very much, Mr. Speaker, and I do thank my honourable colleague for the question. I'm not sure what he took away from the remarks that I've made on S2. Certainly, while the legislation in front of us is very similar to C62, there are some differences. It is not the same bill, and there are new measures in this bill, and certainly an amendment that's coming forward from the Senate that we would like the opportunity to review. We know we will be reviewing it, and I look forward to supporting this bill at second reading to get it into committee. Thank you.
Questions and comments? Questions et commentaires. L'honorable député.
The honourable member for Trois-Rivières. Thank you very much, Mr. Speaker. I'd first like to say that I always listen closely to what my colleague from Transport says in the House, because she pays close attention to the bills, and I do share some of the questions that she has raised this morning. And obviously our consideration of the bill in committee will allow us to go further into these issues. But here's my fundamental question. Was there any sort of paradigm change within the Conservative Party? Because it seems to me they've always been the champions of self-regulation. And here we have Bill C-62, which was the ancestor of S2. A few months before the election in 2015, how is it that the gaps in S2 were not addressed in C-62? And how is it that after so many years in government, Bill C-62 arrived so late? Because it could have been passed much earlier to guarantee the safety of all vehicle drivers in Canada.
Carleton Trail, Eagle Creek.
Thank you, Mr. Speaker, and I do want to thank my honourable colleague for his question. I, too, appreciate the opportunity to work with him on the Standing Committee for Transportation, Infrastructure and Communities, and I do appreciate his comments. I recognize that Bill C-62 was introduced in June of 2015, just prior to an election being called, but I can reassure him that consumer safety is important not only to me, but to our Conservative caucus, as I'm sure it is for everyone in this place. And without rehashing old battles, I suppose that if the opposition parties in the 41st Parliament had not obstructed the previous Conservative government so much, maybe we would have gotten to Bill 62 a lot sooner than we did in June of 2015. Again, I don't think it does any of us any good to rehash what happened in the last Parliament. What we have before us is S2, and I think I can speak for my colleagues in the Conservative caucus to say we look forward to being able to review this bill in committee, to ask the questions that we have, and to provide amendments that will strengthen it. Thank you.
Questions and comments? The Honourable Member for Central Okanagan, Similkameen Nicola.
Thank you, Mr. Speaker, and I certainly want to thank the member for her contribution in this debate. I am quite concerned, I have to say, Mr. Speaker, in regards to the provisions around compliance versus non-compliance. Vis-a-vis someone from the government can basically walk into a workplace and basically have full access to look for compliance versus non-compliance, which this member has pointed out is quite a vast difference. One is a big government response where they could basically, any workplace is open at any point, versus a targeted approach where we're working to make sure that consumers are protected when concerns are raised. One uses resources and draws away from people's time, and the other one is targeted. So, Mr. Speaker, I'd like to ask the member what steps further can the government take in addressing this concern?
Well, member for Carlton Trail, Eagle Creek.
Thank you very much, Mr. Speaker, and I do appreciate my colleague's question. This is one of the reasons why I highlighted this section in my remarks on this piece of legislation. I think something that the government can do to address the concerns that we are raising is be open to doing a genuine study of the bill and taking a look at this section to ensure that that the issues that I highlighted in my speech are addressed and that they will be open to amendments that we may come forward with. Thank you.
Questions and comments? The Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I thank my honourable colleague for her presentation. And given that she also recalls the 41st Parliament, the first introduction of this Act, I don't know if she has any insights as to this. It may be inappropriate to ask her to expect her to have an answer, but I didn't get a chance to put the question to the minister. And I'm curious as to why a bill that is clearly a government bill supported by the minister comes to us by way of the Senate. I mean, it is based on what came forward initially as a government bill in the 41st Parliament, and I'm always curious when something begins its life in the Senate instead of beginning here in the House.
The Honourable Member for Carlton Trail, Eagle Creek.
Thank you very much, Mr. Speaker, and I do thank my colleague for the question. I think I would be speculating if I tried to answer the question as to why the government decided to introduce this bill through the Senate. However, given that the Senate did review the bill and has put forward a substantial amendment, I think it behooves us to give it the full review that it deserves. And I do hope that when we get into when this bill is referred to committee, that we are able to study it fully and take a look at the amendment that the Senate did put forward. Thank you.
Questions and comments? Questions et commentaires? Reprise du débat, resuming debate. L'honorable député.
The Honourable Member for Trois-Rivières. Thank you very much, Mr. Speaker. And thank you, colleagues. The session is getting off to quite a start, a fast start, speaking of automobiles. Now, I want to tell you how pleased, given that it's the beginning of the session, I am to be here. And it is always with a feeling of honour that I recall the mandate that I've been given by my constituents in Trois-Rivières. They've given me a very important mandate, and that is to be an opposition member, a member in opposition, and that is an MP who holds the government accountable for the choices it makes. As a parliamentarian, we don't necessarily control the legislative agenda, but we do everything we can to ensure that the bills that are tabled by the end of the process are the best they can be, and that through our contributions we can improve them. So I would say there are three categories of bills that we debate. There are unfortunately those rare bills that are unanimously adopted. Then there are other bills, like the one we are debating today, S2, bills where the main principles have consensus, are the subject of consensus, and that require the best development possible, the best implementation possible. And then there's a third type of bill that is not S2, but I'm sure there will be bills like that in this session, bills where there's a very strong divide between the parties on the subject matter. Now, throughout these debates, I want to say that I will, most likely quite often, ferociously examine and closely examine the issues, but I will not attack individuals. The voters who elected me are the voters who elected all members in this House, regardless of their political stripes, and therefore it is up to us to find the best formula. Now, every time the House wraps up its work, we always thank the staff that have made that work possible. But I'd like to start out like that because after 6 years in Parliament, I've become more and more aware of how important the work is of these people and the workload that we impose on them given the nature of our work. And yet we see them come back for a new session with smiles on their faces and with the willingness, once again, to serve Parliament and serve democracy. And therefore, they deserve all our thanks and congratulations. So I'm doing that in advance. Now, let's move on to this bill, S2. S2 deals with motor vehicle safety. Now, I'm not the only one here to say this, but I think I'm in a good position to talk about it. We are many kilometers away from Trois-Rivières, but we can't go by plane to Trois-Rivières to Ottawa. We have buses. However, you have to do bus transfers. And we also don't have a passenger train. So, in the end, I only really have one option for getting here, and that is to use a motor vehicle. And that means that week after week, I have to drive about 800 to 900 kilometers. Now, there are some who have to drive more, but what I'm trying to say is that every time I drive on the roads that go through urban centers, or when I have to drive faster, of course, under the speed limit, every time I have to drive faster on the highways, I have an opportunity to see, unfortunately, many accidents due perhaps to the drivers, but also due to mechanical problems that we would like to see disappear. Now, what has disappeared is a time when we could all just do our own minor repairs in our vehicles because mechanics were a relatively simple thing, but that's not the case anymore. And even most dealerships have a hard time diagnosing problems. Now you have to actually hook up the vehicle to a computer that does the diagnostics work, and then after, the mechanics are responsible for the repairs or maintenance in order to deal with the problem. So the whole motor vehicle market has changed and evolved. Now, I'd like to start out with a criticism, because once again, the government has come forward with a bill, and I must say the same thing used to happen under the Conservatives, but once again, this government has come forward with a bill that they're sort of calling a harmonization bill. It's a bill, or that I would say is a harmonization bill. Because here what we're doing is trying to harmonize what happens in Canada with what's happening in the United States. Well, that's all very well. However, here's what I want to point out. In Canada, when we talk about harmonization, what we're implying by that is, in fact, catch-up. We're always behind when it comes to American legislation and safety. And we're still, it seems to me, that we could actually be leaders. But no, we're not. We're in catch-up mode, and S2 is another beautiful example of that. This is a bill that has many virtues, and I've already told the minister that we will be voting in favor of second reading in order to make sure that this bill is considered in more detail by the committee, where all of us, I think, have the same goal, which is to end up with the very best bill possible. However, it would be interesting to see how Canada could become a leader rather than be trying to catch up. Now, I had an opportunity to put a question to the minister, but I would like here to say again, talk about the intentions of the bill that, yes, are virtuous, versus the reality that exists within Transport Canada. In the last audit by the Auditor General, there were several comments that were made, and I'm going to quote the Auditor General here because I think he says it much better than I could, and it's about this reality that I'm concerned about. Overall, he says, Transport Canada had not, in a timely manner, drafted motor vehicle safety standards in order to deal with the emerging risks and problems. Generally speaking, the report says, the department waited for the United States to change its safety standards before revising its own Canadian standards. Oftentimes there were consultations that were limited to the automobile industry. In the report, it also says that there were not full data on injuries and injury data in order to help inform their decisions. The report says that the department didn't appear to be using evidence in making its decisions, and Transport Canada had not appropriately financed its research activities and regulations activities in the long term. So here we have a beautiful bill. However, how can we end up with a fantastic bill that's effective unless Transport Canada has the resources it needs to ensure that motor vehicle safety exists? If it does not, we have a serious problem in Canada. And S2 is not the bill that's going to solve that problem. It's actually the Transport Canada budget and its use of the budget that will. And it's the minister who is in charge of Transport Canada. Now, what about all this new technology in motor vehicles? That's also another reason to be a leader and not be playing catch-up. Another concern I'd like to raise is this. In reading the mandate of the Minister of Transport, I don't see anything. Not a word, not a line on motor vehicle safety. Now, thank goodness the minister decided to go beyond his mandate letter, and he has come forward with a bill that deals with it. However, it's still rather strange that we have such a serious problem, and yet it hasn't been included in the mandate letter. Now, I was talking about budget cuts, and I'm going to give you an example that I raised earlier when I was talking about the funding that had been reduced for collision testing. It seems to me that's pretty important when you're talking about motor vehicle safety. We all have those images in our mind that these cars that have been set up under controlled circumstances to collide in order to see how the vehicle will react and how the safety measures will stand up, and to also see how well passengers are protected. There have been many studies that have not been followed up on with respect to impact for the passengers in rear seats. And I'd like to see us have an opportunity to talk about this further in committee. So we have these new powers under Bill S2, and many are welcome. However, if these new powers do not align with good management within the department, then we're not solving the problems that exist. So let's look at these new powers that are being proposed under Bill S2 for the minister. Let's see which ones make sense. Obviously, there's a whole chain involved. I'm sure most of us at one point in time have received a recall. I've received one. I got one recently. I'm not advertising the company rather, but I did receive one, and it said, "Mr. Aubin, you are the owner of such and such a vehicle manufactured between the years of this and this, and we have found a problem in your car. In order to know whether or not your vehicle is concerned, please go to the site of the company with your serial number and check the number." Well, of course, I appreciate receiving the letter, but I have to say, whenever one receives this kind of letter, that also generates a certain amount of concern automatically. So, of course, I went immediately onto the website of the company to see whether I was directly concerned by this recall. And I wanted to see if my car was still able to function safely. Well, this happens when the company issues a recall. And what that means is that you're at the end of a process, basically, because the company, after having received a certain number of complaints, after having undertaken a certain number of tests and studies, then concludes that, yes, in fact, there is a problem and deals with the problem. However, we have seen over time that there have been many situations where several years have gone by before a company acknowledges that there is, in fact, a problem in their product. For example, the GM problem at a certain point in time, there was an ignition problem, and that was the subject of a recall. However, the time that went by between the first complaints and the actual point in time when there was a recall was actually very, very, very long. It included many years, about 10 years. So as a consumer, we only received the recall many, many years after the problem was disclosed. You see, there have to be tests, yes, but during that time, there are accidents, and unfortunately, those accidents can lead to injuries. Some of those accidents can lead to death. So it's all very well for the minister to have increased powers to increase that process and to be able to make a company issue a recall. That's fine. No one can be against that. However, we also have to make sure, and that's always really the difference between intentions and what actually happens. We have to make sure that the minister's intentions also has the right budget within Transport Canada in order to be able to undertake those analyses and reach these evidence-based conclusions in a reasonable amount of time.
So I share many concerns with my Conservative colleague when we see that funding is being cut for some of these teams. $5 million put into collision testing. We should all applaud $5 million more. But this is forgetting that before they cut 59% of the budget. When you cut 59% of the budget and then congratulate yourself for investing $5 million, that's a problem. And I think that all of this has to be analyzed together, giving the manufacturer the ability to correct any defects. And this follows the power to order a recall. And they also have to pay for the equipment and repairs. That's also obvious. The industry, which has an image to preserve, they don't like it when they have to admit that there was a problem in their manufacture. These repairs have to be repaired before the vehicle is resold. You don't want to put problematic vehicles on the road. But there is something about an amendment that was proposed in the Senate, and there were automobile dealers who came and talked to me about it in my riding. Because if we're harmonizing Canadian legislation with American legislation, we should help support the car dealers industry, because they, in their great majority, when there are problems, they have to deal with these non-sold cars. They've already purchased the cars, and there they are on the sales lot. But the car has been recalled, and in some cases, and we saw that in the case of the inflatable cushions, we saw that with certain car manufacturers that had this problem, not everyone was able to assure that they could quickly repair all cars with this equipment. So the dealers, the car dealers, had these cars parked on their sales lot with the attendant costs, and it was impossible for them to sell these cars. So I think we have to think about this carefully. I listened to the proposal of the minister earlier, and he was talking about something that wasn't about direct safety, but yes, it was something that would go in the direction of harmonizing our legislation with the American legislation. And this is indeed a very deeply integrated market. Being able to require that the manufacturer provide more information, but when I hear that they have to answer any reasonable question put by the inspectors, well, it's one thing and it's opposite. Again, we see in the text of the legislation that there is this provision without defining the word reasonable. This is a word that can bear many interpretations. So this would mean that in the future, it would be something that would have to be debated, because what is reasonable for me might not be reasonable for you. So this is a text which says they should change this to say they have to answer any question that has to do with safety. That would give it much more precise parameters, because otherwise the text is just a little too nebulous. I think one day we have to put an end to the practice of vacuous language, boilerplate language. Well, time is passing, and there are a great many things I would have liked to say, but I'll be able to get back to them either in answering questions or when the bill is sent to committee. But I repeat, the NDP will support this bill at second reading in the hopes that we will be able to contribute to improving it at committee. And we want to make sure that all interveners who are affected by vehicle safety, we want what they say to be taken into account. Yes, the industry is a major player, but we also have consumers associations, police associations, and I'll stop because I have to stop. So it'll be my pleasure to answer questions and comments.
Or Canada Carlton.
Thank you, Mr. Speaker. And I'd like to thank my honourable colleague for his speech this morning. And I agree that Canada can become a leader in the field of automobile safety. Does he have ideas about how and in what areas Canada can succeed and prosper in this area? The honourable member. Well, as I said earlier, we're in catch-up mode, and we also are for car traffic, and we have cars, motorcycles, trucks. So we have a whole new generation of cars coming up, and this will lead to new problems, and then there are going to be driverless cars. We know that some of these are being tested worldwide. It is an absolutely key technology. I think it's an inevitable technology. So these are cars that can get you to where you're going without having to drive. I think we have to start thinking about we're going to create a framework for these new technologies. There are new fuels, new technologies, things that we thought were science fiction only a few years ago. Questions and comments. The Honourable Member for Salaberry-sur-Roi. Thank you, Mr. Speaker, and I'd like to thank my colleague for his speech, which shows that we're still in catch-up mode. What does he think is the major lack in this bill? Does it have to do with funding or consulting the various players in the field of automobile safety? Have we taken the time to consult properly? Because we had the Auditor General's report, which really stunned me. It seems you would have to read this report to understand what I'm saying. So those are my questions. The Honourable Member for Trois-Rivières. Thank you, Mr. Speaker, and I thank my colleague for her question. And I would say briefly, according to me, the main problem is the time factor. How can we make sure that a bill that's meant to improve vehicle safety, we have to deal with this, but we have to deal with it in a way that as soon as we see a defect, it has to be repaired. How can we make sure that months or possibly years go by before a defect is recognized by the industry and the implementation of a corrective and repairs? So from the two parts of this process, I think S2 helps, but we think it can do better. Questions and comments?
Winnipeg North.
Yes, Mr. Speaker, the member made reference to time factor being a major issue or concern with the New Democratic Party on Bill S2. And then he went to possibly, and let me go to the next line and just say, let's give a specific example. Let's say after a year of being in production and a model of a vehicle is out, and then we find out there are some issues with the side door airbag. From the moment of discovery to the moment of a recall, would he not agree that within this legislation that we are giving the minister a better opportunity to ensure that the consumer and, in fact, Canadians are better protected by this legislation, because there will be more teeth in the legislation to ensure that we're able to address things in a more timely fashion? Would he not agree that the principle of the bill deals with the issue that the NDP seems to be most concerned about?
The Honourable Member for Trois-Rivières. Thank you, Mr. Speaker, and I thank my colleague for his question. On the principle, I would say that I probably agree with him. But I would say again, there is this dichotomy between the powers conferred on the minister and the management in the Department of Transport. Let's say that somebody discovers an abnormality. If Transport Canada doesn't have the ability to do at the same time a study and have something done, it's possible that the industry, for all kinds of reasons, might decide to take more time. And if the minister really wants to be able to enforce these powers and to require that they correct the situation, they would need the proper information, and this is related to the capacity of expertise in the department itself. And this is where, For years now, we've observed that cuts are going in directly the opposite direction of the goals set forth in this bill. Questions and comments?
L'honorable député de Salaberry-sur-Roi.
The Honourable Member for Salaberry-sur-Roi. Thank you, Mr. Speaker. My question has to do with the funding. There have been a lot of cuts to vehicle safety. When it was said that 59% of the budget was cut, and there were members of the staff who dealt with verifying vehicle safety who were let go, does this bill, S2, make sure that these monies will be reinvested and that the additional people that they need to deal with vehicle safety will be there? The Honourable Member. Thank you, Mr. Speaker, and I thank my colleague for her interest in Bill S2. Two things. First of all, the cuts that to the Minister of Transport. It wasn't just the Conservatives who did this. This was followed up by the Liberals in 2015. And as to the second part of her question, in S2 there is nothing about increasing staff. There are increased powers for the inspectors, increased powers for the enforcing officers. The minister will also have the power to hire new enforcing officers. But as to the budget for doing this, doesn't say anything. So are they talking about an additional budget which will be provided to the Department of Transport, or are they talking about moving things around in the same department? So are they robbing Peter to pay Paul? Or will there really be new monies to help them to meet the objectives of S2? Questions and comments?
Reprise du débat.
Resuming debate.
The Minister of Transport.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Speaker.
Honourable member from Central Nova. Okay, Monsieur le Président et chers collègues.
Mr. Speaker and dear colleagues, it's a pleasure for me to stand and talk about Bill S2, a bill to amend the Motor Vehicle Safety Act. I consider that safety is utterly important. This bill, as presented by the government, will help us improve the safety of Canadians.
A strong motor vehicle safety regime is clear. Millions of Canadians rely on that regime as they travel on our roads every single day. Large vehicle recalls in recent years highlight the importance of motor vehicle safety. This importance placed on safety is why we are pursuing the proposed changes to the Motor Vehicle Safety Act. Those changes will, if passed, address key gaps in the regime and help ensure the safety of Canadians. The proposed measures include new order powers for the Minister of Transport to order a company to correct safety defects at no cost to the consumer, an administrative monetary penalty regime, and consent agreements to help promote compliance, measures that will help foster the introduction of innovative technologies, as well as many other proposed changes. These provisions have been envisioned as a suite of changes to strengthen our current safety regime and help ensure that Canada can benefit from new technologies. Il s'agit d'importantes révisions de ce.
This is a major review of these provisions. The vehicle safety regime is not as robust as it might be in order to protect the Canadian population. In cases where a vehicle had a defect which would endanger safety and where an industry did not want to correct this defect, the Government of Canada couldn't do much in the past. This situation could endanger Canadian drivers.
While our vehicle manufacturers have a good track record here in Canada, we do not want to be in a situation where there is a safety issue for which we do not have the proper tools or authorities to address the situation. It is our desire to pass this legislation as quickly as possible to ensure that this safety gap is addressed. This is not to state safety recalls will not occur in the future or that unforeseen risks and problems will not arise, but that we are taking concrete steps to improve safety by including new tools in the legislation that will be available to help address issues when they arise. As part of the review of the bill, an amendment was brought forward from the other House that would provide additional financial protections to automobile dealers, above and beyond to those available to purchasers, in the event that the Minister of Transport orders a company to correct a defect or stop a sale. As outlined in the amendment, these protections would ensure that dealers would receive from the vehicle manufacturer or importer the parts needed to correct a defect, or the manufacturer or importer would repurchase a vehicle at full price, plus transportation costs, and compensate the dealer at the rate of 1% per month of the price paid. Now, I must state from the outset, vehicle dealers are an important component of the Canadian economy. They employ thousands of people across the country. They help to ensure that our vehicles are well maintained and are valuable members of the communities in which they operate. I believe the changes introduced in the other chamber were motivated by a sincere desire to protect them from financial harm. This is a perfectly understandable goal, and I'd like to thank our colleagues in the other chamber for raising awareness about the concerns that dealers had with S2. The purpose of the Motor Vehicle Safety Act, however, is to protect the safety of Canadians. It's not designed to regulate the commercial relations between automobile manufacturers and importers and their dealers. Furthermore, the Strengthening Motor Vehicle Safety for Canadians Act, as originally introduced, already included provisions that would require manufacturers and importers to be financially responsible for correcting or repairing a defective or non-compliant vehicle. This applies to dealers as well. To clarify, vehicle safety defect repairs will be covered by the manufacturer. This applies to importer vehicle owners, including dealers. I stress that these provisions include dealers because I think this point was not always fully understood when the bill was initially considered, or by the dealers themselves during previous study of this bill. The originally proposed protections includes repairing the vehicle or equipment, repairing the vehicle or equipment with a reasonable, replacing the vehicle or equipment with a reasonable equivalent, reimbursing the reasonable cost of repairs to the vehicle or equipment that have already been undertaken before a notice of defect or non-compliance has been given, or reimbursing the sale price of the vehicle or equipment, less reasonable depreciation on return of that vehicle or equipment. The addition of dealer protections above and beyond these available to other purchasers, as well as the generous payments to this particular stakeholder group, would lead to an unbalanced regime that could raise significant risks of disputes between dealers and manufacturers. While the amendment introduced by the other House does impose some minimum obligations on dealers as written, it would be challenging to enforce. Lacking any recourse mechanism, the involved parties would likely look to Transport Canada to mediate their commercial disputes. These powers are also not part of the amendment, and such activities are not in Transport Canada's mandate. We believe that this amendment as written has many potential unforeseen complications. It should be noted that it would actually remove some of the protections that were already built into the Act. For example, it would create a mismatch of powers and may mean that dealers who have repaired, their vehicle before would not be eligible for reimbursement. Our overwhelming priority with this bill, as it is more broadly for the minister and across the entire transportation sector, is the safety of Canadians. Passage of the bill, as introduced by the government as quickly as possible, will help close some key gaps in the motor vehicle safety regime and help ensure the continued safety of Canadians. Thank you.
Hear, hear.
Questions et commentaires, questions and comments. The honourable member for Carlton Trail, Eagle Creek.
Thank you very much, Mr. Speaker, and I thank the honourable colleague for her remarks on this piece of legislation. Earlier, I did have the opportunity to ask the minister specific questions around the difference between C62 and S2, and I don't believe that he answered the question that I asked specifically to Section 16, which speaks to issues of compliance, making violations public, and powers of the minister. And so I'm wondering if my honourable colleague would speak to those changes in Section 16 that make the difference between C62 and S2. Thank you.
Parliamentary Secretary.
I'd like to thank the honourable member for her question. And she's right to point out that Bill S2 does build upon Bill C62. And it actually goes further by adding extra mechanisms for the minister to be able to use. And one of those is this consent agreement. And this allows them to actually negotiate and mediate long-term solutions. And because right now the minister does not have the power to actually compel any manufacturer or dealer to actually address issues, that's why the need for this bill is there, and why there needs to be a little bit of flexibility in how we address these issues. But it all comes back to the same issue over and over again. It's about what do we need to do in order to protect consumers, and we need to be able to do it proactively instead of always being reactive. Actually be able to be part of the solution and negotiate or mediate a solution for Canadians.
Questions and comments, questions et commentaires. L'honorable député de Trois-Rivières.
The honourable member for Trois-Rivières. Well, thank you, Mr. Speaker. I'd like to make some mileage on the question put by the member for Salaberry-sur-Roi. And there's a bit of a hypothetical answer to it. Now, perhaps by passing the question over to the government side, we'll get a real answer. Now, the question was Bill S2 outlines the possibility for the minister to hire new officers. Now, how will it be possible to put in place those types of positions when the department is facing cuts? Now, will there be a paradigm change in the future? The Honourable Parliamentary Secretary.
Thank you, Mr. President. I know that my honourable colleague knows it's very difficult to respond to hypotheticals and to speculate on this, but I understand his concern. And to make sure that we have a viable enforcement regime in place. I know the minister understands this as well. There are many ways of encouraging compliance, and I think that's what we want, is a multi-functional approach to actually compliance. So thank you.
Hear you.
Questions and comments. We have time for a very brief question. The honourable member for Hamilton West, Ancaster, Dundas.
Thank you, Mr. Speaker. I'd like to ask my colleague, she mentioned the importance of the new powers that the minister has with respect to in and through this legislation to correct safety defects. And I'd just like her to expand on why that's needed in order to protect the safety of Canadians. How is that going to impact providing Canadians with a safer security on the road?
Well, Parliamentary Secretary.
I'd like to thank my honourable member for her question, and she's right. The way the legislation currently sits, the minister has absolutely no ability to compel a manufacturer or a dealer to address an issue. And that's exactly what we need to do. And we haven't had to use those powers. I would say here in Canada, our dealerships, our manufacturers and importers have been quite responsive to the demands of the government. But in case something like that ever happens, having those powers for the minister to be able to use them would be very important.
Reprise du débat, resuming debate. The honourable member for Central Nova.
Thank you very much, Mr. Speaker. It's my pleasure to rise and offer a few remarks on Bill S2, an act to amend Canada's Motor Vehicle Safety Act. Before I begin, I was under the impression I was initially going to have 20 minutes, so you're going to get the Coles Notes version of a longer speech. Let me, before I get too deep into the weeds on this one, explain in broad strokes what this is about. Currently, motor vehicle safety is a priority, and I think that's shared with every member in this House. When we look at the impact that motor vehicle defects can have, there's a paucity of laws in Canada that allow the government to take action to correct a very serious problem. Over the course of my remarks, I hope to outline roughly the scope of this problem and that it is a priority, and then address three key points that are built into the legislative mechanisms that will help improve the government's ability to deal with this problem. Specifically dealing with the power to order recalls, compliance mechanisms, and then finally the flexibility to deal with emerging technologies. So first and foremost, if I'm to argue that this is a problem in Canada, I need to look no further than some of the very positive news coverage from last year that really highlighted the impact that manufacturers' defects have on vehicles on the road in Canada today. If I'm to believe the contents of a Globe and Mail article from December of last year, 1 in 6 Canadian vehicles is currently subject to a manufacturer's recall in Canada. That means that there are millions of vehicles on Canadian roads today that the manufacturers have acknowledged these are not safe enough to meet Canadian standards. I urge anyone watching, and I know that on CPAC during House proceedings we have a massive audience, to visit Transport Canada's website, use the searchable database, and determine whether your vehicle is subject to an existing manufacturer's recall that you may not know about. Because these things can fly under the radar when Canadians have other priorities and things to worry about in their lives. But it is important, and it does pose a safety risk. With that said, I think we can safely assume that manufacturers' defects are a safety concern in Canada today. And this legislation proposes a number of things to deal with them. Let me first deal with the power of the minister to order a recall when we become aware of defects, which is a power provided for in Bill S2. There's really two sort of categories, if I can group it that way, two categories in which the minister will be empowered. One deals with consumers, the other with dealers, and perhaps I'm simplifying it a little bit too much. But on the consumer side of the equation, we're dealing with a circumstance right now where the minister doesn't have the same power that exists elsewhere in the world, including the U.S., to order a recall. Importantly, this is a remedy that will now exist where the consumer doesn't have to cover the cost of having their vehicle repaired or replaced. This is a burden that can and should be borne by the manufacturer who's responsible for the defect. This is going to enhance safety by allowing more consumers to have their vehicles fixed at no cost. The second side of this equation has to do with dealers, and I'll spend a little bit more time on this. Right now, again in Canada, there's no law that says a dealer can't sell a car with a defect. And in fact, there's not enough information flowing for dealers to know when a defect may exist to make sure that the vehicle doesn't make it out onto the road. If I'm dealing with a leaky roof at my house, the first thing I'm going to do is go find a bucket to stop the water from damaging my floor. The second thing that I'm going to do is try to fix the pipe that's causing the leak. If we're only dealing with the consumer side of the equation here, we're going to maybe prevent more drops from hitting the floor, but we're going to have to keep replacing the bucket if we don't do something to prevent the sale of defective vehicles from getting onto the road in the first place. Now, this puts dealers in an admittedly difficult position. This could put dealers in a position where they're going to be left carrying inventory on their lots that they can't sell, and that's not right. And I want to draw a little bit of attention to a discussion that was had on in the upper chamber on this issue, and the proposed amendment specifically in Bill S2. Before I do, I wanted to extend my gratitude to our colleagues in the other chamber for their thoughtful deliberations on this piece of legislation and many others, and for drawing attention to an important issue that has caused me to think very deeply about this. But I respectfully must disagree that the suggested amendment is the appropriate mechanism to correct the social harm that we all want to fight here. What the mechanism proposed in the amendment seeks to address is really compensation for the dealers who were left with inventory on their lots that they can't sell. They proposed a 1% interest rate on vehicles based on the price of the vehicles per month. If I start to do the math in my head, this becomes a very, very expensive thing for manufacturers and does compensate the dealers somewhat. But when I was trying to understand in my head whether this is the right policy, I had to think back to some of my work before, where I had the opportunity to work in a litigation practice with a bit of a constitutional influence, and back to law school, and really what we have the authority to do in this chamber. My first obstacle and reason why I can't bring myself to support the amendment is really a constitutional issue, and I don't know that we have the constitutional authority to legislate the terms of a commercial arrangement between contracting parties at the federal level. Section 91 and 92 of the Constitution say what the federal and government and provinces can do respectively. And there's no question we can tackle issues that touch on public safety. But when it comes to the contracting arrangements between commercial parties, this is something exclusively within the purview of the provinces. In fact, there's lots of sale of goods legislation in place in the provinces specifically to deal with these issues. I can't overcome this barrier, and I can't in good conscience support an amendment that I don't believe we have the authority to pass and adopt in this House. But the second and more practical stumbling point for me on the proposed amendment is the possibility we could be creating an unintended consequence that I don't believe our colleagues in the upper chamber had specifically drawn their attention to, again, with great respect and deference. What we might be doing is creating an economic incentive for manufacturers to fix cars that are in dealers' lots today before they fix cars that are on the roads. Trying to do math, if we assume, just to make the math easy, there's a recall that applies to 100,000 vehicles at a price of $25,000. We're looking at interest payments on the part of the manufacturer to dealers in the realm of $25 million a month. This is a great motivator for companies. If you're looking at a severe penalty like this, you're going to change your behavior. And this might inspire them to fix these cars sitting on dealers' lots more effectively. But I don't want them to do that at the cost of cars that are traveling on Canadian roads today. And I believe that creating this incentive to deal with cars that have not yet been sold over cars that are owned by Canadians could pose a public safety hazard. Finally, there are remedies available today for dealers. The Bill S2 puts dealers on the same footing that consumers are on. They'll have access to have their vehicles repaired at no cost, like consumers will. They'll also have the protection of any negotiated provisions in a commercial contract that allocates risk as between the parties, and they will have the protection outlined in provincial sale of goods legislation that deals with merchantable quality and fitness for purpose for any goods that are sold in our provinces. So respectfully, for those reasons, I can't support the Senate amendment, but I do believe that the legislation is sound. Very quickly, in the remaining minutes that I have, the compliance regime put in place is going to replace one that more or less doesn't exist today. Today, if you want to enforce violations of the Motor Vehicle Safety Act when it comes to defects, there's an expensive and lengthy criminal prosecution, and many of the violations don't warrant a criminal prosecution. We're implementing a monetary administrative penalty regime that's going to be more like a speeding ticket. It's going to punish those wrongdoers and encourage them to change their behavior, but often to the tune of thousands or hundreds of thousands of dollars per vehicle per day. And finally, and though I don't have time to cover it, knowing that we're on the precipice of emerging technologies in the motor vehicle sector, we want to ensure that we don't stifle innovation, particularly when it comes to driverless vehicles. There has not been a disruptive technology in the motor vehicle industry in over a century. Knowing that we're about to embrace this change, we need to ensure that there's flexibility there that allows the minister to encourage innovation in this exciting industry without compromising our safety. With these features in mind, I'm very proud to support Bill S2 because I believe it'll improve safety on Canadian roadways with the caveats that I mentioned at length about the proposed amendment that is in the legislation today. Thank you very much, Mr. Speaker.
Questions and comments. Question commentaire. The honourable member for Carleton Trail, Eagle Creek.
Thank you very much, Mr. Speaker, and I do thank my colleague for his comments on this bill, and I will say for the record that I always appreciate his very thoughtful interventions in not only in this place but in committee. And so I guess what I would like to do is pose a similar question to him that I've posed to both the Minister and the Parliamentary Secretary. Perhaps I could be accused of asking fairly technical questions, but this is a technical bill. And what I am focusing on are some of the changes that we should be very familiar with between C62 and S2, because there aren't very many, except for the amendment that's been spoken to quite a bit during this debate so far. So I'll get a little more specific in terms of the measures in Section 16 that I have asked for some clarification on. So I'm going to pick 16.24, which establishes that following the issuing and service of a notice of violation, the minister can make the nature of the violation and other related details public. What I simply want to know is the purpose of that measure. Why was it included? Just to frame it for myself going forward in this debate. Thank you.
Member for Central Nova.
Certainly, and thank you, Mr. Speaker, for the opportunity to answer the honourable member's questions, and I appreciate her kind remarks, and I too appreciate her thoughtful deliberations both in our shared committee assignment and in this House as well. Now, I don't hazard to speak for the government, being merely a member of the governing party and not a member of the government proper, but I do think the ability to make public information about the quality of defects and the extent that may impact Canadians to be important. When we're operating in an environment with full information, people tend to behave the way you would hope they behave. If I know that the world is watching me, do my job, and again, with the great audience we've got on CPAC, I know perhaps they are, we tend to be more conscious of our record. It creates accountability in my mind when we know that the information about our safety record, particularly in an industry where safety is so important, is being watched. I don't mean to suggest that manufacturers today are not operating in a safe manner, are not being accountable to an acceptable degree, but we can always be better. And shedding a light on the information that pertains to different companies' safety record is, in my opinion, going to help save lives in Canada. Thank you.
Questions and comments. Question commentaire. La députée de Trois-Rivières.
The Honourable Member for Trois-Rivières. Thank you very much, Mr. Speaker. I have a simple question, and this is what I've been trying to figure out from earlier on. Would he say that Bill S2 directly meets the needs in terms of safety gaps that the Auditor General raised in his last audit? Oh, will we have to get there indirectly? Because there is a difference between the intentions of the bill, the resources, and the funding provided.
Honourable Member for Central Nova.
Thank you very much, and I've had the opportunity to work with the member opposite as well on the same committee that I referenced previously. I believe simple questions are best, although I think without having the Auditor General's report in front of me at the moment, it does make it a bit more difficult to answer in detail. What I can say about Bill S2 is that it's probably not going to create every possible safety measure when it comes to preventing defects from getting onto our roadways, but it's going to make Canadian society and our roadways safer as a result. I look forward to working with the member on our committee, presuming that this bill gets through in one form or another the legislative process in this House, so we can dig in and examine the Auditor General's recommendations, if he wishes, alongside the measures that are explicitly contained in the bill, so we can make this the best possible legal outcome that protects the lives of Canadians on our roads.
Time for a very short question. The Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and to my friend from Central Nova, thank you. It's the first chance I've had in this debate to say that I do favor Bill S2, will vote for it. But I'm wondering why, if he can shed any light on why this bill began in the Senate. I think we all agree that it's important for the minister to have powers to actually take vehicles off the road, not merely negotiate with the automakers. It seems overdue, and I just wonder if he can shed any light on that. It certainly isn't germane, except that it's a matter of parliamentary procedure. It strikes me as odd.
Member for Central Nova.
Thank you, Mr. Speaker, and I'd like to thank the honourable member for the question. I always enjoy participating in debates with someone who knows my backyard so well. I've got to say, unfortunately, again, not being a part of the government, this is an area where I don't have the information directly that you're seeking, and I'm not afraid to admit that. The bill was sponsored by Senator Harder in the Senate. What I see this, despite the fact that it may have not started on the floor of this House, there's an opportunity to move quickly to save lives. When I've met with consumer advocacy organizations, their biggest request was, let's get this thing through. Every day that we don't have these laws in place, we risk the danger of having another motor vehicle that suffers from a defect, leading to a fatality in our country. And that's not acceptable. So with respect to the oddities and procedure, as the member pointed out, I can't answer why, but I'm glad it started, no matter where it started. Thank you.
Resuming debate, the honourable member for Battle River, Crowfoot.
Well, thank you very much, Mr. Speaker. And again, it's a privilege to stand in this House after a good summer, a summer where all Canadians were on the road traveling throughout Canada, appreciating our great country and celebrating Canada's 150th. And but it is nice to get back to Parliament and to represent the good folks of Battle River Crowfoot. Mr. Speaker, I am pleased to participate in today's debate on Bill S2, an act to amend the Motor Safety Vehicle Act. S2 gives the Minister of Transport new vehicle recall powers. And this bill is similar to legislation introduced by the previous Conservative government. Our Conservative government is also concerned and was concerned with passenger vehicle safety, and we had legislative amendments in what was then called Bill C-62. And it has been referenced today in the House a number of times. And I thank the Minister of Transport for his recognition of that bill as a good measure. This bill, S2, would give the Minister of Transport the power to order companies to issue a recall notice. It will then compel manufacturers and importers to repair a recalled vehicle at no cost to the consumer. So it's obvious that recall not only for safety on our roads and to our customers, but a certain confidence that they have that the manufacturers and the model that they bought is going to comply when they understand and realize that there are questions about safety. It will give the Minister of Transport the power to order manufacturers and importers to repair new vehicles before they are sold. It will allow the Department of Transport to use monetary penalties or fines to increase safety compliance and use the monetary penalties as a way to require manufacturers to make additional safety action. Provide the department with flexibility to address ever-evolving vehicle safety technology and require companies to provide additional safety data and conduct additional testing to address safety concerns. And finally, it will increase Canada's vehicle inspection capability. The importation of motor vehicles and motor vehicle equipment into Canada is governed by the safety standards established by the Motor Vehicle Safety Act. Before vehicles that are imported and equipment manufactured in Canada can be shipped to another country or province for sale, they must have a national safety mark confirming that they have been manufactured according to the Act and the existing safety standards that are in place. Currently, under the Motor Vehicle Safety Act, only manufacturers can order vehicles to be recalled in Canada. The Minister of Transport can only order a manufacturer to notify Canadians that their vehicle is a subject to this safety recall. Bill S2 proposes to allow Transport Canada to issue monetary penalties to manufacturers. This new power is intended to ensure that manufacturers comply with Canada's Motor Vehicle Safety Act. So what does that replace? Well, the monetary penalty system replaces the time-consuming and very, very costly criminal prosecution of automobile manufacturers. Bill S2 will more closely align Canada's automobile recall process with the existing process in the United States. And that was a question that I asked the minister this morning as to how closely it aligns with the United States. He was fairly clear that the intent of the measure is to reduce enforcement gaps between Canada and the United States, although I think he also insinuated that there were other safety precautions in I'm not so sure Bill S2, but in our safety standard that is even more than what the United States may have. The previous Conservative government had already strengthened the Motor Vehicle Safety Act in 2014. Our government also passed into law provisions that brought the Motor Vehicle Safety Act very close in line with American legislation. We know that we have an integrated industry. We know that there's vehicles that are manufactured here in Canada and then sold in the United States and vice versa. And it's an integrated market. And so it's very important that we not put up red tape or barriers that limit the industry in having that equivalency between the two countries. For example, we made explicit the differentiating between an automobile defect as compared to an automobile's non-compliance with Canada's Motor Vehicle Safety Act. In 2014, our government gave Canada's Minister of Transport the power to order an automobile company to inform Canadian consumers of safety defects. Bill S2 is building on that effort by giving Canada's Transportation Minister the power not only to inform the public, but to actually recall those vehicles. Canadians want and they expect our vehicles to be safe, and we want to identify defects as quickly as possible. The power to order vehicle recalls will help manage vehicle safety in Canada. Everyone knows that technology advances in motor vehicles are evolving so quickly and becoming more and more technical and complex. I mean, we see it everywhere. We see it in our cell phones. We see it in our video, anything dealing with electronics. We see this. Well, certainly we see it now in vehicles and vehicle safety. And as the technology grows, the question is, are we keeping up? And later on, I'll talk a little bit about that. But in order for us to be competitive, we must facilitate these needs. Canada's regulatory regime needs to be more responsive to new and emerging technologies. We need to be responsive to new fuels as they come online, and also safety advances. This bill will allow the department to require manufacturers to provide more safety information and do testing when needed, as well as increase their flexibility to address ever-changing safety technology. Bill S2 has provisions that did not appear in Bill C-62, tabled by the previous Parliament in June 2015. Consent agreements relating to safety improvements in non-compliant companies have been added. As well, the current government wants to try to impose initiatives to provide some early flexibility to address the challenges of rapidly changing vehicle technologies. This measure needs to be pursued carefully when Bill S2 is studied in committee. And, Mr. Speaker, I think right here is a time for me to again express the important work that committees do. We need to allow our committees the ability to look at these and to look at the timeliness of how we can deliver change or how we can adapt to the ever-changing world of technology and how that equates back to vehicle safety and as to whether or not all the possibilities are then being checked out. As well, the current government, this measure needs to be pursued carefully. The purpose of S2 is to increase consumer protection and motor vehicle safety in Canada. And that's why we moved on this in 2015. So I think it's obvious today that the official opposition wants to support, in principle, Bill S2, but certainly we want this bill to get to committee and then the proper work being done there. I think we should also recognize that we should thank the Senate for bringing this forward quickly. I'm not certain, again, why the government didn't bring this as a government bill, but the Senate did bring it forward with some amendments. There are some amendments there. We'll talk about that a little later on as well. I have the privilege of chairing the House of Commons Standing Committee on Public Accounts. And I'm also pleased that today in this chamber, the Auditor General's report, as well as the Public Accounts Committee's report, important work that they've done, is part of the debate today here in the House. The fall 2016 report of the Auditor General of Canada included a chapter on oversight of passenger vehicle safety and the performance of Transport Canada. Here's a couple of things that the Auditor General's report, which I have here with me today, Oversight of Passenger Vehicle Safety, Transport Canada, these are some of the things that the audit found. First of all, vehicle safety technology is evolving faster than Canadian regulations and standards can even keep up. Transport Canada faces challenges in exercising its important role of keeping these passenger vehicles safe. The auditor noted a number of significant deficiencies in the regulatory framework, including a lack of timeliness and an absence of broad stakeholder consultation and outdated regulations. For example, Transport Canada's regulations did not allow vehicles to be equipped with advanced headlights that are controlled by software. Also, unregulated semi-autonomous vehicles are being driven on Canadian roads. So here's a couple of areas where Transport Canada was not even keeping up to really what is available out there for not so much for the general public in some cases. Transport Canada waits for the National Highway Traffic Safety Administration in the United States to develop new or amended standards before proposing regulatory actions in Canada. The Auditor General took, he was concerned about that, although I am pleased that we do recognize the integrated industry and that we are not always changing after the United States does it, but we're watching what they do so that we can have access to their market. This reactive approach, the Auditor General stated, created significant delays in implementing new standards and meant that some passenger vehicles were not equipped with the newest safety features available in other countries, such as the advanced headlamps. The Auditor General said there were lengthy delays, and I quote, sometimes of more than 10 years from the time that Transport Canada started to work on an issue to the implementation of new or amended standards. Well, as we've already mentioned, Mr. Speaker, technology is advancing fast. What is new today in much of our technology will be old news or will be old technology in 6 months. So Transport Canada needs to address ways in which it can keep up. Prior to making proposed regulations public in the Canada Gazette, Transport Canada consulted with manufacturers but did not engage broadly with stakeholders such as consumer associations, medical associations, and our police forces. The audit found that the important standards were not working as intended or they were outdated. And again, for example, I quote our Auditor General, quote, Transport Canada was aware that child seat anchorages could fail under certain conditions, but it had not proposed a new regulation or issued an advisory by the audit completion date, unquote. Transport Canada's response to our Auditor General was that introducing a unique to Canada requirement for anchorage strength in passenger vehicles would be detrimental to trade. So for that reason, there was a delay. Most concerning and a challenge for the current Liberal government is that Transport Canada has not been focusing on planning or funding its research and regulatory activities for the longer term. The department could not prioritize resources and spending decisions. It sounds like, there's some real administrative problems there. For example, between April 2012 and December 2015, the department purchased 98 passenger vehicles for research testing, so between 12 and 15, and yet by December 2015, none of those tests had taken place. I apologize, that is not correct. As of December 15th, there was still a number that had not taken place. So these vehicles were sitting there, but many of them had not taken place. The department appears to adequately assess complaints from Canadians and identify vehicle safety defects. However, the department did not request information about critical safety issues that manufacturers were already investigating. As well, manufacturers issued 318 recalls between 2010 and 15 for safety-related issues that were never brought to the department's attention. So we can see again, communication, the passing of information, the data that is there. Data in just about everything in government is problematic. But here was a case of not working closely enough with the industry to even be aware of the recalls that the manufacturers on their own had called for recall. Furthermore, the department did not have the authority to assess whether manufacturers implemented effective processes for identifying and reporting safety defects. This limited the department's ability to investigate defects and better protect Canadians. While Transport Canada adequately assessed vehicle manufacturers' efforts to complete safety recalls, it was left to the manufacturers to contact owners for some recalled passenger vehicles. Manufacturers had difficulties identifying and contacting owners, especially those owners who had older vehicles. And we know that sometimes other related or unrelated issues in an older vehicle may compound the problem that is actually being recalled for. So you almost have a double whammy with these old clunkers on the road, as someone, another politician in the past has talked about. And so we need to be certain that, that we do comply with this. And the good news, I guess, out of all of it is that Transport Canada has agreed with the 7 recommendations made by our Auditor General and is pursuing a detailed action plan. And again, pleased to report the Public Accounts Committee has studied and reported on this. And we are also still involved in a follow-up process that will hold them to account and that will make Canadians even feel more safe. I just want to read some of the recommendations the Auditor General had here. Recommendation 1, Transport Canada needs to confirm in writing to the committee that it provides regular public updates on the status of its regulatory plans. Public needs to have confidence. Recommendation 2, Transport Canada needs to provide the committee with a report detailing the implementation of an expanded and standardized consultation process seeking comments in a timely manner from expert stakeholders on motor vehicle safety regulatory initiatives. This, again, goes back to stakeholders, including the industry, but stakeholders like our emergency responders, our police forces, other stakeholders. Recommendation 3, Transport Canada needs to provide the committee with a report detailing how it has implemented its action plan to improve the quality of collision and injury repair. And again, part of the process of follow-up that committees do, and this is one of these recommendations. Recommendation 4, Transport Canada needs to provide the committee with a report detailing the progress of the updated regulatory process and how evidence and scientific research are used to inform the development and or modification of motor vehicle safety standards. So how is science and research helping? Transport Canada 5 needs to provide the committee with a report outlining its long-term operational plan for Motor Vehicle Safety Directorate. Recommendation 6, Transport Canada needs to provide the committee with a plan detailing how Bill S2 proposed new authorities will be implemented into the passenger vehicle safety regulatory regime. And finally, Recommendation 7, Transport Canada needs to provide the committee with a report outlining its process to support a new authority in the Motor Vehicle Safety Act to request that major auto manufacturers provide information on their data sources and internal processes for identifying and reporting safety defects. In the audit, the Auditor General, those were his recommendations, but again, some of the things that he concluded with, Transport Canada did not maintain an up-to-date regulatory framework that responded to emerging safety risks and technological issues. As a result, the approach failed to ensure that Canadian-driven passenger vehicles had the highest possible safety features and technologies. Mr. Speaker, I see that you're telling me I have only a minute left. Let me just quickly say that I believe that there are laudable measures being taken in Bill S2 that should be supported. The current government faces some formidable challenges to address vehicle safety in Canada, but I think this is a step in the right direction. As he stated, it is adopting the Conservative Bill C-62, and so we commend him for that. Beyond that, there are always, the devil is in the details. And again, we'll be watching to see how quickly this is implemented, how quickly a minister would actually step out and tell manufacturers that there should be a recall. And so, it needs not only to be passed, but it needs to be complied with a minister that is prepared to make those tough decisions. So there are numerous challenges keeping Canadians safe in the vehicles on our road. I think our former government was very aware of it, and that's why we acted in 2014 and again in 2015 with the tabling of Bill C-62. And I commend this government for moving as well by adopting a bill that unfortunately had to start in the Senate. But I would hope that this government again would allow the committee to do its work and that we would see this move through committee in a timely fashion. Thank you very much, Mr. Speaker.
Questions and comments. The Honourable Member for Hamilton West, Ancaster Dundas.
Thank you, Mr. Speaker, and I'd like to thank the Honourable Member for his speech and comments today. And he raised the topic of the fast pace of innovation, and I think we can all agree with the member there that we do have to always be conscious of that, celebrate the success, but make sure we're prepared for it. Of innovation. So the question I have for the member is, does he believe that the extra powers that are in this legislation, so the Minister of Transport's power to order repair of recalled vehicles and new vehicles, to use monetary penalties to increase safety compliance, and the flexibility of Transport Canada to address vehicle safety technology, are these things that he sees as important with respect to ensuring that we're keeping up with the fast pace of innovation?
Honourable Member for Battle River Crowfoot.
Yeah, Mr. Speaker, again, I may be better off answering that when we see the response, from Transport Canada on the processes of carrying out the recommendations that were brought forward by the Public Accounts Committee and indeed by our Auditor General. The safety of Canadians and everyone who uses our roads is of paramount importance to us. We have to be aware of the quick and changing world of technology when it comes with, to buying new vehicles. So although this bill may not be perfect, it is a good balance, I believe. And I think, again, this is the time where committees need to research this through. Transport Committee as well should be looking at this carefully. Public Accounts have and will continue to. Yes, what the Auditor General stated was because of the new and quick technologies, there must be a process where Transport Canada can do more than just comply with the regulations that are brought forward in the United States, but where we can on our own move towards better safety on our roads.
Questions and comments? The Honourable Member for Trois-Rivières. Thank you, Mr. Speaker. My question is simple. When we compare C-62 and S2, which has been tabled by the Liberals, there are many similarities but also differences. And there are two forms of administration, but there have been cuts to Transport Canada. My question is simple. Does my colleague think it's possible to increase vehicle safety while cutting funding at Transport Canada?
Well, Mr. Speaker, that would be up to the government to lay out the funding for their departments. They do this in budgets, and as far as that goes, the safety of Canadians and everyone is, paramount, I believe, to all of us. And so it's important that we have as my honourable member said, adequate funding for the department, but also for this specific area of vehicle safety. So when a industry or a department purchases 98 vehicles in 2012 and to 2015, and yet not all of the vehicles are even used in these checks. We have new vehicles sitting there that are going to be checked for certain safety. They have this optimal number of 98 vehicles that need to be purchased. They go out and purchase, or we went out and purchased, but 24 or 25 of them are still sitting there, and those tests have never been done. So this isn't even, the quick and moving technology changes. These are things that they had budgeted for and wanted to test certain models of vehicles for certain things, but 24 of them didn't get around. Now, if it was because of resources, that's what we expect. We expect that resources balance out with the needs.
Questions and comments? The honourable member for Carleton Trail, Eagle Creek.
Thank you very much, Mr. Speaker, and I want to thank my honourable colleague for participating in this debate and for the comments that he's made. I also want to thank him for the good work that he does on the Public Accounts Committee. I did have the opportunity to sit in on one of their committees and to question the Auditor General on the very report that both my colleague from Trois-Rivières and I have commented on. And so I guess my question to this member would be if he would comment on the very important work of the Auditor General in providing these kinds of reports back to Parliament, and how they should inform not only the amending of current legislation but the creation of new legislation, and ensure that we're not only getting things done quickly but getting them done right. Thank you.
The honourable member for Battle River Crowfoot.
Well, thank you very much, Mr. Speaker, and I want to thank my colleague for that question, and I also want to thank her for appearing before with our Public Accounts Committee and the very good work she did that day with questions to the Auditor General and to his department. Mr. Speaker, there is so much that I could say about the Auditor General's office. We know that in a democracy, that transparency and accountability are paramount to maintaining a strong democracy in a strong country. Canadian citizens must have a confidence that whether they're provincial, territorial, or federal governments, that there is somebody who is looking at doing performance audits as well as financial audits, and that they're holding departments and ministers and governments to account. And I can tell you that we can be very proud of the Auditor General's office that we have, and our Auditor General and his staff, and that when they come with a decision, we need to accept it. We need to accept the recommendations. We need to accept generally certainly on all public accounts, financial audits, on performance audits, I would suggest as well. It holds departments to account. Now, vehicle safety, there is no gray area here. I don't think you're going to find a lot of differences in political parties as to whether or not we believe there should be standards on vehicle safety. I'll maybe go on a bit of a rabbit trail and a rant here. I'm very concerned about safety on the road. I'm concerned about young people and, on occasion, I know Chief of Police across the road here, this texting and being on a phone at the time. You see these people still on the road, texting, looking down, or being on the phone. I'm very much concerned when I see it. I had a call from Mothers Against Drunk Drivers this week, very concerned about alcoholism and travel on the road. And I am very concerned about our movement towards legalization of marijuana and what that will mean, without even yet the ability to do roadside testing. So all these things I think Canadians get. There are very few people that think we should just be an open society with no regulation. I mean, obviously we want safety on the road. But we also expect that when I go into this dealership to buy a new vehicle and I see the new technologies that we have, although I do not understand the electronical components and what all this vehicle can do, I expect that it's going to be safe. And I expect that it's not going to injure or harm me or anyone else on the road because of that technology. And so the Auditor General spoke more specific to process than he did the politics of any of those issues. But again, very important work that our Auditor General does. I again thank him for that, and we can be very pleased that that report came out and that the government has moved with S2 as part of the answers to the Auditor General's report.
And we have time just for one short question and response. The Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and to my honourable friend from Crowfoot. I'm reflecting back on the 41st Parliament to a similar bill, and I'm wondering if he reflects on it as well, that it seems strange to me that until the 41st Parliament, with Conservative government leadership, passed Vanessa's law, the pharmaceutical industry was not required to withdraw a drug when the Minister of Health asked them. It took Vanessa's law to say the Minister of Health could tell the pharmaceutical industry to withdraw a drug. Now we're passing legislation, I think it's overdue, that the Minister of Transport can tell the automobile industry when a dangerous vehicle needs to be pulled off the road. Does any of the reflections, it seems to me these two bills come perhaps in a new phase of being more aggressive in protecting the rights of Canadians for health and safety?
The Honourable Member for Battle River Crowfoot.
Again, Mr. Speaker, one of the great things about this country is that we do have certain bodies, certain councils that protect consumers. Our honourable member mentioned the pharmaceutical industry, and obviously, again, we reach into that pill bottle and take a little pill that we hope is meeting certain standards, and I think the government, rightfully so, all governments, make sure that drug identification numbers and processes are there. Also, food safety. To be quite frank, we remember the melamine in the milk in China or in baby formula. I mean, we just assume that there are these groups. We kind of live in faith that the government is doing its due diligence in keeping Canadians safe. And so pharmaceuticals, food safety, vehicle safety, yes, to Canadians, there is a confidence that you can have. We have the highest quality food in this country with our agricultural products, but we also have the highest standards of safety. And I think all people are looking for ways that we can continue to give the consumer choice, but also certainty of safety.
Resuming debate, the Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker, and it's always a pleasure to be able to rise in the House. Welcome all members back. This is really the first opportunity I've been provided in terms of just being able to stand and add some of my thoughts and on an important piece of legislation. I reflect at the very beginning in terms of just how important it is when we have these breaks to meet with our constituents, to get a better sense in terms of what sort of messages they would want us to be bringing to Ottawa. One of the things I respect immensely about our Prime Minister is the fact that he continues to challenge members of Parliament to go into their constituencies and represent their constituents' interests here in Ottawa, as opposed to bringing the interests of Ottawa and representing those interests to the constituencies. That we need to ensure that our priorities are right, and the priorities are, quite frankly, ensuring that our constituents back home in our communities are in fact being represented, whether it's within this chamber, whether it's in committees, our caucus, respective caucuses, and so forth. So it's such a pleasure to be back here in Ottawa to deal with important government legislation. In fact, all legislation is important legislation, but today is really special in the sense that we're talking about Bill S2, legislation that will in fact make a difference in safety in our communities. It is something that is, I believe, very important for all of us to be able to understand and appreciate just what sort of an impact that this will have. And, one of my colleagues made reference to the fact that it's estimated, and this would be, I suspect, a conservative estimate, by saying 20% of our newer vehicles that are on the roads today are, in fact, in need of some sort of a recall on some sort of a manufacturer default. And there is a substantial cost to that. And listening to and wanting to be able to address that issue, this legislation carries the ball quite far, I would suggest to you, Mr. Speaker, and I applaud the Minister and the Parliamentary Secretary and all those involved in bringing forward the legislation, and I appreciate the fine work that the Senate has done, or the other chamber has done, in providing us this legislation to be debated today. I note that given the importance, and listening to my colleagues from across the way, there was a couple of comments that I would like to be able to address. You know, the Democratic representative made reference to the fact that there's different types of legislation that we will be expected to look at. And then making reference to the fact that S2, as a piece of legislation, should be relatively uncontroversial. It's a piece of legislation that ultimately, I believe, will receive the support from all members of this House, at the very least in terms of advancing it to the Standing Committee, where no doubt there will be a much more detailed analysis done of the legislation. And if there's ways in which it can be improved upon, I am sure that the committee will look at that and pass judgment in terms of if there's ways we can improve it, that we will do just that, recognizing that we can always do better where we can. We will strive to do so, Mr. Speaker. When we think of vehicle safety, that we need to recognize that there is two components in terms of, I would suggest to you, in terms of jurisdiction that play a critical role. One is the national government, and here today we have through S2 important legislation dealing with manufacturers. But you will find that often cars do not last a lifetime. You have individuals that today will have really two major expenditures. Their homes that they live in often, and followed by a vehicle in which they will acquire. Many of those vehicles are purchased at face value, being that they are brand new. There's a certain expectation of those vehicles. And Ottawa, or the national government, plays a critical role in terms of not only ensuring that our vehicles are safe, but to a certain degree also providing that assurances to the consumer. And we do that through recall, ensuring that manufacturers take responsibility for their product. So if, in fact, I walk into a showroom today and I buy a nice, brand new, shiny vehicle, and I pull off, and a month later there's an issue with an airbag or a steering column issue or whatever it might be, that I have some sense that there is going to be a recourse where the manufacturer will, in fact, have to rectify the problem, because it is not my driving that caused the issue, but rather it was a default or a manufacturing-related issue that has caused the problem. And we know that that exists. As I mentioned earlier, it's estimated 20% plus of all manufactured vehicles at one point or another should have something that has been recalled or needs to be tweaked or replaced. It can be fairly substantial. It could be something somewhat inconsequential in terms of cost, but important in terms of safety. So we know that those are the types of things that we have to face. Ottawa, in coming up with legislation such as this, is empowering the minister to be able to do certain things that we are not able to do today. And I want to focus some attention on a few of those things, Mr. Speaker. But to speak broader about the industry as a whole, we understand and we appreciate just how important the automobile industry as a whole is to our nation in terms of just the overall GDP, the impact that it has on real middle-class jobs, the impact that it has on our economy in every region of our country. Not only is it the manufacturers, there's the individuals that service, to the individuals that sell, to the major retailers that are out there that are very dependent on the automobile industry. It is an industry that I'm quite familiar with in the sense that whether it's through my father or other family members have been involved in it for in excess of 40 years. We understand that, the average individual, when they go out and they purchase a car, even though they might think that this is going to be the car for me for the rest of my life, very few will purchase a car and then that will be the car for the rest of their life. We know, for example, surveys have been done, whether it's between 6 to 8 years, that an individual will keep a car. After that, they will sell it. And it doesn't mean that once they lost interest or they changed or decided to go for a newer car, that car does not leave the road. That then becomes a second-hand car, and this is where you have many provincial jurisdictions coming to the table, recognizing that we do need to ensure that our roads continue to be safe. And that's why, if I use my own province, the province of Manitoba, if you sell a car, a second-hand car, there is an obligation to have it safety. So whether it is 2 years old or 10 years old or 11 years old, that vehicle, when it has been sold, is in fact a safe vehicle to be driving. As provinces continue to look at ways in which they can improve the second-hand cars and the condition of those vehicles on the road, we also have a responsibility to ensure that the new cars that are in fact being sold are in fact safe, and where we can play a role in ensuring that they are safer, that we should do just that. And Mr. Speaker, when I look at the legislation and what specifically it does, the first thing that comes to mind, and I say there's a few things, but one of the things that really kind of tweaked my interest was in regards to how the manufacturers will be financially responsible for correcting a vehicle defect, but there's also going to be a responsibility or an enhanced responsibility that Transport Canada will be provided information related to the safety of the vehicle. And that is, in fact, being enhanced with this legislation, where that information will go into the Transport Canada data bank. And one of my colleagues made reference to the data bank. Motor vehicle safety recalls. You go to the Canada Transport site, you'd be amazed in terms of just how detailed that data bank is. I would argue that many people that are driving newer vehicles today, whether they're 1 or 3 or 4 years old, those vehicles, there's a very good chance that there has been some recall of some part on that vehicle, and consumers or drivers are just not aware of it. And it's very simple to find out whether or not your vehicle has been recalled. You visit the website, you virtually click in the type of model and your vehicle is, and the style. It'll pop up saying, here's the recalls that have actually taken place. It is an incredible data bank. And I would suggest to all consumers, people that have purchased cars in the last number of years, that don't take it for granted just because your vehicle seems to be driving well. You don't have to wait for something to go wrong. There is a fantastic data bank that's there to be utilized. And one of the things that this legislation is proposing to do is to enhance that data bank by requiring additional safety information to be passed on, some of which no doubt will ultimately end up in some form of the data bank. I see that as a very, very strong positive, Mr. Speaker, and I would encourage others to look into it. The Minister will in fact have the power to call for additional testing to address safety concerns. That is something in which all of us need to be concerned about. It was interesting in listening to a number of the Conservatives. They talked a lot about Bill C-62, which is a piece of legislation that former Prime Minister Stephen Harper had brought to the floor of the House. And this is one of the reasons why I'm somewhat optimistic that the Conservatives should be on side and wanting to see this legislation passed sooner as opposed to later. Because the legislation, and I would suggest you, originates not necessarily from the Conservative government as much as actions that were being taken in the USA. There is a gap that has been created between the USA and Canada related to safety issues and recall processes and procedures and what that government is able to do in comparison to the government of Canada. I suspect that what we saw was a Conservative government looking at what was happening in the U.S. and then wanting to adopt some of those measures. And I do give them credit for doing so. I know that the NDP expressed some concern in terms of, well, this legislation wasn't in the mandate letter of the current minister. And the only thing that I could respond to that particular issue is that just because it's not within a mandate letter doesn't necessarily mean that the ministers are not looking at still improving the system. We have ministers that are very keen that will look and administer the mandate letters and achieve things within the mandate letter, but there are many other initiatives, and this is one of those initiatives. So it would appear across the way that both the NDP and the Conservatives are in general supporting the principle of the legislation, and we see that as a good thing, and we look forward to the opposition parties supporting it. In the legislation, the Minister of Transport will have the power to order companies to make manufacturers and importers repair a recalled vehicle at no cost to the consumers. For those that use and have to get vehicles serviced, there is a substantial cost factor to it. One would obviously argue, why should a consumer that purchases a brand new vehicle 3 months later find out that there was a default, have to be financially responsible for recovering or bringing that vehicle up to Canadian safety standards? So enabling the minister to have that additional power or authority is a very strong message that is being sent to the industry. I don't think that we need to say the manufacturers or all manufacturers are not taking their responsibilities to ensure that their vehicles are in fact safety and at the highest quality, Mr. Speaker. We recognize that manufacturers do whatever it is that they can, and we have seen manufacturers institute recalls, massive recalls, well into the billions of dollars, Mr. Speaker. We understand and we appreciate that the fact that this legislation is there because at times, whether it's today or going into the future, a minister should have the authority to be able to do what is being suggested in the legislation. It will allow Transport Canada to use monetary penalties or fines to increase safety compliance and to enter into compliance agreements with manufacturers to take additional safety actions. It will also increase and clarify Transport Canada's vehicle inspection capabilities. It is important that we have a sense of enforcement that's there, that's very real, that's tangible, that if we have a vehicle that needs to be recalled for whatever purpose, that we have the ability to ensure that that it is in fact being carried out, Mr. Speaker. That is also something in which we see within the legislation. I look at the legislation as a whole, recognizing that we need to see the Senate amendment and what is being proposed by the Senate is something that ultimately is dealt with within the legislation. If we take a look at what the legislation is proposing, Mr. Speaker, you'll find that we do not, or that with the Senate amendment, a company will be required to compensate a dealer for an amount equivalent to at least 1% per month of the price paid by the dealer. The amount would equal an annual interest rate of at least 12%. This arbitrary rate does not take into account the fluctuations in the real financing costs. As such, the amendment could have the perverse effect of a dealer potentially making more money by not making repairs, keeping the vehicle on the lot, and charging the manufacturer. Mr. Speaker, when one looks at the amendment that's being proposed by the Senate, I don't believe, as much as their intent might have been very good, that it is actually required. Within the legislation, the minister does have the authority to be able to have manufacturer defaults dealt with and paid for and recovered by the manufacturers. The minister has that authority already, and we've got to be very careful that within the Transport Canada legislation framework, that it is not required for us to play that arbitrary or that working with between the dealerships and manufacturers. It is very much a consumer issue, Mr. Speaker, and at the end of the day, as much as the intent of the Senate's amendment is meant to do well, I don't believe that it actually is required, that the opportunity to see dealerships adequately taken care of through the current legislation as being proposed is there. The minister will have that authority. It was interesting, one of my colleagues who made reference to the fact that we have to ensure that the priority of manufacturers when you think of recalls is to get the vehicles that are actually on the roads dealt with as the first priority. Those that are in those large compounds, and we've all seen those large compounds, Mr. Speaker, those vehicles, no doubt, will ultimately be on the road, and I suspect that there will be changes and modifications made to them before they're actually sold to the consumer. Bottom line, once it's all said and done, Mr. Speaker, this legislation is in fact all about increasing the safety on Canadian roads, and as such, ensuring that manufacturers and companies take on their responsibility by providing the type of vehicle that the consumer is expecting when they purchase that new vehicle. I think it's legislation in which all of us should be supporting.
The honourable member for Flamborough-Glanbrook on a point of order.
Mr. Speaker, I just thought it would be important to point out that we just finally had a good example of a good response to the Parliamentary Secretary, the House Leader, and unfortunately the example was removed from the House, so I hope everybody takes a look at Hansard in the future and takes a look at a proper reaction to the member's speech.
I'm not sure what the honourable member is referring to in terms of a point of order. Perhaps I missed something in the debate, but I'm not giving anything to react upon here. We'll go back to the honourable Parliamentary Secretary to finish his remarks. I know we are getting close to the end of his allotted time. I'll just remind him of that. The Honourable Parliamentary Secretary.
Yes, thank you, Mr. Speaker, and I look forward to a question, and maybe the member across the way can expand as to what it is that caused the frustration that led him to standing up on a point of order. I believe the time has expired, so I look forward to his question. Maybe he can kind of expand on his point of order.
Questions and comments? The Honourable Member for Carlton Trail, Eagle Creek.
Thank you very much, Mr. Speaker, and I want to thank my colleague across the way for his comments on S2. I have had the opportunity to ask a question of a number of the members of the governing party, and I would just ask if he could, if he had to, what would he pick out are the key differences between C62 and S2 that he believes makes this a better bill? Thank you.
The Honourable Parliamentary Secretary of the Government House Leader.
Well, Mr. Speaker, I appreciate the question and take it very seriously from the member. As I pointed out, C-62 was a piece of legislation that came out of concerns that were being developed in the United States, and the Harper government introduced it at that point. There was a review from within the ministry, and with all due respect, maybe it might be advisable for the member to have posed the question, and I suspect maybe she has. I'm not sure of the minister that introduced the bill, so she probably already has the answer to the question that she's actually posed. We do know, or I believe, that the Senate itself and the amendment that they've brought forward was not incorporated into C-62, if that's the point that she's getting to.
Questions and comments? Question commentaire. The honourable member for Hamilton West, Ancaster Dundas.
Thank you, Mr. Speaker. Really, this legislation this morning we're talking about is safety first and foremost. And, you know, we want to ensure that all vehicles on the road are safe. And I'm happy that we're taking steps to ensure that. I speak firsthand. I was in a terrible accident. I'm lucky to be alive today. Airbags deployed, glass crumbled, vehicle flipped right upside down, and I was lucky the roof didn't crunch. And I know there's many others that have had similar experiences. So that's really what today is about. It's about ensuring that the vehicles, part of it is about ensuring that the vehicles on the road are safe. Now, the member talked about manufacturers and them taking the responsibility for their products and how this legislation actually enhances that. So I wonder if the member could comment on this very important point about how this will ensure that manufacturers are more accountable and more responsible with respect to ensuring that the vehicles that we drive on the road are safe.
The Honourable Parliamentary Secretary to the Government House Leader.
Yeah, the single greatest thing that the legislation does is that it attaches additional powers to the minister and provides additional information to the department, Transport Canada. I believe that it will help facilitate different types of agreements between companies and manufacturers, things that were not incorporated into the previous legislation under the Harper government. But these are likely some of the more significant things, but the member is quite right in the assessment. The number one priority of the legislation is to ensure that Canada has safer roads. And the second one I would ultimately argue is also to protect the consumer. As I pointed out, Mr. Speaker, that when an individual goes in to buy a brand new vehicle, there's an expectation that vehicle is going to last a good number of years, 200,000 plus kilometers, depending in terms of how the individual drives and maintains the vehicle. But there's this expectation that when they enter into the showroom and they purchase this new vehicle, that there will be a vehicle that will in some way be safe to drive at all times. And with the recall legislation, or what we're doing within this legislation, is that we're ensuring that manufacturers stick to their responsibilities in ensuring that when there is a known default or problem with a vehicle that has been sold that is not consumer related, but rather it's a manufacturing default issue, that the part and the labor is in fact covered for it to get that vehicle safe and back on the road.
Questions and comments? Question commentaire. La députée.
The Honourable Member for Trois-Rivières. Thank you, Mr. Speaker. My question is simple and somewhat repetitive, but I still haven't gotten the answer. Even though I do acknowledge that there is some virtue in Bill S2, and I pointed this out in my speech earlier on, I'd like my colleague to point out what parts of S2 address the or several safety gaps that were raised by the Auditor General for motor vehicles. The Honourable Parliamentary Secretary for the Government House Leader.
Thank you, Mr. Speaker. I believe, not having read the report that the member is referenced, and I've heard the member pose that question a couple of times this morning. So I really don't know the details, or I can't provide the type of answer that the member across the way would like. Suffice to say that the Government of Canada does look in terms of what it is that our independent officers of Parliament have to say on a wide variety of issues, including this one. And I suspect that you will find that there are a number of the issues that the auditor would have raised that have, in fact, been addressed within this legislation. I think that coming from an opposition point of view, and I sat in opposition for a number of years, the real challenge for the opposition is to look at what the auditor has said and where the NDP might feel that the legislation doesn't meet what the auditor has requested. And then I think that might be more helpful, especially going into the committee stage. As I indicated earlier in the speech, that we have a government that is very sympathetic to well thought out, argued, and articulated amendments that could possibly be made to improve the legislation. And if the NDP have some specifics, I am sure that whether it's the parliamentary secretary, the minister, or members of the committee, in particular if it's at committee, the members of the committee will be afforded the opportunity to have a good, healthy discussion and vote on the merits of what's being proposed by all members of the House.
Questions and comments? Essay commentaire. Before we go to resuming debate, I think the Parliamentary Secretary, the Government House Leader, perhaps had another point that he was going to arise on. The Honourable Parliamentary Secretary.
Yes, thank you, Mr. Speaker. And I guess it would be on a point of order. There have been discussions amongst the parties, and if you seek it, you should find consent to adopt the following motion. I move that the membership of the Standing Committee on Procedure and House Affairs be amended as follows. Member from St. Catharines for member for Scarborough Agincourt, and the member for Perth Wellington for the member of Halberton Kawartha Lakes Brock.
Does the Honourable Parliamentary Secretary to the Government House Leader have the unanimous consent of the House to propose this motion? Yes? The House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? Yes? Agreed? Agreed and so ordered. Resuming debate, the Honourable Member for Edmonton West.
Thank you, Mr. Speaker. I'll be sharing my time today with the Honourable Member from Medicine Hat, Councillor Warner. But before I start, I just want to mention it's been almost 2 years since the passing of my friend's predecessor, Jim Hillier. This summer, I had the absolute pleasure of having Jim's son, London Hillier, as our interim, and I just want to let Jim know upstairs that your son London did a fantastic job and you should be very proud of him. I'm pleased to rise today to talk on Bill S2, an act to amend the Motor Vehicle Safety Act. Like many of the people in the House today, we generally support the intent of the bill. Presently, the Motor Vehicle Safety Act limits the power of the Minister of Transportation to issuing notices of safety defects and criminally prosecuting manufacturers. Transport Canada does not presently have the authority to order recalls, but rather to list active recalls on its website and issue press releases if it believes that there is an issue with a type of model or a vehicle. S2 amends the Act to provide the Minister with the authority to order a vehicle recall and order the vehicle's manufacturer to correct the defect at no cost to the consumer. So far, so good. Now, an honourable Conservative senator from Newfoundland amended the legislation to ensure that vehicle manufacturers would be responsible for the costs to protect car dealers from shouldering the costs of the vehicle. Now, in Edmonton West, we have many car dealerships, and I've spoken to several of these dealers, and they are 100% behind this amendment, of course, because it saves them money. Now, I generally agree with parts of this amendment, but not where the amendment starts to set out compensation guidelines. I believe that's best left to the market to decide. Mr. Speaker, I support legislation that will protect consumers from unnecessary and unfair financial burdens of defective products. It should not fall to a consumer, nor really the car dealer, to assume the cost of manufacturer defects, particularly with something like vehicles, which has potentially fatal consequences if something goes wrong. I also support legislation that is designed to keep consumers informed of any real or potential dangers with the equipment they choose to purchase. Now, the Auditor General report on Transport Canada, the Oversight of Passenger Vehicle Safety Transport Canada report, lists two positive items on S2. One, they point out a proposed new regulatory power to establish information reporting requirement that would help identify safety defects sooner. The Auditor General report also notes a positive part of S2 It would have required companies operating in Canada to be more aware of foreign defects and issues of non-compliance for vehicles that are similar to those sold in Canada. Now, that said, I have a few concerns with S2 as it is outlined, and I'm going to elaborate now. The government's justification for this legislation is, to be charitable, a bit underwhelming. For the words of the government's representative in the other place, he stated it's because vehicles are complex and sophisticated and much of the technology is proprietary. No kidding. Bill S2 gives the minister new powers on ordering companies to conduct tests, analysis, or studies on vehicles or equipment at the minister's discretion. At the minister's discretion. No parameters, no guidelines, just at the minister's discretion. I want to stop and take a look at what's going on with Boeing and Bombardier. The government is putting jobs at risk, investment at risk, and has politicized the replacement of needed equipment for our men and women in uniform to protect their friends in Bombardier. And we want to give unfettered and undefined power to the minister. We ask, what is next? Interfering with General Motors' CAMI strike going on right now because of concerns of moving the plants to Mexico or the U.S., or using these powers to punish Toyota for not putting a plant in a friendly riding. I know it sounds inconceivable, but we have to stop and look at this through the lens of the Bombardier and Boeing mess, where the government has stepped and interfered. We have to look at the Liberal cabinet interfered with the purchase of the Navy's replenishment ship, apparently at the orders of a rival firm. Now, it's important to ensure that motor vehicle inspectors at Transport Canada have the information they need to ensure companies are complying with the Motor Vehicle Safety Act. It's also important that we're not necessarily and excessively increasing the discretionary power of the minister at the expense of companies invested in Canada. 2015, it's been noted before, 5 million passenger cars were recalled in Canada. Dozens of vehicle types were recalled each year for which Transport Canada had not received any complaints. This means that vehicle companies, who already have the incentive to ensure that their vehicles are operating safely on our roads to the benefit of consumers, are largely fulfilling their role ensuring vehicle safety. Therefore, left wondering if we're increasing the discretionary power of the minister and the Department of Transport to fix a problem that does not really exist. The government's argument is that the powers are anticipatory. Unfortunately, it's logically inconsistent to arbitrarily increase the power of a member of the executive unless there's a clear need to do so. The new ministerial powers are also potentially self-justifying of their actions. The minister would be able to order a company to conduct tests on a product and provide evidence to the minister, which the government can then turn around and use to justify a recall against the same product. The legislation also gives vehicle inspectors from Transport Canada new powers to enter any other private property other than a home dwelling, examine any documents, disassemble and remove any components, use any computers that are on the location, and copy data, as well as interrogate workers present to ensure compliance with the Act. This power is quite exceptional and directly contradicts the very basic privacy protections afforded to individuals and businesses in Canada. The government must provide clear and objective standards under which the minister would invest inspectors with such extraordinary powers to prevent said abuses of power. Now, reading from the Auditor's General Report, there's a couple items here. It states, overall, we found Transport Canada did not develop motor vehicle safety standards to respond to emergency risks and issues in a timely manner. We had to wait for the U.S. to change its Motor Vehicle Act before modifying Canadian standards. Also said we could not always determine how the department used evidence and research to develop and amend safety standards. Transport Canada did not plan or fund its research and regulatory activities for the longer term. Now, nothing in this Act does anything to address these real concerns addressed in the Auditor General's report. Earlier, the minister stated that Bill S2 was well-intentioned. I think we do need something a bit more than well-intentioned. Now, the Auditor General provided a rather uncomplimentary assessment overall of the state of operations in Transport Canada Motor Vehicle Safety Directorate. His office was especially tough on the processes Transport Canada used to create and enforce new regulations, noting that we, as in the AG, could not always determine how the department used evidence and research to develop or amend safety standards. So the AG cannot determine how Transport Canada comes up with safety standards, but the government wants to give Transport Canada full power to order recalls and demand to demand companies conduct research on safety standards. It's not clear how Transport Canada would obtain, utilize, and keep the vast new data they've been able to collect, and is unsure whether it will be able to justify the decision to obtain the data in the first place. The Auditor General criticized Transport Canada's national database for not including complete Canadian data and for not attaining relevant information on industry statistics. Troubling that the department criticized for its existing processes should be granted new powers without clear mechanisms for oversight to protect the integrity of the process. Perhaps the minister should focus his energies on addressing the Auditor General report first before moving on with S2. Now, we look forward to the minister addressing the processes at Transport Canada and to rectify the issues noted by the Auditor General. And I encourage the government to provide adequate justification to make the case to increase discretionary power. It's unclear how the government plans on addressing differences in opinion between vehicle manufacturers and Transport Canada. While not opposed, auto and parts manufacturers are concerned about the outcome of the potential difference in opinion and about the nature and gravity of the defect defined between them and Transport Canada. It's incumbent upon the government, as I mentioned, to ensure that they are creating a system that is open and clear and can be objectively applied in each case. Perhaps some system where they could make evidence-based decisions or something. That all being said, I'm concerned about the lack of details surrounding the arbitrary increase in the powers afforded to the minister. I'm further concerned about the lack of oversight of Transport Canada, which has been criticized by the Auditor General specifically for being opaque regarding its internal processes and decision-making frameworks. I hope we can get this legislation to committee for further study and trust this committee will take a long, hard look at ours and the Auditor General's concerns. Thank you, Mr. Speaker.
Questions and comments? Question commentaire. The Honourable Member for Hamilton West, Ancaster Dundas.
Thank you, Mr. Speaker. As has been noted many times in the House this morning in discussion of this bill, it's really about safety and protection of consumers. And so I'm curious because the member across now is questioning the use of ministers' powers. So let's take one of the powers that the minister would have in this legislation. And that power would be that if a defect is found, that the minister would have the power to make sure that before the vehicle is sold, that defect is corrected. Now, I know as a consumer, before I buy a vehicle, I want to make sure that it's working and it's in good order. I've just shared my own personal experience with being in a very significant car accident. So I want to know if the member has a problem with this specific power of the minister, which we know whose concern is safety and protection of consumer. Does he have a problem with the fact that the minister has the power now to ensure that unsafe vehicles aren't sold?
The Honourable Member for Edmonton West.
Thank you, and I thank my colleague for the question. Obviously not. The issue we have, and very clearly I said in my speech, perhaps she wasn't listening, is obviously he has to have the power of the recall. The issue we have is the undefined power for himself and also for Transport Canada. The undefined power to go in at will and raid offices looking for information. It's just the issue is the power is undefined. If they want to put it in a statute or very clearly write out, we have the power to recall on this condition or this and this, we're perfectly fine. We just ask it to be defined better. But thank you very much.
Questions and comments? Question commentaire? La députée.
The Honourable Member for Trois-Rivières. Thank you, Mr. Speaker, and I'd like to thank my colleague for his speech. I share many of his comments and concerns, but I think one crucial point is this. Are we talking about a bill that is only attractive in its appearance, or is it something that it will do something and that will require a significant investment in order to implement these virtuous principles in the bill?
Honourable Member for Edmonton West.
Thank you, Mr. Speaker. My colleague from the NDP makes some very good points. S2, while the intent, as the minister mentioned, is well-intentioned, we need a lot more than just good intentions for this. The Auditor's General report is rife full of issues where Transport Canada has ignored safety issues, recall issues down in the States that they've known about for years. They've laid off people in the investigative division. The problem with this is S2 does not go anywhere near far enough to address very important safety issues. We hear the people on the government side talk, oh, safety, safety, safety. S2, while we do intend to support it again into committee, does not go anywhere near far enough to really look after the true safety of Canadians. I would suggest that the government take a really hard look at the Auditor's General report and listen to what myself and some of the colleagues in the NEP have to say about it. Thank you.
Questions and comments? Question commentaire? L'honorable député.
The honourable member for Salaberry-Sirois. Thank you, Mr. Speaker. I have a question for my colleague. When the Liberals say that they want to improve motor vehicle safety through Bill S2 and that they're going to be able to designate enforcement officers, does my colleague think that with a 59% funding cut in the oversight capabilities of Transport Canada, does he think that they will in fact be able to go ahead and ensure protection for motor vehicle drivers? Or should the Liberals reinvest massively in the Department of Transport? The honourable member for Edmonton West.
Thank you, Mr. Speaker. Again, she has a very good point. We've been discussing about we want real safety issues and not just fluff. The Auditor's General report is very clear about the people laid off in the safe or areas for safety investigations. We strongly hope the Liberal government, as well as the members of the committee, will take to heart the very common sense, straightforward suggestions by the Auditor General and bring about the changes that will help bring much better safety conditions to Canadians and drivers. Thank you.
Resuming debate, the honourable member for Medicine Hat, Cardston Warner.
Thank you, Mr. Speaker. I'm pleased to rise today to speak to Senate Bill S2 to amend the Vehicle Safety Act to empower government to force recalls of vehicles with safety problems. The role of government is, as we know, first and foremost, to protect its people. We cannot protect everyone from everything, and as they say, to defend everything is to defend nothing. However, we certainly should be protecting Canadians from predictable safety issues. I think all members in this chamber and most in the other chamber as well can agree on these principles. Protecting Canadians is the role of all parties and all parliamentarians. That is why this act has been introduced twice in two different chambers by members of two parties. Bill S2 is very close to the bill tabled at the end of 2015 by the honourable member from Milton, then the Minister of Transportation. She tabled Bill 662 to provide recall powers to the Minister and the Department of Transportation, impose fines where appropriate, and ensure that Canadians have safer vehicles. Bill S2 was diligently reproduced from this leading legislation by the Senator, and we appreciate his work, the work of the members of the Senate Transportation Committee, and all the witnesses that appeared before them to bring this legislation forward. This bill provides new powers that are not really that new. In fact, if you were to read stories about vehicle recalls in the press, it almost sounds like the government has recall powers already. Surprisingly, though, Canada's federal government lacks recall measures to order manufacturers to recall any vehicle with a defect. According to testimony before the Senate, Canada has the power to order recalls and changes to other vehicles like airplanes and ships, but not to any cars or trucks. What this bill does is create those new recall powers as well as penalties of up to $200,000 per day and makes it the prerogative of the manufacturer, not the dealer, to make repairs. From the testimony, some of the issues that occur when there is a recall will continue, and it can't be fixed by legislation. As any of us who have gone through a recall know, the recall may be ordered, but the parts are not always instantaneously available. I read an interesting article last week, the story of a John Fawcett from Iqaluit and his recalled Jeep with a known defect that abruptly shifts the transmission into neutral while driving. As a new father, this created a major problem for him. his vehicle was unsafe for his family. After some research, Mr. Fawcett discovered that his Jeep was under manufacturer's recall for 4 different issues that were listed on Transport Canada's website. The issue of the abrupt shifting of gears was also listed on the website and described as an unexpected shift to neutral, which could result in a loss of motive power, which in conjunction with traffic and road conditions and the driver's reactions may increase the risk of a crash. Mr. Fawcett accepted that his car needed a bit of work and that Chrysler was responsible for doing this work. This bill will ensure that consumers like John are protected from the potentially catastrophic accidents that can result from manufacturer's defects and authorize the Minister of Transport to order a company to correct a defect or non-compliance in a vehicle or equipment if it is considered to be in the interest of public safety. In addition, there would be the power to order companies to pay the costs of correcting a defect or non-compliance in a vehicle or equipment. These combined order powers are important for potential situations where consumers would be expected to pay for the correction of a defect or non-compliance in a vehicle or equipment. Such a situation would place an unreasonable financial burden on Canadians and potentially place other Canadians at risk should their fellow citizens be unable to undertake the necessary repairs. Mr. Speaker, I will have to agree with my colleague from the Senate Chamber and former City of Ottawa Police Chief who summarized this bill as legislation that will strengthen the oversight of the recall process. It will be a big win for consumers and overall for safety of Canadians, end quote. The purpose of Bill S2 is to increase consumer protection and motor vehicle safety in Canada. This is why the previous government brought this bill forward in 2015, why it is before us today, and why I will support this bill. I found it useful to look at some of the parts of the testimony provided by consumer protection groups, vehicle dealers, and manufacturers. First thing that came to me was the interesting insert of the dealers and manufacturers arrangement. The dealer networks noted that some, not all, but some manufacturers were providing poor business support to their dealers. Dealers were left holding costs for vehicles under safety recalls that were not sold to a customer directly, or already, I mean. It was left to the headquarters of the car manufacturers in other countries to determine if they would provide help or not. This seems like a poor arrangement and a bad relationships between two businesses. And that I was confident that government can help fix a poor business relationship. And time will tell if this new arrangement to manage recalls between manufacturers and dealers is a good deal for the end user. Because, Mr. Speaker, when this bill was tabled under the previous government, it was all about the protection of consumers. There were no clauses about fixing a lopsided business relationship. The bill was about protecting people who use and operate vehicles daily. Specifically, the bill ensured that vehicle recall notices were sent as soon as possible so that people were aware of potential risks, that manufacturers were required to act on the recall quickly and at the convenience of the customer, not at the convenience of their product cycles, and that manufacturers cover the costs associated with the recalls. This put families first and works at the heart of protecting our regulatory regime. The president of the Canadian Vehicle Manufacturers Association said that, and I quote, "In particular, we support Bill S2 amendments that provide a clear, more rigorous and transparent process for exercising a number of ministerial powers to order, recognition of the rapid pace of technology change through enhanced ability to provide exemptions to standards where new technologies exist," end quote. So we know for the most part the manufacturers agree in principle with many of these measures. So why would they agree? Well, for the American companies, this aligns for the most part with U.S. regulations, and this makes it easier to understand and comply. This bill empowers the Minister of Transport to impose fines on manufacturers who delay or postpone recalls or who do not comply with recall orders. Ian Jack from the Canadian Automobile Association said, and I quote, "The Canadian system is a veritable, if not literal, paper tagger. Bill S2 will give the Minister the authority to order a company to issue that recall, to make companies repair a recalled vehicle at no cost to the consumer, and to prevent new vehicles from being sold in Canada until they are repaired. This matches similar legislation that exists in the U.S., finally leveling the playing field for Canadian consumers." So, Mr. Speaker, S2 brings Canadian consumers up to the level of other consumers around the world, at least on measures related to recall notices. And this measure aligns with the harmonization of regulatory issues across the U.S. and Canada. Mr. Speaker, this legislation brings forward the protection of consumers, ensures that Canadian dealer networks are treated fairly, and ensures that our roads and streets have safer vehicles on it. I'm always happy to see some bipartisan cooperation on issues that ensure Canada is protecting its citizen. And I'm always happy to support when Liberals follow the leadership of the previous Conservative government. I'd like to thank the Senator for bringing this legislation forward, and like many parliamentary processes, it ran longer than a single mandate or government. I look forward to working with him and all my colleagues in the House to advance this legislation. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires?
Questions and comments?
La députée de Trois-Rivières.
The Honourable Member for Trois-Rivières. Thank you, Mr. Speaker. I listened carefully to my Honourable colleague's speech, and although I agree that we are looking forward to this impatiently, looking forward to its referral to committee, one of the things that I find problematic is that I would like to know what he thinks the major lack is in S2 as we go forward with our work.
Warner.
Mr. Speaker, I'd asked the member, there's a phrase in there that the interpreter didn't allow me to hear very clearly on the question. There's something in this legislation that prevents, and I'd missed what that was. If I could just get them to ask that one more time, please.
Alors, peut-être la députée de Trois.
The Honourable Member for Trois-Rivières. The Honourable Member. Yes, very briefly. I would ask my colleague to identify what, according to him, is the major fault or lack in the bill.
Carson Warner.
Thank you, Mr. Speaker, and I thank my colleague for his question. You know, I think there is probably a number of things that if you look at this particular piece of legislation is a carry forward. I think one of the things that when you look at it is the government now trying to get into a business relationship fixed between manufacturers and dealers, and something they have to deal with? I think that could be an issue that could detract from the intent of this bill, which is to protect Canadians. And I see that as probably the largest gap that exists right at the moment, Mr. Speaker.
Questions and comments? Questions and commentaires? The Honourable Parliamentary Secretary to Government House Leader.
Yes, thank you, Mr. Speaker. And based on the last answer, there is a question that comes to mind in regards to the Senate amendment. One of the positions that we've taken with respect to the Senate amendments, not being able to support the Senate amendments, is the fact that we don't see that our role is to deal with the commercial relationship. So how that Senate amendment actually is encouraging the national government or transport to get engaged into commercial relations. And I'm wondering if the member would agree that we should be concerned about that aspect of the Senate amendment. By the sounds of it, he does, but I would just like him to affirm that he shares that concern.
The Honourable Member for Medicine Hat, Cardston Warner.
Mr. Speaker, thank you for my colleague for the question. I think it's fair to suggest that if the legislation loses focus from its intent of protecting Canadians and on vehicle recalls, and it gets bogged down with the requirements of business relationships in a commercial setting, that it may detract from its intent. I don't know if it's a deal stopper, but it's certainly something that at committee should be considered. Thank you.
Questions and comments? Questions et commentaires? La députée de Saanich Gulf.
The Honourable Member for Saanich Gulf Islands.
The committee will have the time and the experts to advise. But in turn, to the member for Medicine Hat, a member for Central Nova suggested there could be constitutional issues about the Senate amendment. That had not occurred to me. Certainly the heart and soul of the bill speak to the relationship between consumers and car makers, and the dealers are somewhat in the middle, but I'm not sure that puts it suddenly into provincial jurisdiction when all parts of the legislation deal with we want to make sure that we leave the customer in a good position after having had a recall of vehicles. I just wonder if the member for Medicine Hat has any thoughts about whether there are constitutional issues raised about the amendment from his point of view, bearing in mind that I think we all are going to need constitutional advice when the bill gets to committee.
The honourable member for Medicine Hat, Cardston Warner.
Thank you, Mr. Speaker, and thank you to my honourable colleague for the question. I have to admit I am not a constitutional expert, and I'm not aware what challenges this might present. However, I would agree that it certainly is worthy of study and advice, and I actually have no comment further to make on that because I'm certainly not aware of what that could be. Thank you.
Resuming debate, the honourable member for Vaughan Woodbridge.
Thank you, Mr. Speaker, and good afternoon to all my colleagues. Mr. Speaker, it's a great pleasure that I rise to speak on Bill S2, an act to amend the Motor Vehicle Safety Act, or the Strengthening of Motor Vehicle Safety for Canadians Act. The safety of Canadians is of high importance to this government, and this bill will help further ensure safety for Canadians. The rapid development of automated and connected technologies for light-duty vehicles is of great interest to this government. We have heard of fully autonomous vehicles, ones that can fully drive themselves without the aid of a driver. Prototypes of some of these vehicles are already undergoing on-road testing in the United States. This exciting new area of vehicle technology development can be seen as both a safety benefit and an economic innovation opportunity. Shifts in the global technology landscape are placing a growing reliance on vehicle safety innovation while transforming business practices and consumer demands. These emerging and disruptive technologies offer promising opportunities for economic, safety, and environmental benefits, as well as a number of regulatory challenges. The pace of change associated with these technologies and how they are transforming the motor vehicle sector is rapidly increasing, while the regulatory process, remains unchanged. Mr. Speaker, new technologies offer promising opportunities for improving road transportation and, yes, road safety, including the environmental impact of vehicles. However, these technologies can be challenging in terms of safety oversight. Much of the technological safety of a vehicle cannot be seen by the naked eye. From the outside, two vehicles may look the same, but many of the safety elements are internal to the structure or operating systems of a vehicle. Safety standards include those related to crashworthiness and crash avoidance, crashworthiness or how to survive once you are in a collision. Standards include those related to front and side impact. As we shift to new technologies and building materials, we need to ensure that this survivability is not compromised. Crash avoidance technologies allow drivers to detect and avoid collisions. One example of such technology is electronic stability control, which has been mandated on new vehicles since 2011. For this type of technology, we need to ensure that the promises made by the developers are accurate, as consumers will be relying on those technologies. The speed and scope at which new technologies are being developed and implemented is challenging the status quo and is testing government's ability at all levels to respond in a timely manner. Canadian industry and businesses need to understand, adopt, and deploy new innovations and business models to stay competitive and better position Canada for success in leveraging the full potential of emerging and disruptive technologies. An important element of the discussion will be about motor vehicle technologies and how they are regulated. The legislation needs to be flexible and adaptive to promote Canadian leadership and to give Canadians access to these new technologies as quickly as practically possible. The regulations are aimed at keeping Canadians safe, but they cannot be so rigid that they delay the introduction of new vehicle safety technologies or fuel systems. Mr. Speaker, these proposed improvements to the Motor Vehicle Safety Act have been developed to address these and a number of other important challenges. Currently, the Motor Vehicle Safety Act includes a provision for interim orders. An interim order allows a Canadian regulation that corresponds to a foreign regulation to be suspended or modified if there is a change by that foreign government. Currently, interim orders can suspend or modify Canadian regulation for 1 year, which does not reflect that some regulations could take longer to develop, particularly if they deal with very technical subject matter. As such, Bill S2 proposes to extend the period of an interim order to 3 years to reflect the typical length of time required to complete the full regulatory process for such a technical requirement. The bill also introduces suspension orders, which allow for the suspension or modification of an existing Canadian regulation. For this type of order, a foreign government's enactment or regulation is not required. In this way, Canada has a tool to lead the way in regulatory development to address new and emerging technologies. This process permits the Minister of Transport to allow newer technological solutions, when appropriate, to take effect more quickly. The order would be in place for up to 3 years, Mr. Speaker. Mr. Speaker, both of these tools will increase the flexibility of the Motor Vehicle Safety Act to address an ever-changing landscape related to the automotive industry globally. These orders will be published and will apply to all manufacturers equally in order to provide a level playing field. Another tool that is currently available in the Motor Vehicle Safety Act is an exemption order. These orders allow the Minister to exempt a model of vehicle from a regulation. Currently, exemption orders are only valid for 1 year and require approval from the Governor and Council. An exemption is requested by the regulated body and is up to that entity to demonstrate that safety is not negatively affected. An example of this type of request would be if a manufacturer, an automotive manufacturer, auto parts supplier, applied to not meet a rear-view mirror regulation in order to install a rear-view camera that performed the same function or improved on it. As these requirements are very technical in nature, under these proposed changes, the Minister would be given the power to decide, based on the best evidence, whether it is in the interest of safety to grant the exemption. The duration of the exemption would apply for 3 years to allow sufficient time to determine what technical regulatory requirements will be appropriate and to allow time for the manufacturer to implement and use the proposed technology. The exemption would only apply to that model of vehicle, but the exemption would be made public, allowing other manufacturers to be knowledgeable about options for advancing their own technologies. Mr. Speaker, in summary, the automotive industry is changing very rapidly, and vehicle technologies are making vehicles safer and more fuel efficient. However, these changes are challenging our regulatory capacity to assess and apply them in the Canadian context in a timely fashion. This Act includes a number of tools to allow adoption of regulations already available in another country and the ability to create short-term regulatory changes in advance of the full regulation of being available. It will also be possible to exempt specific models from a regulation that would no longer be applicable to that model, for example, for a different type of fuel system. Mr. Speaker, I'm glad to say this represents a new regulatory process for Canada for the next century and will increase safety and fuel efficiency on our roads and help Canada be an important player in the next generation of the automobile. Thank you, Mr. Speaker.
Questions and comments? Question commentaire? La députée de Trois-Rivières.
The Honourable Member for Trois-Rivières. Well, thank you very much, Mr. Speaker. Now, there's an aspect of information that I would have liked to have heard from my colleague, but it wasn't something that he said in his initial remarks. Perhaps he could answer a question. Now, when he talks about a dealership, when we talk about dealerships back home, we talk about middle-class jobs, be it the mechanics, the salesmen and women. There are small and medium-sized businesses that contribute to the local economies and to the development of our markets. Now, I understand from the start that the Liberals don't agree with the Senate amendment to S2 to facilitate compensation for dealerships. If that's not something that they agree with, do they have something else to propose to deal with this issue for the dealership owners?
On Woodbridge.
Thank you, Mr. Speaker, and thank you for the question from the Honourable Member from Trois-Rivières. I think it was correct. When looking at S2, and our government recognizes the importance of protecting Canadian consumers and ensuring road safety in Canada, and that's what the intent of Bill S2 is. What I would say, in looking at commercial relations between automobile manufacturers and dealers, the Motor Vehicle Safety Act is not intended for that purpose. It is intended for the safety of Canadians. Thank you, Mr. Speaker.
Questions and comments? Question commentaire? Questions and comments? The Honourable... Nope. Resuming debate. Reprise de débat. The Honourable Member for Yellowhead.
Yeah, Mr. Speaker, just 1 second while I grab a pedestal. Didn't think my time was quite up. Thank you, Mr. Speaker. Sorry for the short delay there. I'm pleased to rise in the House today to speak on Bill S2, the Strengthening Motor Vehicle Safety for Canadian Act, which amends the Motor Vehicle Safety Act to give the Minister of Transport new vehicle recall powers. And I believe this is good for Canada. According to the Department of Innovations, Science and Economic Development, there are 5 major auto manufacturers in Canada, Mr. Speaker, and they operate approximately 11 different manufacturing facilities across this country. In addition to that, there's approximately 3,200 car dealerships across Canada, and in my riding alone, Mr. Speaker, I've got 15 different car dealerships. And my point in saying this is that we're talking about a massive industry, an industry that employs hundreds of thousands of people and are a very strong contributor to the Canadian economy. Now, I'd just like to go back 50 years or so. You know, back in 1965, there was a guy that not very well known at that time by the name of Ralph Nader. And he wrote a book called Unsafe at Any Speeds. You know, if you look to a lot of journalists and stuff like that, that's one of the best written books or articles in the 20th century, Mr. Speaker. He took on GM. He challenged him for a vehicle that they were producing at the time, the Corvair. But he didn't only mention the Corvair. He went out of other cars, the Falcons, and a lot of new American-produced subcompacts as being unsafe. Nader later went on to form the Nader Raiders, a group of young, brilliant lawyers from across the United States. And they challenged the U.S. government and industry to improve the standards of building new vehicles in the United States. They went after international manufacturers to improve the standards of building new vehicles in the United States. And of course, what they did spun off to help protect Canadians. You know, their work directly led to the development of the Center for Auto Safety in the United States. Today, we're here talking about Bill C2. And, you know, this is because of what Ralph Nader and his group started. The proposed legislation includes amendments that would give the Minister of Transport the power to order companies to issue a recall notice and make manufacturers and importers repair recalled vehicles at no cost to the consumer. It will give the Minister of Transport the power to order manufacturers and importers to repair new vehicles before they are sold. And this is very important, and I will get back to it later, Mr. Speaker. It allows the department to use monetary penalties or fines to increase the safety compliance and leverage the monetary penalties to require manufacturers to take additional safety actions. It will provide the department with flexibility to address our ever-increasing vehicle safety due to new technology. And it will require companies to provide additional safety data and conduct additional testing to address safety concerns and increase our vehicle inspection capabilities. This is good for Canada. It's good for the safety of Canadians. As you may have noticed, this bill is similar to Bill C-62, which was introduced by our previous Conservative government in 2015. This bill has provisions that did not appear in Bill C-62. It differs by adding consent agreements relating to safety improvements and non-compliance companies. It also enables the Minister to make the nature of any violations and other related details public. And why shouldn't they be public? Currently, under the Motor Vehicle Safety Act, Mr. Speaker, only manufacturers can order vehicles recalled in Canada. Transport Canada does not presently have any authority to recall vehicles. This needs to change. This act will make that happen. The department merely lists active recalls on its website and issues press releases if it believes that there's an issue with models of vehicle. As I said earlier, Mr. Speaker, The Nader Raiders led us to where we are today. You know, if we look right back to the turn of the century, Henry Ford had no rules. He built cars as he saw fit. He designed them, and you took what he made, and if you didn't like it, too bad. But automobile industry had a pretty good run at manufacturing cars for the first 50 years of the 20th century, without a lot of rules. Thank God today we have strict global automobile manufacturing rules and laws. This new bill is part of that strategy. Mr. Speaker, the current act does not allow Transport Canada to issue monetary penalties to manufacturers. The only way to ensure compliance with the act is through a time-consuming and costly criminal prosecution, a change that will come about because of this bill. I'm sure many members in this House, and maybe a few of us, might own 2015 Volkswagens or 2014 Volkswagens. There was an issue. I don't want to dwell into it because I think most people here in this room know what those issues were. This had far-reaching effects on hundreds and thousands of Canadians who purchased these German-made vehicles. You know, and it took from the time this all started to only this spring when the claims were finally being resolved and there was a standard in which they were going to justify the things, and there are still some claims outstanding out there. It shows, even today, Mr. Speaker, major world-class manufacturers can make mistakes. And I'm going to leave it at that with a few question marks at the end of it. Government must be a watchdog. It's our duty. It's our duty to keep Canadians safe. You know, Mr. Speaker, in Canada, over a 5-year period from 2010 to 2015, the number of safety-related recalls increased by 74%. 74%, that's a large number. Rising from 133 recalls in 2010 to 232 recalls in 2015. While this is a large jump, Mr. Speaker, I do want to note that between 2010 and 2016, manufacturers, our automobile manufacturers in Canada, issued at least 318 recalls for which Transport Canada had not received any complaints. They did this on a voluntary basis. And I think I have to say thank you to the automobile industry, because that's a big cost to them without any force by government. But we know from what I just spoke a few minutes ago, that we need to still be watchdogs. Transport Canada, Mr. Speaker, only influenced about 9% of the recalls during this time. Clearly, Canadian manufacturers are looking out for the safety of our consumers, which is increasing challenges as the vehicles become more and more complex, Mr. Speaker. In 2015, 5 million passenger vehicles were recalled in Canada. In 2015, 5 million passenger vehicles were recalled. This was a consequence of increased caution by automakers and increasing vehicle complexity. Now, I said earlier, they did this on a volunteer basis, and I think we have to say thank you. But I think they also realized that internationally, whether it's the United States, Canada, Europe, France, we have regulations in place, and we are the watchdogs. So most of this is probably because there are watchdogs out there, and we need to be there. This act is needed, Mr. Speaker. I look back quite a few years ago, 1958. Some of you guys, and ladies and guys, may not have been here. I think you were here, Mr. Speaker. You might have been a young whippersnapper then, but I was here.
How to get your speech cut off short.
You know, when I look back, I've been a car buff since about the time I could read. I grew up with Tom McCall in Mechanics Illustrated, and I loved every article he read, and I think I read it for as many years as he wrote articles. But, you know, I think back 1958, Ford Motor Company, one of the largest manufacturers in the world, developed a beautiful car called an Edsel. What a flop. You know, it was ahead of its time. They come up with this bright idea to make a push-button automatic transmission in the steering column, and only about 50% of them worked for about 50% of the time. And Ford, in the wisdom, pulled that car after a 2-year run. Actually, they did slide it into 1960 by customizing a Ford car to look like an Edsel, but they got rid of the vehicle. Probably very wise. You know, and we look back over the years, GM trucks from 1974 to the mid-'86 were plagued by exploding fuel tanks. GM, in its wisdom, designed probably one of the, I think personally, one of the greatest trucks out there, the C10 and C15 GM and Chevy truck, but they put the fuel tanks on the outside of the frame rails because customers wanted 40 gallons and you couldn't get it on one side, so you put 20 gallons on each side of the frame rail. But guess what happened when you got hit? They exploded. I believe there's something like 600 Americans killed by explosions. Ongoing lawsuits today. The Corvair, was it a bad car? Yeah. Some people say it was, others loved them. Built from 1960 to 1959. Yeah, I'll guarantee you, the first 3 years, they handled terribly. The back wheels tucked under on a hard corner, and you could roll it. The Pinto, fuel tanks exploding. A lot of these vehicles today, including the GM truck, are still on the road today. They've never been corrected. This is why we need a strong act, like we are dealing with today, to protect us and Canadians. As I said earlier, more than 600 people have been killed because of inadequacies by manufacturers to follow through on defects on their vehicles. And there are still lawsuits going from vehicles manufactured in the 70s. Today, vehicles are complex, and they need to be identified. They need to have their defects identified as quickly as possible and be corrected as quickly as possible. I'm sure everyone is aware of those self-driving cars that are just beginning to hit the road. Some members here might also have one of those cars that parallel park itself. With the rise of smart technology, vehicles are quickly evolving and becoming much more highly integrated. In order to facilitate industry competitiveness, Mr. Speaker, Canada's regulatory regime needs to be more responsive to new emerging technologies, fuels and safety advances. And I don't even want to dwell into self-driving cars. I don't want to go there right now. This bill will allow the department to require manufacturers to provide more safety information and do testing when needed, as well as increase their flexibility to address ever-changing safety technologies. You know, last fall, Mr. Speaker, I bought a new Buick Enclave SUV. I drive about 40,000 kilometers a year in my riding. And it has all the bells and whistles. Even has this backup alert. Nice big camera on the dash. Tells you when you're backing up to see things. Second day I owned the car. I backed into my house. $1,000 damaged. It was a big hit, Mr. Speaker. I couldn't even claim it. But my wife was mad. I felt stupid.
Should have hit and run.
Yeah, thought of that. I admit, I was inadequate and not inclined to understand the technology of the new vehicles, Mr. Speaker. Now I know how it works. While it is important that Bill S2 protect the safety of consumers, it is also important to understand the implications of this bill on small businesses and local dealerships, ensuring that they are not negatively impacted by these changes. But what I'm saying here, Mr. Speaker, and I want you all to listen here, because I have to thank the Senate for changing this bill to protect dealerships across Canada, small business dealers, medium-sized business dealers, that were being stuck with cars that had recalls on them and they could not sell them. I had dealers in my riding that were stuck with vehicles for over 2 years waiting for repair parts so that they could put that vehicle back on the lot and sell it. They were paying the interest on those loans. That is unfair. That is wrong. This bill protects those dealers and puts that authority back on the manufacturer and importer of that vehicle to take care of that and to compensate dealers throughout Canada from coast to coast to coast. That is a big factor, and I thank the Senate for bringing that amendment in. This amendment makes the manufacturer entirely responsible for the cost of recalling of all repair vehicles. It will be a counterbalance to ensure the auto dealers are treated fairly as small business consumers of the manufacturers. How much time have we got, Mr. Speaker? 2 minutes? Good. As usual, there are more improvements that can be made. For example, manufacturers are concerned with some powers which can be seen as being too sweeping, such as ministers' ability to order tests. Now, therefore, I make one recommendation, is that we add the word reasonable in the Act so that the minister can ask that a test be done if there's reasonable grounds for that. And that is only fair. I want to stress, I've got a couple minutes left, Mr. Speaker, and I just want to stress on one point that I have had a number of calls in my riding, as I imagine a lot of other people. I'm a motorcycle fan, and I have a motorcycle, and I ride every day when I get the opportunity. This summer was not very good. But anyways, motorcycles, like automobiles, are manufactured to Canadian Motor Vehicle Safety Standards, United States Motor Vehicle Safety Standard, European Motor Vehicle Safety Standard. Yet, constantly, in this country and in the United States, dealers will take those bikes before they leave their showroom, modify them with loud exhaust, stuff like that, and then sell them to the unsuspecting public. And who suffers? The people living in residential areas, recreation areas, when guys go by with extremely loud exhaust. That's one area that I think that we can address, and I see one of my fellow riders has loud exhaust. Anyways, in closing, Mr. Speaker, I believe that this proposed legislation will strengthen the oversight on the recall process. It will be a big win for consumers and overall safety of Canadians. Thank you, Mr. Speaker.
If he wishes it, the honourable member for Yellowhead will have an additional 2.5 minutes for his remarks when the House next resumes debate on the question, and of course the usual 10 minutes for questions and comments. But now we'll go to statements by members, déclaration de député, and the honourable member for Humber River, Black Creek.
Thank you very much, Mr. Speaker. I rise today to acknowledge the leadership and service of Dr. Mahmoud Shoukry, President of York University, who completed his term on June 30th, 2017. For the last decade, Dr. Shoukry has guided York University through a period of extraordinary growth and change, cementing its position as one of our preeminent institutions of higher education in Canada. I would like to take this opportunity to acknowledge Dr. Rhonda Lenton, who has been appointed as York University's 8th President and Vice Chancellor, and began her post on July 1st, 2017. Thank you to Dr. Shoukry for his dedication to our community, and congratulations to Dr. Lenton. May I wish her all the best for her success and the success of York University. Thank you.
The honourable member for Edmonton West.
Thank you, Mr. Speaker. I would like to recognize an amazing constituent in my riding of Edmonton West. Kim Street, volunteer extraordinaire, has assisted over 50 community organizations and has helped raise over $4 million for in-need Edmonton schools. Whether it's stepping in and providing a hot lunch for schools that don't have a program, or gathering hundreds of auction items every year for St. Martha Catholic School, Kim, with the help of her tireless husband Jason, is an advocate for those in need of West Edmonton and throughout our city. Veterans associations, athletic clubs, community centers, and public schools across Edmonton have all benefited from her dedication to community service. Kim, your tremendous support of the communities in Edmonton should serve as an inspiration for people across Canada to get involved locally and help out. I urge all Canadians to take a page from Kim's book and volunteer their time for places in need. Kim, thank you for your outstanding service to Edmonton and for proving that one person can make a difference.
The Honourable Member for Lac Saint Louis.
Montreal's West Island has lost a true friend and stalwart. From the humblest beginnings, Nick DiTommaso rose through the ranks of Montreal's retail petroleum industry to become president of Ultramar Canada. Nick's energy and work ethic were legendary. After retiring from a stellar business career, Nick dedicated himself to strengthening Montreal's West Island community, in particular its health and social services sector. He served as chairman of the Lakeshore General Hospital and then of its foundation. He used both positions to bring major needed improvements to the hospital's facilities. Nick was also a founding member of the West Island Palliative Care Residence, a valued advisor to the West Island Association for the Intellectually Handicapped, and a fundraiser for their local women's shelter. These vital contributions were in addition to his myriad other volunteer causes and activities. The West Island is a better place today because of Nick DiTommaso. He left us a lasting legacy, and for that, our community is truly grateful.
Member for Kootenay, Columbia.
Mr. Speaker, earlier this month I attended meetings with the Cranbrook and Kimberley Chambers of Commerce to discuss the Finance Minister's proposed tax changes. Across my riding of Kootenay, Columbia, small business owners, farmers and professionals are all coming together to express their shock and outrage at being told that they're verging on being tax cheats and even struggling businesses will have to pay more. David Hull, Executive Director of the Cranbrook Chamber, said in a news release, "Nobody supports tax evasion or loopholes, but these changes will punish legitimate businesses." And one of my small business owners has offered to pay their own way to come to Ottawa to meet with the Finance Minister or the Prime Minister. That's how concerned he is. The people in my riding are asking the Liberal government to please extend the period for consultation, focus tax reform on closing stock option loopholes and stopping the use of offshore tax havens, and ensure they do not target hard-working small business owners who already feel betrayed by the Liberals for not cutting small business taxes. Thank you.
The Honourable Member for Avignon, L'Amitié, ce matin, le Matapédia. Mr. Speaker, Baie des Chaleurs in the Gaspé Peninsula had the 4th edition of an annual event. Many athletes representing several countries, including France, Uruguay, and South Africa, competed, especially in Carleton-sur-Mer. This was an exceptional ground for people who love to compete. Canada offers precious international visibility to Gaspé and to its natural beauty with the presence of many international journalists. The media attention was significant, and that means Gaspé Peninsula has become an exceptional location for tourism. I would like to highlight the exceptional work of the promoters of this event in the Gaspé Peninsula, Carleton-sur-Mer Management Company, and others. Thank you for calling attention to our beautiful region.
Member for Brantford-Brant.
Mr. Speaker, this summer, Brant MPP and Speaker of the Ontario Legislature, Dave Levac, a very good friend, and I commemorated the Canada 150 by recognizing 150 outstanding individuals from the communities of Brantford, Brant, Six Nations of the Grand River Territory, and the Mississaugas of the New Credit First Nation. Recipients were nominated by their fellow citizens in recognition and appreciation for their significant contributions to their communities, province, and country in the categories of agriculture, arts, culture and heritage, caregiving, community building, educators, entrepreneurs, faith in action, first responders, good neighbors, legions, ladies and youth auxiliaries, seniors, youth and students, service clubs, and sports and recreation. It is my sincere hope that recipients who received the awards know how truly grateful we are for their hard work, dedication, energy, and passion. Congratulations to you all.
The Honourable Member for Longueuil, Charlemagne. Mr. Speaker, last Sunday, more than 20,000 people participated in the 10th Annual Army Run. This event recognizes the service and sacrifice of all the brave men and women in uniform as well as their families. I had the honor of running with my family, many members of the Liberal caucus, including the member for Ottawa-Vanier,
the Parliamentary Secretary to the Minister of Foreign Affairs, the Parliamentary Secretary to the Minister of Infrastructure, and the Minister of National Defence.
Our government feels strongly about our commitment to support and celebrate members of the Canadian Armed Forces, and that is why, for the first time since the Army Run began, a Prime Minister joined us and ran with our troops. Ill and injured veterans lead the way in the Army Run every year, and I think I speak for all participants who also sit in this House when I say that for those few hot hours last Sunday, it was an honor to run in the footsteps of these true Canadian heroes. Thank you.
The Honourable Member for Coquitlam, Port Coquitlam.
Mr. Speaker, 37 years ago, Terry Fox ended his Marathon of Hope. On September 17th, along with runs in communities all across Canada, Port Coquitlam hosted the Terry Fox Hometown Run. 3,000 participants walked and even danced across the finish line. I am reminded of Terry's words. I am not a dreamer, and I'm not saying this will initiate any kind of definitive answer or cure to cancer, but I believe in miracles. I have to. Together, the Terry Fox Foundation has raised $800 million, and we still need a cure for cancer. I encourage all members in the House and all Canadians to stay involved. And thank you to all who ran and donated. We are still searching for Terry's miracle. The traveling exhibit, Terry Fox, Running to the Heart of Canada, is open in my riding and Terry's hometown, Port Coquitlam, until the end of November. Thank you, Mr. Speaker.
The Honourable Member for Brandon Souris.
Mr. Speaker, over the summer, the federal government quietly issued new regulations which decreed the credit unions can no longer allowed to use the words bank, banker, or banking. Well, Mr. Speaker, these terms have been part of the common vernacular for over a century. I've spoken to longtime credit union members who are irritated that the federal government can unilaterally make this change and waste millions of dollars. In fact, the administrative costs of the 300-plus credit unions across Canada to change and popularize other unknown terms and order new signs are estimated to be over $80 million. Crazy. In constituencies such as mine, the credit union is the only financial institution left in many rural communities. These are pillars in our communities and are one of the most philanthropic industries in the country. Instead of making business harder for these important institutions, we should be looking for ways to help ensure that credit unions can thrive and prosper. Here, here. I am calling on all members of this House to work together and fix this calamity and restore some common sense.
Here, here. The Honourable Member for Fleetwood Port Kells.
Mr. Speaker, I rise today to welcome the Canadian Urban Transit Association, CUTA, to Ottawa for their annual Transit Awareness Days. Our government knows that reliable and efficient public transit gets Canadians to work, to school, and home again after a long day. And we know that this is helping to grow our economy and delivering on the promise of strengthening the middle class. I know this personally from my many years with TransLink, Metro Vancouver's excellent transportation authority. We're proud to have worked with CUTA to design versatile infrastructure programs that are meeting the needs of Canadian communities and Canadians day to day. It's through these programs that we've now approved more than 1,000 public transit projects across Canada. Working with our partners like CUTA, we're investing in the strong, sustainable communities Canadians deserve, delivering on our historic infrastructure investment for Canadian families and their growing communities. Thank you, CUTA, for all the work you do, and welcome to Ottawa.
The Honourable Member for Davenport.
Mr. Speaker, on September 8th, shortly before midnight, the largest earthquake in 100 years struck the Pacific coast of Mexico. The magnitude of the earthquake registered at 8.2 on the Richter scale and was felt by approximately 50 million people across the country, as far away as Mexico City. The states of Chiapas and Oaxaca, home to 9 million Mexicans, were most affected. 98 people are confirmed dead, hundreds injured, and an estimated 2.5 million people in need of assistance. Our Prime Minister shared his condolences to the President of Mexico in the immediate aftermath of the earthquake. I know that I speak on behalf of all the members of this House and all Canadians when I say that our thoughts are with those injured and with those who lost loved ones in this deadly earthquake. Canadá es un gran amigo de México. Les deseamos mucha fuerza y fortaleza en los próximos días. Sabe que Canadá siempre estamos listos para ayudar. Muchísimas gracias. Thank you, Mr. Speaker.
Order, please. The honourable member for Flamborough-Glanbrook.
I'm sorry. Speaker, tragically, this past summer, we lost our beautiful daughter, Lara, at age 23. To members from both sides of this House who sent emails, cards, flowers, and attended the visitation and celebration of her life, please know that your thoughtfulness and support were a great comfort to Almut and I at a deep time of grief. On behalf of the entire Sweet family, a very sincere thank you to the entire House. Speaker, Lara's struggle with mental health began at birth and continued until she left this earth for a new life in heaven. In spite of her own battle, Lara reached out to an extraordinary number of young people with love, hope, and even resources, though her means were minimal. In doing so, Lara reframed my thinking on whether someone has to have it all together in order to assist others. Lara was the essence of the wounded healer. I ask all in the chamber to be mindful of those who struggle with mental health. I encourage the government to continue to adequately fund the Canadian Mental Health Commission and for all Canadians to use its tools in time of need. I encourage everyone to be generous to the Canadian Mental Health Association and others who are deeply committed to the fight for mental wholeness. To Lara, will be greatly missed by all of us. God bless you.
I know I speak for all members in offering our deepest sympathies to my friend, the honourable member for Flamborough-Glanbrook. The honourable member for Northwest Territories.
Mr. Speaker, yesterday in Yelton, I've had the honour of attending the swearing-in ceremony for Margaret Tom, the new Commissioner of the Northwest Territories. Ms. Tom, a proud Northerner, has been counsellor at Degas School in Fort Providence for the past 20 years. Mr. Speaker, I know this small community well because I also call Fort Providence my home. She has worked in counselling and education for most of her career, has volunteered her time, too many events to mention. Ms. Tom has demonstrated leadership with many organizations, including serving as a governor of the Aurora College Board, a member of the Territorial Board of Secondary Education, Keitra Hall Advisory Board, and Vice Chair of Nutsa JK Treatment Center. She is a recipient of the Queen's Diamond Jubilee Medal, a member of the NBT Education Hall of Fame, and has been awarded the NBT Territorial Wise Woman Award. I send her my most heartfelt congratulations, and I know she will do a wonderful job in her new role as Commissioner. Masicho, Mr. Speaker.
The honourable member for Skeena-Bulkley Valley.
Speaker, it seems this is a week of reflection and loss. I, too, rise with a heavy heart today to pay tribute to my very dear friend, Bruce Hill, who passed away yesterday morning. Surrounded by his loving family in Terrace, British Columbia, Bruce was a great bear of a man, fierce in his defense of the beautiful Northwest, but was at his most fearsome when defending the underdog. He was a great personal support for me, and that was most evident when he was giving me hell for not living up to his expectations in defending our home and its good people. He was a lover of life, great food, and even better, wine. He gathered around him a vast and eclectic assortment of friends and troublemakers. Whether leading the fight against devastating projects or working with his Heisler brother, Gerald Amos, to establish true reconciliation, this peaceful warrior was all love. I already feel his absence in my heart today. To his wonderful wife, Anne, to his two outstanding children, Aaron and Julia, today we mourn with you. Thank you very much.
Honourable Member for Caribou, Prince George.
Thank you, Mr. Speaker. I'd like to tell you all about the wildfires in British Columbia. It included the longest state of emergency in BC's history. It included the largest mass evacuation in BC's history. Thousands are still out of their homes. 1,262 wildfires have burnt over 1.2 million hectares. Over 53 million cubic meters of timber has been burnt. An area twice the size of Prince Edward Island has been scorched. Over 30,000 head of cattle are missing or lost altogether. To say the wildfires have taken its toll on our province would not be an understatement. They have been devastating in my riding of Caribou, Prince George. Families have lost everything. Some are simply not returning. Businesses are struggling to recover, and some are just simply closing the doors. Now is not the time for partisan politics, but the Prime Minister's Ministerial Committee has not met with the mayors, regional districts, MLAs, or the MPs, or those left behind to somehow pick up the pieces. Mr. Speaker, we may not be on the front page of the newspaper or the top headlines in the news stories anymore, but now is the time for action.
The honourable member for Cape Breton-Kensal.
Mr. Speaker, it is my profound honour today to rise and pay tribute to a true giant in Canadian politics. The Honourable Alan J. McEachern dedicated his life to the equality of citizenship, both under the law and with opportunity. He used his perilous parliamentary skills to turn the dreams of a progressive few into the reality to benefit all. A national health care program, old age security, guaranteed income supplement, and a national labour code are aspects of life in Canada that Alan J. helped build. As our Prime Minister said Sunday, this Canada existed only in the hopes of Canadians when Alan entered politics in 1953. By the time he left in 96, it was a fact of life. And although he shaped this country at the cabinet table, make no mistake, his view of this world was very much shaped back home at the kitchen table. I'm confident he is looking down on us here today in this place, encouraging us all to be better and to do better for all Canadians.
Oral questions, questions orales. The Honourable Leader of the Opposition.
Mr. Speaker, the Prime Minister likes to falsely repeat that his tax changes will not hurt the middle class. But hundreds of local business owners have said that that's simply not true. These changes will also hurt employees with layoffs and reduced working hours, and it will be harder for young people looking for their first job. Why is the Prime Minister saying that he's helping hurting the people he wants to help? Mr. Speaker, we now have a tax system that encourages the wealthiest Canadians to have private corporations so that they have a lower tax rate than the middle class. This is a significant challenge. We want to have a system where small businesses have the opportunity to invest in their active investments so that they can improve our economy and so that we can have a better situation for employees and for all Canadians. The Honourable Leader of the Opposition.
This morning, I visited Vimy Brewing Company, a startup business operated by Kevin and Michael, two brothers and former Navy reservists. They took a risk and left their jobs to start this new venture. But now they're worried that the Liberals are putting their operation in jeopardy by taxing away their future. Kevin and Michael are not rich. They are middle-class Canadians, exactly the kind of people the Prime Minister claims he wants to help. Why is the Prime Minister putting the future of Canadian job creators at risk with this increased tax hike?
Mr. Speaker, our system currently creates
an incentive for wealthy Canadians to incorporate so they can pay a lower rate of tax than middle-class Canadians. That's just not fair. I suspect that the member opposite is okay with wealthy Canadians paying a lower rate of tax than middle-class Canadians. We're not. What we're trying to make sure that we have is a system that encourages people to invest in their business so that our economy can be successful, so that all Canadians have a fair system.
Hear, hear.
Order. The Honourable Leader of the Opposition.
Speaker, 98% of businesses in Canada are small and local businesses. And we're not talking about the corporate elites at Morneau Chapelle. We're talking about the farmer who employs 5 people, or the family-run sporting goods store employing 20. Now, I know the Liberals might like to look down on these kinds of jobs, but these are the job creators who provide opportunities in our neighborhood. Can the Prime Minister explain how even one new job would be created by going after these job creators and local businesses?
The Honourable Minister of Finance.
What we're saying to Canadians is a system that encourages the wealthy to incorporate so they have advantages and a lower tax rate than the middle class is just not fair. What we want to have is a system that actually does encourage investment, and that's what we're going to have for those small businesses, the businesses that employ Canadians that want to employ more Canadians. They will have a fair tax system encouraging them to invest, which is what we need for a successful economy.
The Honourable Member for Richmond North Athabasca. Mr. Speaker, the Liberals are directly attacking our family businesses, our small businesses, and our farmers, people who work hard every single day. It's not by taxing them that will create more jobs here in Canada. In fact, it's quite the opposite. This improvised reform will cause job losses and will cause financial pain to local business owners. What will it take for the Prime Minister and his team to realize that they are endangering jobs all across Quebec and Canada? Honourable Minister of Finance. Mr. Speaker, as I've said, we don't want to have a system where the richest Canadians have advantages that aren't available to the middle class. We want to have a system where it's possible to make significant investments in your business. So we're listening to farmers, to small business owners. Yesterday, I got news from Terry, and I talked to him on the phone today to learn about his situation. I will continue to listen to ensure that we have a system that is fair, but also a system that provides advantages to the middle class. The Honourable Member for Richmond Athabasca. Mr. Speaker, here's the reality. For the last week, thousands of business owners have been telling us the same thing about the tax reforms. They're going to have to cut their operating budgets. They're going to have to cut their donations that they make to community organizations. They may even have to eliminate jobs because of the Prime Minister's tax hikes. Mr. Speaker, the Liberals are directly attacking our job creators. When will they finally understand that taxing more and more doesn't create more jobs? Honourable Minister of Finance. Mr. Speaker, a tax system that encourages the wealthiest Canadians to have private corporations and to have lower tax rates than the middle class doesn't work. That is the challenge we're facing. But it's very important that we listen so that we are certain that we properly understand how our proposals will help small businesses continue to invest. That's important, and that's why we're listening. The Honourable Member for Outremont.
Bilingualism bonus intended to encourage civil servants to learn both English and French has existed for 40 years. A Liberal report is now recommending that the federal government scrap this bonus. Does the Liberal government really plan to eliminate a bonus that helps to promote bilingualism in Canada's civil service?
The Honourable Minister of Fisheries.
Mr. Speaker, Canada's 2 official languages are obviously at the heart of our identity as a country and certainly at the heart of the way this government functions. We always believe, Mr. Speaker, that a bilingual public service better serves all Canadians. We respect the hardworking men and women in our public service, many of whom have learned their second language and continue to do so. And, Mr. Speaker, we will always do everything necessary to support Canada's two linguistic communities and ensure that these communities are reflected in Canada's public service at every level.
Honourable Member for Outremont.
The Minister of Fisheries didn't provide an answer that was really in line with the question because he didn't give me a clear answer. So I'll say again, the president of Impératif Français believes that this recommendation reflects an Anglophone vision of bilingualism. And the Union of Public Service Employees is skeptical too. We know that the Liberal government isn't used to consulting on this issue. They don't even have an official languages commissioner right now. But can they at least commit to consulting parliamentarians, linguistic minority groups, and unions about the bilingualism bonus before they scrap it? The Honourable Minister of Fisheries. Mr. Speaker, we are always interested in consulting public service unions and public servants and parliamentarians, of course. And we will consult vastly about the policy changes that may result from this. But, Mr. Speaker, know that our respect for linguistic communities and the ability of the Canadian Public Service to serve both linguistic communities will always be at the heart of everything we do. The Honourable Member for Outremont. Once again, that's not very reassuring when it comes to the bilingualism bonus. It's clear that Canada is moving toward legalization of marijuana, and the NDP supports this approach. But the Liberals have left massive flaws in their bill, and they're leaving the bulk of the work to the provinces. We know that Canadians are often turned away at the U.S. border when they admit to having smoked cannabis in the past. Well, everyone except the PM, even if they've never been convicted of the crime. What is the government doing to get an agreement with the Americans to ensure that Canadians will not be turned away from the U.S. for acts that will soon be legal in Canada?
The Minister of Public Safety.
Mr. Speaker, Canadians should have every expectation that when they approach the United States border, they will be treated in a consistent, fair, and respectful fashion. We have raised that expectation with our American counterparts, and they have every right to expect the same treatment in return. But it is exceedingly important to recognize, Mr. Speaker, that each sovereign country establishes the rules for themselves. We would not tolerate the Americans writing the rules for us, just as we would not purport to write the rules for them.
The Honourable Member for Outremont.
Today that he's never going to get turned back at the U.S. border, even though that he admitted smoking marijuana while he was a member of Parliament. We just want to make sure the same rule applies to all Canadians. Legalized marijuana will soon be a reality. It's a very important change, but we've got to get it right. The NDP supports this legalization, but the Liberals' bill will not legalize edible forms of cannabis, which is a far healthier option than smoking it. And the black market, of course, will continue to thrive under their new rules. If one of the key purposes is to eliminate the black market, why won't the Liberals fix this problem in their legislation?
Honourable Minister of Public Safety.
Mr. Speaker, we have worked extensively with all of the provinces and territories, as well as with municipalities and law enforcement across the country, to develop a comprehensive approach that will move Canada in a far more positive direction. That work is ongoing, including the full regulatory framework that will deal with cannabis in all of its forms. That work is ongoing. The objective is to keep cannabis out of the hands of children and to keep illegal profits out of the hands of organized crime, and we will make sure we have a regulatory regime that accomplishes that goal.
Order. The Honourable Member for Louis Saint-Laurent. Thank you, Mr. Speaker. Now, the Liberals have a voracious appetite for attacking business owners in Canada, and that's been there for a long time. Remember what the PM said 2 years ago when he was the candidate at the time. He said that a significant number of small businesses are just a way for the wealthiest Canadians to pay less tax. Mr. Speaker, maybe the Prime Minister was looking in the mirror when he said that. The reality is that for real small business owners in Canada, they are creating jobs for hundreds of thousands of Canadians. This is arrogance and contempt. Why is this government showing contempt for small business owners who create jobs? The Honourable Minister of Finance. Mr. Speaker, we will continue to state that under our current system, there is an incentive for wealthy Canadians to have a private corporation so that they can have a lower tax rate than the middle class. And this is a significant challenge. We are currently listening to Canadians to make sure that our measures are appropriate, because that's very important. But our goal is clear. We want to have a fair system. The Honourable Member for Louis Saint Laurent. Mr. Speaker, in real life, for real business owners, there are good years and bad years. That's why real business owners who know how to manage a business put some money aside, because sometimes they need that. They also put money aside for their pension. This is what the government doesn't understand. They don't understand that these business owners are responsible and prudent, unlike the government. Why is the government taxing business owners who are putting money aside? The Honourable Minister of Finance. Mr. Speaker, we thoroughly understand that our current system encourages wealthy people to have corporations so that they can have a lower tax rate than the middle class. This is very important. We also know that it's important for small businesses to have the opportunity to continue to make investments in their business. That will continue. That's the fact, that's the truth, and that is what we want for the future of our country.
The member for Lethbridge.
Thank you. I'm hearing from hundreds of people in my constituency who are very concerned with these tax hikes that the Liberals are imposing on Canadians. One woman who came to me, she owns a local clothing store, and she said that she's saving up in order to hire a business manager and go on maternity leave. She's hoping to start a family. However, these changes actually defeat her ability to be able to do that. So she's feeling quite discouraged. The Prime Minister calls himself a feminist. So why is it that he insists on attacking hard-working female entrepreneurs?
The Honourable Minister of Employment.
Mr. Speaker, we inherited a tax system from the Conservatives that encourages wealthier Canadians to incorporate and pay lower tax rates than middle-class Canadians. We don't think that's fair. We're going to fix it. Parental leave benefits apply to all self-employed Canadians. Doctors and other business owners are just as eligible as any other worker to participate in maternity and paternity provisions. Just because rules are legal doesn't mean they're fair. It's not fair when a budding entrepreneur who is a single mother with 2 young children has to pay a higher tax rate.
Order. Members need to not only listen to the questions, but also the answers. Order. The member for Kamloops, Thompson Caribou.
Mr. Speaker, Paula, a small business owner in Kamloops, has asked me to give an unequivocal message to this government. Your tax measures are ill-conceived, heavy-handed, and will have unintended consequences. She goes on to say she's got no guaranteed income, no pension, no employment insurance, no health plans, unlike perhaps some of the advantages that the Finance Minister might enjoy. Will the Minister stand up and justify why he is attacking Paula's future?
Yes, why? Well, Minister of Employment.
Mr. Speaker, our existing tax rules let the wealthiest Canadians pay less taxes than
Order. Order. The Honourable Member of Employment. Order.
Mr. Speaker, our existing tax rules let the wealthiest Canadians pay less taxes than millions of middle-class Canadian women and men. We inherited a tax system from the Conservatives that encourages wealthier Canadians to incorporate and pay a lower tax rate than middle-class Canadians. And just because these rules are legal doesn't make them fair. Everything this government does takes gender into account. Canada's economy depends on equity and fairness. We are focused on ensuring that Canadian women have the same opportunities as everyone else. Our economy depends on it.
The Honourable Member for Carleton.
Today, the Finance Minister announced that his deficit will be 80% larger than the $10 billion the Liberals promised in the last election. They're running out of money and coming after small business to pay for it. But Liberals have exempted big, publicly traded companies that are on the stock market from any of the tax increases. So millionaire owners of large multinationals will pay just 55%, while the corner store will pay 73% on investment income. How's that fair?
Honourable Minister of Finance.
Mr. Speaker, I want to say that I appreciate the context of the question. What actually the member opposite has identified is that we announced this morning in our annual financial report that we are $11 billion better off than we said we would do in budget. What we have, Mr. Speaker, is a situation where our economy is doing very, very well. We are growing better than we've grown in the last decade. We created almost 400,000 new jobs over the last year. More Canadians are employed, and we're looking towards a better future because of the investments we've made in our economy.
Order. The member for Carleton.
So to this finance minister, having a deficit 80% bigger than planned is the signal of success. The signal of success to Bombardier is that companies like them will be excluded from any of these tax increases because they're big enough to trade on the stock market. So the billionaire owners will pay only 55% on passive income held inside the corporation, while Stan Stewart, the roofer in my riding, will pay the new 73%. How is that fair?
The Minister of Finance.
Mr. Speaker, what we know is that over the last 15 years, we've seen wealthy Canadians take advantage of a system that allows them to incorporate so they can pay lower tax rates than middle-class Canadians. We don't see that that makes sense. I know the members opposite might feel that it's okay that wealthy Canadians pay a lower rate of tax, but we don't. And what we're looking to do is to make sure that our system works. That's why we're putting in measures that will actually make sure that our system encourages investment in active business, that encourages our economy to be successful over the long term, while making sure that our tax system is fair.
Order. I've asked the member for Brant privately here a number of times to try and calm himself. These are issues people feel strongly about, but we need to take our turns, speak when it's our turn and not when it's not. The
Honourable Member for Belleuil-Chambly. Mr. Speaker, the Privacy Commissioner is concerned that American customs officers are carrying out intrusive searches of Canadians and their electronic devices. An iPhone is not like a suitcase. Searching it gives you a direct view into a citizen's private life.
For once and for all that they will stand up for Canadians' rights at the border rather than playing right into President Trump's hands by giving more powers to American agents with bills like C-23 on Canadian soil. And let's not hear this talk about respecting the law, because the law is completely silent on this particular issue. Maybe we can get an update to that while we're at it to protect Canadians' privacy.
Honourable Minister of Public Safety.
Mr. Speaker, I hear most definitely the concerns of the Privacy Commissioner with respect to certain U.S. procedures. I also notice in the same report that he was far more positive about Canadian procedures and the work of the CBSA. This is an area where technology is emerging and changing all the time. And obviously, it's an area where we will have consultations and discussions with our American counterparts to ensure that the treatment of Canadians at the border is fair and professional and consistent and respectful of the rights that they have the right to.
Member for London Fanshawe.
Mr. Speaker, this afternoon, veterans and their families are gathering on the Hill to demand action on mefloquine, an anti-malarial drug with potentially severe side effects. CF members were ordered to take mefloquine as part of a botched drug trial, and the results have been tragic. Both Conservative and Liberal governments have long ignored the calls for an investigation, leaving veterans and their families suffering. Will the minister finally do something right and initiate a study to determine the long-term neurotoxicity of mefloquine?
Honourable Minister of Veterans Affairs.
Mr. Speaker, whatever the cause, we support veterans with service-related illnesses and injuries. Every situation is unique, and we work with each veteran on their individual circumstances. The health and well-being of our veterans is our top priority.
Member for Mégantic-L'Érable. Mr. Speaker, the Minister of Finance showed yesterday that his government simply doesn't understand the experience of Canadian farmers and producers. His proposed tax changes would sound the death knell for many of Canada's family farms. The minister said yesterday that he hoped to talk to farmers about his proposal. But that's the problem. Our farmers are out in the fields bringing in the harvest, Mr. Speaker. If he's really sincere, will the minister agree to extend the consultation period and listen to farmers who will tell him out loud that his reforms don't make any sense?
Honourable Minister of Agriculture.
Merci, Monsieur le President, and I can understand my honourable colleague. He's from a party that fully supports the encouragement of wealthy Canadians to form a tax system that means that they do not pay the rate of tax that the middle-class Canadians pay. So we're going to fix that. And along with it, I'm very proud to be able to say that we're in improving the grain transportation system, a very vital part of making sure that the agricultural sector prospers. We are going to work, we have worked with farmers, we're going to continue to work with farmers, and we will make sure that farmers prosper. Thank you very much, Mr. Speaker.
The Honourable Member for Mégantic-L'Érable. Mr. Speaker, several farmers tried to communicate with the Finance Minister yesterday, but you know what? His voicemail's full, and nobody's listening to the messages. But what particularly concerns me is what the Agriculture Minister said. In fact, he hasn't said anything to defend the farmers who will have to pay for the Liberal government's out-of-control spending. I'd like to know if the Minister agrees with the Prime Minister, who says that farmers and producers are rich citizens who are privileged and who are using their businesses to avoid paying taxes.
Minister of Agriculture.
Merci, Monsieur le President, and we inherited a tax system from the Harper government that encouraged wealthy Canadians to incorporate and make sure that they paid less taxes than the middle class. We think that's unfair, Mr. Speaker. But I'm certainly very proud of being part of a government that invested $100 million in science research in the agricultural sector. We have and will continue to invest in the agricultural sector to make sure they're competitive worldwide. Thank you, Mr. Speaker.
Order. The Honourable Member for Foothills.
Mr. Speaker, the Liberals believe that it's only wealthy folks in gated communities who are going to be impacted by these punitive tax changes. Canadian farm families do not live in gated communities, and they will be impacted by these tax changes. Of course, the Finance Minister would know that if he picked up the phone and returned the calls like he promised to yesterday. Mr. Speaker, will the Prime Minister commit today to extend the deadline on these consultations past October 2nd so the Finance Minister can keep his promise and call our farmers back?
Honourable Minister of Finance.
Speaker, as I said, we want to work to make sure that we have a fair system. We want to make sure that we have a system that doesn't encourage wealthy Canadians to incorporate so they can pay a lower rate of tax than the middle class. That's really important. I assume the members opposite don't want a system where the wealthy few can pay a lower rate of tax than the middle class. That's what we're going for. I will continue to listen to Canadians. When I heard yesterday of a gentleman named Terry, I called him today. I haven't yet had the phone number for Nicole, but I'd be happy to call her too. What I'm trying to do is to listen to people across the country to make sure that our measures have the intended consequences and that we move forward with an economy that works for all Canadians.
Order. The member for Battle River Crowfoot.
Thank you, Mr. Speaker. Jake Vermeer owns a dairy farm in my riding. Jake has told me that these massive tax increases that the Finance Minister is threatening to impose on all Canadians will damage this successful farm and cost jobs. Farmers often mortgage their homes, their home quarter, their land, in order to expand, innovate, and create jobs for the local rural community. Why is this Liberal Finance Minister treating these farms as nothing more than cash cows and jeopardizing the future of farmers in Canada?
Honourable Minister of Agriculture.
Mr. Speaker, I can understand my honourable colleague from a party that supports that people can incorporate and pay less tax than the middle class. And the fact is, we as a government feel that's not fair. We're going to fix that. But also for the dairy farmer, my honourable colleague must be fully aware, we invested $350 million to make sure that the agricultural sector is on the cutting edge. $100 million for the processing sector and $250 million for the dairy farmers. It's obvious, Mr. Speaker, my honourable colleagues do not want to hear this, but we have worked and will continue to work with the agricultural sector.
The honourable member for Laurier-St. Marie. Mr. Speaker, tomorrow the nuclear weapons ban treaty opens for signature at the UN. Over 120 countries have approved the treaty, but not Canada. Tomorrow, also on Parliament Hill, a giant treaty will be unveiled and open for signature by all who believe in nuclear disarmament. My question for the Prime Minister and all Liberals is, will you join the thousands of people from all over Canada who will be signing the nuclear weapon ban treaty tomorrow? I'd like to remind the honourable member to always direct her comments through the Speaker, the Honourable Parliamentary Secretary. Thank you very much, Mr. Speaker. Our goal is certainly nuclear disarmament, and we are taking the necessary steps to achieve that. That means working hard to deliver something tangible, and in 2016, for the first time, Canada rallied 159 countries to support the passage of a resolution on the dissolution of fissile materials, a treaty in that regard. That's a huge step forward for nuclear and nuclear countries. That's a concrete step.
Today, Immigration Canada still rejects permanent residency of family members based on them having a disability. The minister has admitted this practice is, quote, outdated and out of step with what Canadians expect. The Liberals have been reviewing this issue for 2 years, and last week the minister met with the provinces, but still no action. In the meantime, the future of families like Mercedes Benitez hangs in the balance. Will the minister stop discriminating against children with disabilities and scrap this outdated provision?
The Honourable Parliamentary Secretary to the Minister of Immigration. Thank you, Mr. Speaker. I understand the concerns raised by families confronted with this situation, and we are proceeding with an in-depth review of the situation by consulting the provinces and territories, because this comes under their jurisdiction. The minister recently raised this question at a meeting with federal, provincial, and territorial ministers, and our goal is to strike a balance between welcoming new Canadians while protecting our social services and public health care. Thank you very much, Mr. Speaker.
Mr. Speaker, I was proud last month when the government announced it was moving forward with dissolving the old colonial vestige of the Department of Indian Affairs and is in the process of working in partnership to create 2 new departments. One focused on moving the relationship with Indigenous peoples to one based on recognition of rights, respect, and cooperation, and another department focused on improving current service delivery to Indigenous peoples. Recent comments by a member of the Conservative caucus has caused outrage. Can the Minister of Crown and Indigenous Relations and Northern Affairs comment on the impact these comments will have on the efforts of all Canadians towards reconciliation?
The Honourable Minister.
Mr. Speaker, the Senator's ongoing offensive comments regarding Indigenous people are ill-informed, hurtful, and simply wrong. These disturbing views expressed by a sitting parliamentarian undermine progress towards reconciliation. Her removal from the Senate's Aboriginal Committee was the right thing to do. If the Conservative leadership want to demonstrate their commitment to reconciliation, they should remove the Senator from their caucus.
Mr. Speaker, Canadians entrepreneurs work hard and want to ensure that their children have a better life than they did. These new tax changes will hurt these Canadians. The Prime Minister's intentions are clear. He wants to make local businesses pay more taxes to fund his out-of-control spending. This isn't fair. When will the Liberals stop their attacks on small business owners?
Honourable Minister of Finance.
Speaker, we know that the party opposite was fine with tax advantages that encouraged the wealthy few to incorporate, so they got lower tax rates than middle-class Canadians. We're trying to make sure the system is fair because we just don't think that works. What we're going to make sure is that Canadians can continue to invest in a small business, continue to invest in that active business to create jobs and to create economic activity. But what we're not going to do is continue with a system that encourages the wealthy few to incorporate at a rate that's lower than the middle class.
Here, here. Barry Springwater Oro-Medonte.
Mr. Speaker, the Prime Minister appointed himself the Minister of Youth. He promised to reduce payroll taxes on youth and small businesses, but he hasn't. He promised to create 40,000 new jobs for youth, but he's lost over 18,000 jobs for youth to date. His proposed new taxes will only increase the number of young people in their parents' basements looking for work. Mr. Speaker, when will the Prime Minister find a mirror, look his Minister of Youth in the eyes, and fire him?
Honourable Parliamentary Secretary for Youth.
Mr. Speaker, we're very proud of the investments that we've made in young Canadians, particularly after 10 years of inaction from the previous government. First and foremost, Mr. Speaker, we doubled the number of summer jobs from 35,000 to roughly 70,000. Following that, Mr. Speaker, we ensured that we're ensuring that young Canadians have the funding to be able to go to university and get the education you need to find the jobs that they're looking for. Most recently, Mr. Speaker, we're very proud of the fact that we invested to ensure that there's 60,000 new co-op placements to ensure that young Canadians have the experience, on-hand training experience they need to get the jobs they want. We're proud of the investments. We're going to continue to invest in young Canadians.
Honourable Member for Central Okanagan, Similkameen Nicollet.
Mr. Speaker, first they promised to lower taxes for small businesses, and then they broke that promise. Shameful. Now, with their latest small business tax grab scheme, Liberals are attacking some of the hardest working people in the country. Now, rather than focusing on expanding, investing, or hiring, local businesses are fearful. And without sufficient details on this tax grab, Mr. Speaker, it'll only get worse. My question is to the Minister of Small Business and Tourism, whose job it is to help create an environment where entrepreneurs can invest, hire, and grow. Is she proud of her government's ham-fisted approach and the fear that it's caused in our business community?
Here, here. Honourable Minister of Finance.
I want to be clear. What we're putting forward are measures that are going to make sure that we don't have a system that encourages the wealthiest to incorporate so they have a lower tax rate than the middle class. We know that's important. What we're going to also continue to do is to grow our economy. That's exactly what we're achieving through the measures of investing in our economy. Creating a system that's fair, that allows the middle class to thrive, helps all of us. And that's what we're looking forward to in our economy in the future.
The Honourable Member for Central Okanagan, Similkameen Nicollet.
Mr. Speaker, entrepreneurs need to hear that they are valued and desperately needed in this country. Small business needs a champion inside cabinet, and if the Minister of Small Business and Tourism can't even rise in this place to speak to her government's record, Mr. Speaker, she could choose to be that voice in cabinet. Now, Perrin Beatty of the Canadian Chamber of Commerce has offered the government to sit down with local businesses in town halls across the country and really hear small business. Her colleague, the finance minister, just has refused to do so. How about it, Minister? Be the voice. Is she willing to meet with the chambers of commerce all across this country, or is she going to stay here in the Ottawa bubble?
Honourable Minister of Finance.
We want to make sure that we don't have a tax system that favours the wealthy over the middle class. What we know is that putting forward measures that will make a long-term difference is important. We also know that we need to listen, and that's why I am out. I was pleased to speak to the St. John's Chamber of Commerce last week. I'm looking forward this weekend to going to Fredericton to talk to the Canadian Chamber of Commerce to hear from them. We want to get these measures right. We want to continue to encourage investment in this country. We want to do it while making sure that our tax system is fair for everyone, especially the middle class.
The Honourable Member for Salaberry-sur-Roi. Mr. Speaker, Enbridge's Line 9B is a 40-year-old pipeline that crosses the Ottawa River and runs through Vaudreuil-Soulanges. Greenpeace, elected officials, and the public are very concerned. If the pipeline leaks in under 12 hours, 3 million people in the Montreal area will no longer have safe drinking water. Will the government require Enbridge to make its pipelines safer and share its emergency plans for protecting our sources of drinking water before approving any more energy projects in this region?
Mr. Speaker, the health and safety of Canadians is of primary interest to the Government of Canada. It's one of the reasons that we passed the Pipeline Safety Act, which introduced a whole new set of measures talking about insurance liabilities and talking about the necessity of cleanups in a timely way, talks about who's responsible, and in any approval of any major infrastructure project in the country, the safety and the well-being of Canadians is at the very top of our list.
Member for Port Moody, Coquitlam.
Last month, an open net salmon farm in Washington State released as many as 300,000 Atlantic salmon into the Pacific. Local First Nations immediately declared a state of emergency. Washington State immediately imposed a moratorium on new salmon farms. But our federal fisheries minister chose to stand by and, quote, monitor the situation. What will it take for this minister to protect West Coast wild salmon and transition these dangerous salmon farms to safe land-based closed containment?
Minister of Fisheries.
Mr. Speaker, I was in British Columbia 2 weeks ago, had the privilege to discuss with my new counterpart in the provincial government of British Columbia this important issue. We share the concern of all British Columbians with respect to the escape that took place in the United States. We obviously are working with American authorities to understand exactly how that happened and understand what, if any, impact it'll have in Canadian rivers. But, Mr. Speaker, I can say to all Canadians that my colleagues from British Columbia, and in fact all British Columbians, have made it clear to this government that they want us to do everything possible to ensure that aquaculture can be done safely, and we're open to all options to ensure that this can be done.
The honourable member for Caribou, Prince George.
Mr. Speaker, fishermen are the lifeblood of our rural and remote coastal communities in Atlantic Canada. They work hard, they create jobs, and they pay their taxes. After they pay for the repairs of their vessels and gear, pay their employees' taxes and other expenses, what little is left is put away for someday, perhaps, a modest retirement. When the minister makes changes that crush the dreams of fishermen's retirement, there's nothing fair about that. Why can't this minister see that?
Honourable Minister of Fisheries.
Mr. Speaker, I have the privilege on many occasions, including this morning, to meet with fishermen, for example, from southwest Nova Scotia with my colleague, the Member of Parliament for that area. And I can tell the honourable member that the fishermen that we talk to want to earn their living in a responsible, sustainable way. They understand, Mr. Speaker, the importance of middle-class Canadians having the appropriate tax structure so they can continue to thrive and support their families. So, Mr. Speaker, we will always work to ensure that middle-class Canadians benefit from a tax regime that's fair for them. And if the wealthiest amongst us have to pay a bit more, that's understandable.
The honourable member for Lakeland.
Mr. Speaker, the Canadian Federation of Independent Business says Atlantic Canadians, like my relatives, feel tax pain more than most, and that the combined tax burden is one of the biggest challenges in the region. Right. Small business owners there have, quote, significant anxiety about the Liberals' tax plans. Yeah. Hard-working, risk-taking, job-creating Canadians who don't have a family fortune to fall back on, like the PM, will suffer from this Liberal cash grab. Will the finance minister explain to middle-class fishermen, private contractors, small business owners, why he wants to make things so much harder for them?
Honourable Minister of Economic Development.
Mr. Speaker, as the minister responsible for HoC, we work very closely with all the communities in Atlantic Canada to create economic opportunities and economic development opportunities for small and medium-sized enterprises. Through HoC, for example, and our involvement as a government, we worked with Riverside Lobster to help create 40 jobs for West Nova. And in Egmont, with IO Solutions, we helped create 100 jobs, Mr. Speaker. That is why since 2015, there's been over 400,000 jobs created in the Canadian economy. That is our #1 priority, helping small and medium-sized enterprises create good quality, resilient jobs across Canada.
Now, a member for Beauport, Côte-de-Beaupré, Île d'Orléans, Charlevoix. A new session of Parliament begins and the government goes right back on the charge with new taxes. I believe profoundly that the coming changes will discourage entrepreneurship and hurt those we want to help. Those are the words of a Liberal member who, like most Canadians, fears the new Liberal taxes will have adverse consequences for small business in the Atlantic region and for the future of the fisheries. Is the Prime Minister imposing this new tax to pay for his massive deficit or to budget for his next vacation? The Honourable Minister of Finance. Mr. Speaker, we are considering how we can change our system to make it fairer. We currently have a tax system which encourages the wealthy to set up a private corporation to pay lower taxes than the middle class. That's unacceptable. So we are listening. We're all over the country. I'm listening constantly to make sure that our system is fair and that companies can continue to invest in their active business. The Honourable Member for Montarville. Mr. Speaker, a resident in my riding, my residents, my constituents are fully aware of the benefits of these changes, and we're very interested in the progress our government has made. Canada's, in light of the strong economic growth and evidence that our plan for the middle class is working, can the Minister of Finance update us on our fiscal situation? The Honourable Minister of Finance.
Monsieur le Président.
Mr. Speaker, our economy is working. We're in a great situation. Today we announced our fiscal situation. We have a higher growth rate, the highest in a decade. Almost 400,000 new jobs have been created in the past year. This is a great situation. We are continuing with our investments in our economy because it's very important. But right now, there are more families with jobs. There are more opportunities for all across the country with this growth rate. Thank you, Mr. Speaker.
Mr. Speaker, small business is the lifeblood of the tourism industry and of Canada. And campground owners and many other small business owners just like them are amongst the hardest working Canadians. And the Minister of Small Business and Tourism is simply cheerleading while her government destroys their businesses with huge new tax bills. So why has this minister stood by as family-run campgrounds are taxed for being too small to be a small business? And why isn't she standing up against this tax hike on all small businesses that will lay waste not only to the tourism industry, but to all of the Canadian economy?
Honourable Minister of Small Business.
And to remind all Canadians that our tourism industry is doing better than ever. And they have a champion at the cabinet table because this Prime Minister and this government takes the tourism industry, takes small businesses seriously. Not only are they the backbone of the economy, they are the very people that we will continue to fight for. This year, it was Canada's 150th of Confederation. We saw record numbers. 2018 will be the year of Canada-China tourism, and we expect to increase those numbers. The tourism industry is booming. This government will continue to support them, and the tourism industry is the #1 employer of youth, and we are proud of their record. Thank you, Mr. Speaker.
The Honourable Member for Drummond. Mr. Speaker, this government is endangering the environment in the Drummond area with its disastrous management of toxic substances. 9,000 tons of toxic substances in my riding. Quebec has just served notices of violation on the Liberal government and is threatening to sue for putting highly contaminated soils in an unauthorized place. The Drummond area deserves to have its residents' health and environment protected. Is the Liberal government going to stand up and respect environmental legislation? The Honourable Parliamentary Secretary to the Environment Minister.
On this side of the House, take the protection of the environment very seriously. Issues such as contaminated sites are addressed through the Canadian Environmental Protection Act. We work hard to ensure that we are addressing those in a thoughtful way, and we engage with governments, including the Government of Quebec, to discuss issues as they arise.
Surrey Centre.
The situation in Myanmar is devastating. The Rohingya people are suffering the sort of violence and horrors that should be relegated to our history books. Thousands of women, children have been attacked, killed, and forced out of their homes. Will the Parliamentary Secretary to Foreign Affairs update this House on what actions Canada is taking to prevent these horrible acts against the Rohingya people?
Honourable Parliamentary Secretary.
Mr. Speaker, I would like to thank the member for Surrey Centre for his question. Our government is seized by the unacceptable persecution of the Rohingyas in Myanmar and is actively engaged on this file. The Prime Minister and Foreign Minister have raised this at the highest level, including with Aung San Suu Kyi and Kofi Annan. They will both continue to raise it this week at the UN General Assembly. We will continue to provide our humanitarian aid to the Rohingyas and call on the Myanmar government to allow access into Rakhine State to further assess the situation. This violence has been equated to ethnic cleansing, Mr. Speaker. This is unacceptable and must cease immediately.
Honourable Member for Calgary Rocky Ridge.
Well, thank you, Mr. Speaker. I've met with countless small business owners to discuss the Liberals' plans to raise their taxes. Most of the people I've met have a small family-owned business. Some have mortgaged their family's home and taken huge risks that they share with their spouses, and they contribute everything they have to the success of their dreams. They wanted to know how the minister intends to have bureaucrats determine the reasonableness of how they share income from the family business. When did it become the minister's job to tell families which spouse should receive what benefit for the risk that a family-owned business shares?
Honourable Minister of Finance.
Mr. Speaker, the challenge we have is that our system currently favors the wealthy. It allows them to incorporate so that they can actually pay a lower tax rate than the middle class. What we need to do is we need to continue to make sure that our system is fair. We are going to listen to small business owners. We're going to listen to people across the country to make sure we hear their comments. These measures are intended to make sure the system is fair, intended to make sure that everyone has opportunities. And as we listen to people, we will make sure that we take their issues and their ideas into account. But be clear, we want to move forward to make sure that our system is fair for the middle class and for all Canadians for the future.
The honourable member for Pierre Boucher, Les Patriotes Verchères. Mr. Speaker, the Catalan people have elected a majority pro-independence government, and their elected officials have every right to consult their people on their future. Canada must decide now whether to respect the right to vote or to support the Spanish government's aggressive crackdown. Over 70% of Catalans in both camps want to vote, and it's up to them to decide if they want to remain part of Spain. Is the Prime Minister going to call on the UN to respect Catalonia's right to self-determination and democracy? The Honourable Parliamentary Secretary to the Minister of Foreign Affairs. Thank you, Mr. Speaker. As the Minister said yesterday, Canada highly appreciates its friendly relations with Spain, a democratic and united Spain. The question of Catalonia is a domestic matter for Spain to resolve. We hope that the debate will be harmonious and respectful within the constitutional framework of Spain. The Honourable Member for Repentigny. Mr. Speaker, we asked the Heritage Minister yesterday to charge the GST on Netflix and Spotify just like everybody else. Her reply, we do not feel that a new tax is the solution for supporting our creators. Since this GST exemption is preferential treatment compared to other cultural creators, can the Minister, in the spirit of fairness, undertake to do away the GST for all cultural products, because either she's granting the U.S. internet giants preferential exemptions or she's against the GST on cultural products. The Honourable Heritage Minister. Mr. Speaker, we invested $1.9 billion in arts and culture, the largest investment in a long time, the only G7 country to have invested so heavily. We've decided to launch a broad consultation and conversation on how to support the arts and culture in the digital era. I would invite my colleague on September 28th to take part in my presentation of our vision for this industry. Thank you. The honourable member for Rivière-du-Nord is standing on a point of order. I'm not sure the earpieces are working on the other side of the House because the answers have nothing to do with the questions.
Orders of the day.
Government orders, government of the Senate.
Alors, l'honorable député.
The honourable member is rising on a point of order.
Mr. Speaker, I have a request for unanimous consent to table the following motion that the House of Commons note that the Catalonian government has chosen to hold a referendum on the independence of Catalonia on October 1st, 2017, and consequently the House of Commons that the right to vote be respected. Does the member have the unanimous consent to propose the motion? No, there is no unanimous consent.
Government orders. Projet de loi émanant du gouvernement Sénat. Reprise du débat des cartes de la deuxième.
Resuming debate on second reading of S2, Strengthening Motor Vehicle Safety for Canadians Act.
Okay, so Jim McGlinskey maintenant. Allowed order. I'd ask honorable colleagues to take their conversations, which are, I think, very important, out into the lobbies so that we can carry on with the business of the House. And I'd ask colleagues to assist me by saying shh. Thank colleagues for their assistance. And now the honourable member for Yellowhead has 2.5 minutes remaining in debate, followed by questions and comments. The honourable member for Yellowhead.
Thank you, Mr. Speaker. 2.5 minutes. I don't have my speech with me, but that's okay. It was borrowed from me right after the last session. But anyways, Mr. Speaker, I was part of my speech dealt with some of the early history of motor vehicle regulations regarding the safety of motor vehicles. And I want to go back to Ralph Nader. Ralph Nader did a lot for North America, a lot for Americans, a lot for Canadians, in forcing the government of the United States to strengthen the way it set its rules and regulations in the manufacturing of vehicles in North America. And of course, because of that, and because of our bilateral trade agreements, we buy the same vehicles that the United States builds. We build a lot of the components that are used in the vehicles that are sold in the States and vice versa. And what Ralph Nader did, and the Nader's Raiders, was that they forced government to do, back in the 60s, what we are doing today, strengthening the motor vehicle safety acts across North America and across this country to make the vehicles that we purchase as consumers in Canada, whether they're made here in Canada, they're made in the United States, or made in European countries, we are buying vehicles that are much safer, and we are protecting Canadians. And that is very important. And I have to say thank you to Ralph Nader and the Nader Raiders. It's getting hard to say, but they did a job. They led the way, and we now, as a government, the people of Canada, must lead the way and make sure that the new Act, S2, is a good act and it protects Canadians in the purchasing of motor vehicles. And I spoke a little bit right towards the end of my speech, Mr. Speaker. You weren't here, but I talked about the motorcycle industry, and you missed that. But I spoke about the motorcycle industry and how as the sellers, the dealers for motorcycles across Canada, modify motorcycles that are built to Canadian safety standards. Then they modify them before they sell them. And this is one thing the Act needs to look at and needs to enforce. And I hope that as we go along, and as this Parliament follows this Act, S2, that we continually change it to meet the changing times and the needs of new technology that are coming into the motor vehicle industry. I think I'm supposed to stop because you're standing, so I will stop.
The honourable member is an experienced member, but perhaps he didn't quite realize that the rule against noting the presence or the absence of a member does include the Speaker. Who is often in meetings, as he knows. Questions and comments? The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I thank my honourable friend from Yellowhead for his speech, which mostly preceded question period. And I'm really pleased, I think in the debate today on S2, he's the first member to reference the Volkswagen fraud case. If there was another, I apologize. But I think that is worth noting. And I wonder, as I look at the legislation, it certainly should apply not just to human safety issues, but to fraud that involves allowing polluting vehicles to pollute while their online report system tells the owner of the car that they're not polluting. So I'll ask my honourable friend from Yellowhead, in the spirit of his friend, his hero Ralph Nader and Nader's Raiders, whom he mentioned a few times, does he think S2 will go far enough to protect us if a vehicle manufacturer defaults on environmental safety as opposed to vehicular safety as it's commonly understood?
The member for Yellowhead.
Thank you, Mr. Speaker. And I thank the honourable member for that question. I believe that S2 will strengthen our ability as a government. Are they having problems there, Mr. Speaker, that I might be able to help them? No? All right. S2 will definitely strengthen the ability of the Canadian government to deal with corporations such as the 2015 fiasco with Volkswagen. Now, is it strong enough? No, I think we could have been stronger in some of the legislation. And that's why I said in my last couple moments of the speech that we need to continually upgrade S2 and whatever we're going to call it after that, Mr. Speaker, so that we stay up to date with the current change in technologies. Anybody defrauding the public in their vehicles should be dealt with severely, quickly, and it should hurt them in their pocketbooks. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Medicine. The honourable Parliamentary Secretary of the Government House Leader.
Yes, thank you, Mr. Speaker. And I enjoyed the member's speech as he was talking about the importance of our manufacturers and companies. And it does need to be acknowledged. You know, those big manufacturers and the thousands of jobs and opportunities that they have provided Canada's middle class over the years has simply been overwhelming, feeding our manufacturing industry second to no other industry for many, many years, and the way in which they're getting engaged in technology and so forth. This legislation that we're talking about today is all about making our streets and roads safer by looking at the obligations that manufacturers and companies have at ensuring that the product that they have and they're selling is in fact safe for our roads and our streets. And the member across the way seems to agree with the legislation, and we look forward to the Conservatives supporting it ultimately going into committee. But my question to the member would be more of an affirmation than anything else, recognizing, yes, our manufacturers and companies have played such an important role, but there is important for us also to recognize that the Government of Canada does need to step up, make sure that we're harmonizing with the USA and the laws that they have, and we are in fact moving forward at one step at a time, ensuring that our roads and streets across our country are in fact better because of legislation of this nature. Would he member not agree?
For Yellowhead.
Thank you, Mr. Speaker. I'd like to thank the honourable member for that question. That's an excellent question, and the one that I guess right off the bat I can say yes, but I want to add to that. You know, S2 is a modernizing of our Safety Act, and it's very important, as I said a number of times. We need to keep it up to date. And I think that we need to give credit when credit is due, and we have to look at the statistical data on what our motor vehicle manufacturers in Canada, and I think North America too, what they have done to ensure that they have made their vehicles as safe as possible. Go back 20, 30 years, that was not the case. Today it's the case, and the case is because we have strong legislation, and we are proposing stronger legislation, and we always need strong legislation to ensure that they comply, and they comply willingly, and they will, because if there's financial losses to them because they do not comply, they'll keep their eye on what they're doing. But I think we have to look at it further. S2 is the start. We're going through an era now where we have people across the United States manufacturing vehicles that are driverless. Vehicles from small recreational vehicles to large transport trucks. They all have these vehicles so they can drive themselves. And they're going to tear all over the country one of these days. We'll probably all see it in this house, that they'll be driving across Canada with no one behind the wheel. God forsake, I hope that doesn't happen. But it's coming. They tell us it's coming. Mercedes-Benz has a large class commercial truck that can drive itself. We all know the electric car in the United States can drive itself very well. What are we going to do? They're taking over, Mr. Speaker. They're taking over. We've got to be careful. But we also need, as a federal government, we need to work and we need to encourage that the manufacturers keep us in tune of their new technical achievements. We need to work, and we need to start today, Mr. Speaker, to work with the provinces and the legislators, the people looking after our roads and streets, because we've got to get prepared for those driverless vehicles. And the only way they're going to drive is by electronics. And we need to get our act together. We need to start today. We need to start today to get those rules into place. Thank you, Mr. Speaker.
It's the honourable member for Windsor West.
Thank you, Mr. Speaker. And autonomous vehicles are already being tested in Canada, but my question is quite simple to the member with regards to the Toyota recall scandal that took place not only just here in Canada, but also the United States. At the end of that process, the United States received investment and services from the recall where Canada did not get anything under his government. What were the reasons for that? Why did the United States get millions of dollars for new auto development, consumer protections, including pickup, delivery, and return of a vehicle, and investment in communities? Why did his government get zero?
Yellow head.
I'm not exactly sure how the member was phrasing this, but I would believe that the United States probably got financial reward from Toyota because their Motor Vehicle Safety Act probably had a section in there very similar to what the current government is trying to do with S2, where the Minister of Transportation can levy fines against major corporations for such things. It was not in our act before. I do not believe we had the ability to go after it as the United States did. This is one thing that makes S2 very good, and one reason I support it. Thank you, Mr. Speaker.
Cardston Warner.
Thank you, Mr. Speaker, and I appreciate the wisdom of my learned friend and colleague on being able to see into the future what the Canadian automotive sector might be facing. And I have one question for him, and I'm just wondering whether he believes that this legislation strikes the appropriate balance between protecting Canadian drivers and the consumer.
Yellowhead.
Thank you, Mr. Speaker. Thank you to my honourable friend. I believe that S2 could go further. I think, and I said it just earlier, I believe that we need to really look at what's coming down the road. And it's coming so fast that we need to get the legislation in place. We need to look at S2. It's got the right ingredients. It strengthens some of our authorities, which is very necessary. But it's not going far enough, Mr. Speaker. And I think to go far enough, we need to look at the future. We need to get those regulations in place now. We need to protect the drivers. We need to protect the public. We need to protect the public and the drivers from the driverless vehicles. We've got to make sure everything is safe, so this all works together in harmony. Thank you, Mr. Speaker.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of Public Safety.
Thank you, Mr. Speaker. Mr. Speaker, 22 years ago, I walked into the basement of a campaign office, and I met Arnold Chan. I hate that I can say his name. I don't want to be able to do that in this place. Arnold instantly became one of my best friends. And anybody who knows him knows that his care and passion for all that he does and everyone that is around him is evident. I met him at a time that was particularly challenging in my life just because I was so scared. I was young, I was 20 years old. I had just found out that I was going to have a son. That son happens to be here today and actually worked for Arnold. And Arnold was that steady, calm voice in my life. At every dark moment in my life, he evened me out, and he made things okay. He was somebody I could pick up the phone and call and talk to, somebody who gave me advice, who was a mentor, somebody I looked up to. And in the years that we knew each other, we dreamed about this place and coming here. And when we were both elected at the same time, unfortunately, he had already had the cloud of illness. But we did get that opportunity to serve together. But when we talked, of course, we dreamt of all these things that we wanted to do together, and we were supposed to walk out those doors together, having done them. And although we're not going to get that chance, I did get a chance to talk to Arnold in those last days, and with his remarkable wife, Jean, and his phenomenal kids, Nathaniel, Ethan, and Theo, who were his life, that he talked about every moment I saw him, every day I saw here. That for him, when he came here, it was a way to make the world a better place for them. And at first, when he knew he was going to go, he wanted to give this speech that I'm about to read himself, but it became apparent that he wasn't going to be able to do it, and I wish that it was him. I can picture him sitting over my left shoulder right now, and I hate to look back and know he's not there. I just want to let you know how much he loved you, how much everything he did was to try to make a world a better place for you, and that in his final moments when he was talking about the issues that he cared about and worried about, yes, he cared about this house, but he mostly cared about this house for what a better world it could make and what a better world it could make for you. These are Arnold's last words to this House. Mr. Speaker, from the beginning of my parliamentary career, I have been preoccupied with the issues surrounding the exercise of democracy. This has been a passion of mine since my youth, and it is the touchstone for all of my work as a Member of Parliament of Canada. It is fitting that I address these issues once more today to my colleagues. My inaugural speech in Parliament focused on the themes of democracy. Since I rose in the House that day to discuss the private member's bill introduced by the member for Wellington Halton Hills to reform the Canada Elections Act and the Parliament of Canada Act, I had the opportunity in that speech to address what I felt were important elements of change that were needed in Parliament, which would hopefully help to reverse a trend of dysfunction that had been growing for far too long. On June the 11th of this year, I had the opportunity again to direct my comments to issues of democracy and the conduct of our business in Parliament. I wish that my children could have been present, but of course June is a time for examinations in school. Nonetheless, I had them and their generation very much in mind that day, and I do again now as I consider the critical challenges of the future and the role of democracy and democratic institutions in meeting those challenges. I believe that we as a society and a government are just beginning to grapple with three existential threats that will face my children's generation: climate change, accelerating technological change, and the social unrest that arises in reaction to these first two forces. Climate change is undeniably the focus of attention today, as it should be. The recent flooding in Texas, Hurricane in Caribbean and Florida, violent monsoon rains in Bangladesh and northern India, and closer to home, the BC wildfires, all point to an increasingly unpredictable and potentially destructive pattern of change to which everyone must adapt. This is, in part, why I continue to appreciate the presence and advocacy of the leader of the Green Party, the member for Saanich Gulf Islands, along with the leadership of the Minister of Environment and Climate Change. Their tireless work is to be commended and supported. Climate change is not just about storms, flooding, and heat. It is also about crop failure, food shortage, water scarcity, mass displacement of people, and violent conflicts that can arise out of these situations. It is imperative that we stop treating climate change as solely an environmental issue, but recognize it as an all-encompassing priority that we must, as a society and as a government, confront with utmost urgency. One important response to climate change is the focus on technological solutions, but technology itself represents a second challenge. In particular, the confluence of artificial intelligence, robotics, and genomics represents the potential for profound change to the relationship between people, machines, and their environment. There's been much discussion recently of the impact on human employment of self-driving cars and the increased use of robots from everything from manufacturing to personal services. This has led to speculation about the future of work itself and the possible dislocation of social relationships that have existed since the foundation of cities 10,000 years ago. These are issues that we just beginning to grapple with, but with which we will be profoundly important for my children and for their generation. In the face of relentless technological change and economic competition, how resilient will our social institutions be? How will our communities manage the potential for mass unemployment or even just fear those kinds of changes? Therein lies the third challenge, reactionism. In the face of climate change, accelerating technological advancements, and the disruptions they are causing, the tendency of people and communities to circle the wagons, and even worse, to fear the other. We have already seen evidence of this around the world. Increasing nationalism, religious fundamentalism, and isolationism, rising secular violence in many countries, distrust of elites, and strife based on economic class. So what do? We are members of Parliament, a body which is ultimately about civilized discussion and debate. The word Parliament itself derives from the French word parler, to speak. Our task is to exercise democracy through communication, deliberation, and ultimately decision-making, not in our interest, but in the interests of the people. We are representatives of, and we are responsible to the people of our country. And it is our responsibility and our duty to try to meet the challenge of the day through our best collective effort. In facing the challenges of climate change, accelerating technological change, and the forces of reactionism, we must remember that our greatest strengths lie within our civility to each other, our humanity in the face of our own limitations, and our own willingness to serve. We can adapt to change. We can respond to challenges, but we adapt and respond best when we do so after reasoned debate with an open mind and through listening carefully to the needs of those we are so fortunate to serve. But there is one more step in thinking about and managing the problems of the future, and that is to consider who the we of Parliament should be. Historically, our great Parliament has been predominantly comprised of men and largely of European descent. It was only in 2014, just 3 short years ago, that there was a Chinese Liberal MP named Arnold Chan in the GTA, an Asian male. On the issue of gender balance, despite it being nearly 100 years since the first woman was elected to Parliament, we are still far from balanced. Our government has taken some good steps to address this, but we can and should do more. We owe it to ourselves, our community, and our children to strive for improvement in our democratic institutions so that we can better serve our communities and better meet those challenges of the future. Diversity is healthy and increases the chances of survival and success, a truth known at least since Charles Darwin. The greater the range of ideas and opinions that are brought to bear on the problem of the day, the more likely we are as an institution to be able to come up with workable solutions that serve our communities. A greater diversity of members will in turn bring those broader ideas forward. Mr. Speaker, my call to action to my colleagues is to constantly to be open to new ideas, to be willing to adjust the assumptions that ground one's viewpoint, if the facts of the world and the challenge of the day requires it. I would also call upon greater empowerment of diverse voices as a foundation of addressing the challenges that face us. But my call is not only to my colleagues in Parliament, it is also to other Canadians of visible minority descent. We should not be satisfied with the status quo. We should expect more rather, for ourselves and our children. But at the same time, it is up to us to be braver, to go beyond our comfort zone and to engage with people of other backgrounds, to diversify and broaden our relationships, and to seek the betterment of all. We have to take a chance to engage and to participate. That will help strengthen the institutions that serve us. The triple challenges of climate change, accelerating technological change, and social reactionism are extraordinary and radical, and our ultimate response has to be as well. However, if we maintain our commitment to our democratic institutions and broaden and diversify our institutions to reflect the range of voices present in our society, I am confident that we can take the steps necessary to meet these challenges, to flourish one step at a time. Well, I wish I could be there for you and with you to contribute more to the great work of our Parliament and to the better world for my children and yours. I will have to leave this to you, my colleagues. I wish you well. Arnold Champ, I love you.
Questions and comments?
Thank you, Mr. Speaker, and I would just like to acknowledge the words from the member of Ajax and his heartfelt tribute and putting the last words of Mr. Chan on record in Hansard. And it's most appreciated, and I think I am confident to say that I know all members in this House, as well as family members of Mr. Chan's, join with me in thanking you for sharing your words in this place. Thank you.
Does the member wish to respond? The Honourable Parliamentary Secretary.
Just to say thank you. Arnold had such a profound respect for this place and for the members who serve here, and I know through the member that that those words would be very warmly received by Arnold's family who are with us here today. Thank you.
Questions and comments? The Honourable Member for Lanark, Frontenac, Kingston.
Thank you, Mr. Speaker. I thought on numerous occasions since learning of Arnold's passing of what the best way of summarizing him is in his role as a parliamentarian. And I think in some ways it's not that he stood out as being different from the rest of us, but rather that he best exemplified that which is or ought to be what we can bring forward in this place, that he was in many ways a personification of what ought to be the best in us, regardless of our partisan stripe. Notably, his remarkable ability to be nonpartisan in a very partisan place. And I just wanted to say the Prime Minister said the other day that he respectfully disagreed with Arnold's assessment that he was not going to make a lasting contribution. And the Prime Minister was right, of course, but I have to say that Arnold was right in the sense that he had the potential. He was a young man. He had the potential to make a difference in this country had he lived longer and had he had the chance to live out a full career lasting decades to have transform this place in a way that unfortunately is not possible, and we've all been robbed by that fact. So that's not a question, I guess, the honourable member. I feel a little envious that he knew Arnold for as long as he did. The rest of us didn't get the chance to develop that friendship, but I feel we've all been robbed by the fact that we could not in the future have had the chance to develop and learn from this extraordinary man.
The Honourable Parliamentary Secretary.
You know, in speaking to Arnold in the last couple of times that I spoke to him, there were a couple of things that he was really preoccupied with. And first and foremost was his family. And, you know, Arnold, no one was harder on himself than Arnold. And he was reflecting upon the work he did as a father. And, you know, you can never do a good enough job as a father. You can never feel that you did enough for your children. And I know that he felt that way about his boys, that he wished that he could have done so much more in their life. And that, of course, was his first and biggest concern, and his heart for Jean as well, who's been such a remarkable partner to him every step of this long journey, particularly as he went through the last and most challenging part. And lastly, the part that he lamented is that he didn't get to make the contribution that he wanted. And that weighed very heavily on him. And I think the honourable member is 1,000% correct. He's a better parliamentarian than I am or ever will be. He's somebody that I learn from every day. He's somebody whose guidance I sought in everything that I've ever done politically. He managed every E-Day I was ever in. You know, he's somebody who has been a bedrock of my life in so many ways. And I feel like the floor isn't under me some days, you know. And one of the hardest parts of trying to grapple with something like this is the injustice when there's somebody who's that remarkable, who had that much more to give. And, you know, that's when we talked about the speech, about the things that he really cared about and some of the things that he really wanted to persist in his legacy. And I think it's no small one that his love of this institution, this place, his belief in what it could accomplish, the belief in decorum and how we should treat one another and how we should engage in debate, that belief of the challenges that we face and the need for the institution to rise to the quality of that challenge is one that certainly, you know, I'll carry forward, and I know a lot of members will. Maybe we won't live up to it every day in this House, but, you know, it's something that I think it behooves us to remember, and I think he made a much bigger impact than he'll ever realize.
Questions and comments? The Honourable Member for Hamilton West. Sorry, the Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker. I was so moved by the letter, I didn't know if I should rise to say anything, but I thank the member for Ajax for reading it. What's striking about it is the power of analysis and the thoughtfulness of looking at the perils of climate change, technological change, and social reactionary trends, and analyzing that. At the same time, Arnold was aware that his time with us was running out, his thoughts turning to what we should do as a society, what we should do as a human family. And a brilliant mind wrote that letter, somebody who was fully engaged with the life of the human species as a family on this planet. And I will read it over again. I hope that all of us can, as we've said more than once recently, live up to the challenge he put before us. And I really do thank the member for Ajax, and I certainly will never rise on a point of order that it wasn't relevant to S2. It was about time we heard that letter. Thank you so much. And thank you, Mr. Speaker.
The Honourable Parliamentary Secretary.
Thank you to the member for Saanich Gulf Islands. I know that she was a good friend to the member, and I just want to say thank you on behalf of Arnold's family.
Councillor Dundas.
Thank you, Mr. Speaker. I can't express to this House the honour I have to stand at this moment and to say a few words. First of all, I think that what Arnold has asked us to do and tasked us with, I want to say through you to his family that I know I and I think others around me have already started on that. And today is an example. We have rules in this House, but we exercise great judgment and say that sometimes we're going to allow those rules to be bent so that we can do things that we think are right, honourable and just. And so the last 2 days have been a great example of that. And it was through his passing that has not enabled that to happen, but that we're witnessing what he is calling us to do. So through you to his wife Jean, his rock, his everything, to his 3 children who we know we've heard over and over again he loved so dearly. I think it has been fantastic for everyone in this house to witness the love and respect and to come together that we could make the wonderful tributes that have happened over the last 2 days in fact take place. Secondly, I'd like to say as a new MP, I had the honor and privilege of serving with Arnold on the PROC committee. And when I look at Arnold, he was everything that I as an MP wanted to be when I came into service. I wanted to serve. I wanted to work hard. I wanted to put my constituents first. I wanted at the same time to love and respect my family. And I just admired how he found the balance in doing all that. And even in PROC, seeing how Arnold would enable that committee to come together, he was a peacemaker. He was able to move things forward in such a respectful way. And I have to tell you that he has impacted, I know, many of us in so many positive ways. So I want his family to know that he will never be forgotten, that his way will impact me and others in this house in their daily living out and respect for this place. And to let you know finally that if I could model that man's way of life, I have truly succeeded. Thank you. And thank you to the Parliamentary Secretary for Public Safety for reading that. I'm sorry for the loss for so many that I know Arnold was close to. And I just want to thank again this House for the courtesy to be able to go through these beautiful testimonies over the last couple of days.
Resuming debate, the honourable member for Windsor West.
Thank you, Mr. Speaker. And with heavy heart, I rise to continue debate, though, which is what we need to do here in the House of Commons on bills that make difference for Canadians. And we will do that in the spirit of what has been taking place. And Mr. Chan and his family can be rest assured that this bill is of the spirit of getting all cooperation in this House of Commons. And it's an important one for public safety, Mr. Speaker. Bill S2, an act to amend the Motor Vehicle Safety Act and make a consequential amendment to another act, is actually about providing safety for Canadians that we don't currently have. For those not aware, automotive recall is actually not even enforceable in Canada. So say, for example, child seats, when they are defective, when brakes, when other types of measures in a vehicle are being questioned about their reliability, their data, even in the best of circumstances, cannot be recalled by force in this country. Now, that's different than the United States, and my speech is going to focus on a few of those things, but this bill is an opportunity to protect consumers, the Canadian public, and provide, I believe, reciprocity that is necessary for this bill. Now, it's interesting to note, Mr. Speaker, that I have been on this issue on record for over a decade here in the House of Commons about the fact that our transport minister, whether any political party, being the Conservatives and Liberals in the past, cannot enforce the auto companies to do what is necessary. Now, the ironic thing that's happened over these years is that we actually have had a series of accidents, a series of insurance increases, and a series of public safety issues that have gone to neglect. And consumers as well, Mr. Speaker, have been put at the lower end of that. The ones most prolific in terms of the notoriety right now is the Volkswagen issue with regards to the manipulation of emissions, but also we go back to Toyota with regards to the Prius and their willful attempts to mislead the public and as well too the reciprocity and that was not provided to Canada with settlements in the United States. And most lastly, Mr. Speaker, is the fact that we have Takata airbags which are now defective in Canada, where we are secondary citizens with regards to this recall. So every Takata airbag has issues with it, and Mr. Speaker, they pretty well universally have the entire market with regards to airbags and safety, so just about everybody has defective material in their car. And Canada's recall program is subservient to that of the United States. And then I want to touch on a few figures on how we got to this place, Mr. Speaker, but I think it's also important to recognize where we've been in with the industry. So I'm going to focus on our rights as individuals with regards to consumer issues, trade with regards to where the industry has gone and what's happened to diminish our capabilities for recall in this matter, and lastly, the future with where we can go with this legislation when it goes for testimony and what takes place. It is important to notice that the legislation S2 was previously brought in. Minister Baird at that time had promised to bring in this under the Conservative regime and had came close to getting some amendments and some changes, but the lack of political will seemed to be there, and there seemed to be the lack of exercise to get this at the final day across the goal line. So it was an unfortunate opportunity, but it is the first of the strong debates that took place here in the House of Commons related to Toyota. And that file, Mr. Speaker, and that file is very important because in the United States, it really shows the fact that we do not get reciprocity right now, because as Transport Canada at that time was applauding Toyota for issuing a recall notice, the United States was having hearings, and they actually had the company president come to the United States to apologize. As well, they didn't bother even to step into Canada at that time. They received a multi-million-dollar settlement, and consumers got protected much more prolifically in the United States. And on top of that, they got investment in new research and technology. And what did Canada get? Zero. We got absolutely nothing related to that. And that is at a time, Mr. Speaker, where often the industry has been for the past 3 decades crying for reciprocity related to standards. So there has been a movement, and there has been a good movement towards this. In fact, it's been very frustrating to see issues, say, for example, bumper issues between the two countries become a problem, or different parts through manufacturing be not aligned properly. Lobbying, intensive industry action, but when it came to consumer rights, different story. Different take for Canadians, different expectations from consumers, and most importantly, a weak-kneed government to this day that has decided to let a foreign nation set the rules out, the compensation level, and the accountability of automakers in the United States. A complete abdication of responsibility has happened until this bill gets passed, Mr. Speaker. Until this bill is actually through. The Minister of Transport has no official powers. He's an empty vessel, or she's an empty vessel. Whoever it may be, it doesn't matter what political party they're from or have been from. And they've known this for a long, long time. And we've seen the effects of this become real effects that have affected Canadians. There's a number of cases that have been out there in the past. So some of the new powers that are very important I'm going to touch on, and we're glad to see this bill come forward. And there was, and it was a last-ditch effort by the previous Conservative administration to table a bill in the dying days of their government to address this issue, and now it is only resurfaced because the airbag situation over Takata has reached such heightened proportions that Canadians, again, whether it be through the Volkswagen scandal, the Toyota scandal, are, rest assured, shaken. And I think that the mere fact that we went through the election with the Volkswagen scandal, where we saw Canadians not only lose tens of thousands of dollars of investment in vehicles, but also, Mr. Speaker, at a time when we're asked to compete and do other issues to combat global warming and emissions and pollution, we had an organized, complicit attempt that was successful for a time being to market Canadians with dishonesty and Americans and across the world on this issue that increased emissions, pollution, at a time when we've been asked to do the things necessary to reduce those. And they benefited from financially. In the United States, what it's resulted in is financial penalties and elements for consumers. Here in Canada, nothing. A class action private lawsuit is necessary because the government can't be bothered and they're too lazy. So we finally have this bill coming from the other place, coming from the Senate. Not tabled here in the House of Commons. You would have expected the Minister of Transport, given the fact, and again, as I noted, the Conservatives, the previous regime, pretty well built the bill, was available and ready for 2 years now, sitting on a shelf. Just had to dust it off and get it forward, get her going, get her done. Instead, it took the other place to get it going. And they supposedly don't have a caucus in the Senate, so the Liberals don't, so it seems like it's a private members' initiative to get this going is really what it is at the end of the day. I'm grateful that at least there was this fact in history that it was, related to the work of the previous Minister of Transport and the Conservatives, because there is some good work that was done in this bill. And some of them is a power to order a company to publish notice in non-compliance of stipulated in the ministerial order. So right now, they don't have to actually comply with that. The minister will be able to force, say, for example, a child seat that has been ordered for recall and is not listed. They will be able to do that. They will be able to put orders of correction. They will have to do additional inspections and follow ministerial orders. There's also the talk about, and they have it under lesser powers, but they are quite significant, the power to designate enforcement officers, the power to enter an administrative agreement for enforcing the Act, enhanced powers for Transport Canada inspectors, and the power to exempt a company from the regulations under specifics if they're going to be moving forward on new technology and new awareness that would be important to it. I have some concerns about that, but there's some ministerial discretion in there, and and this is going to be the key, is whether or not there's going to be Transport Canada officials that are going to be ready, trained, and available to be able to do this work. So I'm very pleased that this is coming forward to do that. There's also going to be monetary penalties, an appeal and tribunal element, which will bring more publicity to the files. I think that's important, Mr. Speaker, because having a government website is not sufficient for these, or when you finally bring your car into the automotive sector repair shop and then find out about a recall later on is not the best way to be handled. And there's going to be enhanced powers for the inspectors and measures to support dealers. So one of the things that I want to make sure that is important is that it's unfortunate this country has moved and has not retained its automotive footprint. And it's ironic right now, as I talk about these things, we're currently in a restructuring or rediscussions of a North America Free Trade Agreement. So when we signed with regards to NAFTA and free trade, we were at that time the #2 automotive manufacturing country for assembly and production. Now, what that meant, Mr. Speaker, is a lot of the assembly and the production takes place, and then the parts and the other supporting manufacturing and innovation takes place around it. Clusters. The industry is known as clusters, obviously for transportation and other matters. It's easier to be around the assembly component for it, and it's also better for resources to be drawn upon. Things have changed to some degree with regards to materials. When you think about when we signed on to that agreement, and we think about even 10, 20, 30, 40 years ago, steel was the main component of an automobile, still is to this day, but now there are several compounds and elements that are used for different parts, for everything from plastic to some materials that are lighter and are also variations of different elements to actually make the vehicle lighter, stronger, more flexible, so forth. But the big thing is, Mr. Speaker, when we signed these trade agreements, we gave up the Auto Pact. The Auto Pact was about the production and manufacturing of vehicles in Canada that would then be shipped into the United States. It was a very, very positive trade agreement where we actually had access into the American market and did a lot of manufacturing and distributing into the United States. In fact, that's when we were at the height of the auto industry. Well, when we signed on to free trade and NAFTA, that actually was later on challenged by the Japanese to move in their products into our areas, and we've since now tumbled to 8th or 9th. And why that's important to this particular bill in this file is look no further than the industry and the concentration of that industry on recalls, and one would be airbags. And Takata recently filing for bankruptcy and basically consolidating the entire industry under one manufacturer, there's increased vulnerabilities. So we've seen a concentration, and we've seen Canada lose out as essentially, and good points are being made right now in terms of where we've lost a lot of jobs to Mexico and now the southern states in the United States through incentives and that. But the reality is that a lot of it is driven by lower wages. So you have, it's ironic, Mr. Speaker, is that you have in Mexico people assembling vehicles that will never, ever be able to afford them. Never. And it's not that these are luxury automobiles, and it's not that they're foreign to their country, it's just that their wages for making them and manufacturing them are no reflection of to their value. And so what ends up happening is they ship them out, and other societies will then purchase them, and it's been a low-wage market that's also even led to the conflict in the United States related to Trump, the president, and the loss of automotive and other manufacturing there. But the point being in all of that, Mr. Speaker, is that we've lost control and we've lost a significant input and footprint of the decision makers and the industry itself. So what happens is that when we now leave it to others to look at refinement of those vehicles and manufacturing, often they're done through their lens. I'm proud to say that in my riding, Windsor West, infant car seats, for example, baby seats, been part of in the past Auto 21. This government and the Liberals did not renew Auto 21, but they innovated when it was still going and created safer seats. Now, with the production and distribution moving from this area, if we do not fight for this industry, which we are not doing fully right now, we will lose more jobs, more control, and more innovation to others. So without this bill, right now, we will be solely dependent on the United States and others for protection of our vehicles and our standards. So, and it does affect other government policy. So let me point to a program the Conservatives brought in power called the Eco Auto Fee-Bait program. This is a blast from the past, Mr. Speaker. This was a government initiative to bring in lower emission vehicles into Canada. So I mentioned earlier in my speech about the fact that Volkswagen ran basically a systematic scam that has now predominated the courts, and the only protection for Canadian consumers is the courts, unfortunately. But in the United States, they had hearings and so forth. Is in this Eco Auto Fee-Bait program, the Conservatives thought, wow, wouldn't it be great if we had consumers purchase lower emission vehicles? So they put out $110 million. $110 million, and they qualified. If your vehicle reached a certain qualification measure for the emission standards and the mileage, then you would get a Canadian taxpayer-funded incentive. Around $1,000 to some vehicles, to $2,000 depending upon the vehicles. So what we had, Mr. Speaker, what a wonderful idea that was when we had companies that actually decided to take airbags out of their cars to increase their mileage by reducing weight. So the Yaris, for example, made by Toyota, took the side airbags out of its car, and the Eco Auto Feedback program applied to it. We also had secondary vehicles that could not pass European standards related to emissions sent into Canada that then received the Eco Auto Feedback. All at a taxpayer subsidy, Mr. Speaker, and all foreign-made manufacturing automobiles subsidized by the government. So these are the challenges in why this legislation is so important. Because if we are going to look at this industry and the high tech that's going to be necessary in the future, we need to make sure that consumer rights are protected, public safety is paramount, and the minister has the authority with this bill to address some of those issues. It was mentioned earlier, autonomous vehicles. Autonomous vehicles are coming. In fact, some municipalities have become testing zones for autonomous vehicles now. In fact, we actually even have autonomous trucks that will be coming to the roadways of our country rather soon. So we need to make sure that these laws and orders are in place, because that new technology will need oversight, Mr. Speaker, and that's what this bill provides. We'll make sure it provides enough, though.
Questions and comments? Questions et commentaires. The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. I appreciate the comments by the member across the way. You know, one of the things that's really important here is to recognize that there seems to be a fairly high sense of awareness in terms of the importance of the legislation, and that's quite gratifying. In fact, one of the member's own colleagues earlier this morning made the comment that at times you get different types of legislation, and this seems to be one of those pieces of legislation in which there's a consensus that appears to be developing. There might be some issues with some of the smaller areas of concern, but generally speaking that we want to move forward. And the question that I have for the member across the way, just in listening to what he's saying, is does the NDP or members of the NDP have some amendments, specific amendments that they would like to see at this stage that are already developed? Because if they do, I think it would be great to work with the committee. I think standing committees can do great work at looking at ways in which the legislation could potentially be improved. And there seems to be, just listening to the debate, a great deal of concern as we recognize that this is legislation that is needed. I'm anticipating, by the sounds of it, that it will receive virtual unanimous support just based on what I'm hearing, Mr. Speaker, in terms of at the very least going to committee. If the member would just like to share some of his thoughts in regards to the potential of any specific amendments that he might have in mind.
The honourable member for Windsor West.
Thank you, Mr. Speaker, and absolutely. One of the amendments that I'll be tabling and working on relates to work I previously did in this Parliament called the right to repair. And the right to repair, Mr. Speaker, was the automotive aftermarket, the areas, say, for example, that were not the actual dealerships that had a hard time getting information from the dealerships or from the companies related to equipment, and it could be software, it could be training, any of those things. So your Canadian Tires, your third-party, your smaller business, auto manufacturer, garages, repair shops, so forth, are not getting the proper information, training, and even material from what's called the OEMs. The OEMs are the manufacturers. So what ends up happening, Mr. Speaker, is, say, for example, even just downloading a piece of software was prevented, so a car could be fixed in your local garage, but then would had to be towed somewhere else to actually get the software put into it, which would take literally seconds and would be a simple download. So that's one of the things that I'll be raising and finding out as well, because technology is changing, and so the deal that was cut on this before in the past, there was a voluntary agreement that was created for this, and I'm hopeful that the Conservatives and the Liberals will support this, that we may need to look at that some more, because technology has changed quite significant in those 10 years. So it doesn't take into account some of the new elements that are required, because if you have, say, for example, a recall that takes place, but if you're in a rural area and you cannot get your vehicle fixed because your local auto garage shop cannot get the proper software from the manufacturer, and this is not for free, they pay the same price as anybody else, but if they cannot download that information, the vehicle has to be towed or is on the streets longer with worse environmental and repair issues, which create more danger. So we need to make sure in this legislation, because if recall takes place, like say, for example, the airbags, if they're only being done in dealerships alone, then we cannot get all the vehicles fixed properly, and they will take longer periods of time and be on the road longer with recalled parts and materials versus that of having your local garage and your medium-sized business. Now, the Liberals seem to be very much transfixed at really attacking small business right now, but maybe they'll understand in this, out of the reasons for public safety and the reasons for environmental improvement, that we have to support the small business in this, because they're being frozen out at times just because the manufacturers will not release information. And I'll finish with this, Mr. Speaker, but it's important. In the United States, they provide this under their environmental laws, and it was done even on a number of different conditions and so forth that were voluntary or later followed up, and they were more than just voluntary if there was necessary, but they had the power to do so. In Canada, it was entire voluntary, and only companies like General Motors and a few others were doing it in the full capacity. And Ford, another good credit, they came to the table on this, and then eventually Chrysler. But I got to tell you, Mr. Speaker, is that we need to make sure it's modernized, because if people are waiting in a lineup to fix a child's car seat from a recall, that's wrong.
Questions and comments? The honourable member for Vancouver East.
Very much, Mr. Speaker, and I thank my colleague for his thoughtful comments and also a lot of the historical context. He's done a lot of work on consumer protection. There's no question about that. Now, with this bill, there's a provision that would allow the minister to use his power to set a fine amount less than the amount provided by the regulations. Now, I think this begs the question, why would we have a provision like that? And I wonder if the member can comment on that, whether or not he have some concerns around that, or how that could be subject to abuse.
The honourable member for Windsor West.
Thank you for my colleague's question on that. Actually, it's a very interesting question, because it would seem to me like an unnecessary protection against consumers. And it would seem that it would be an escape clause that could do that. Now, I would like to point to what I would argue is what's necessary in some matters is reciprocity with the United States, is that if we are truly going to have a law that's going to be the same vehicle and they want the same standards for the vehicle sold in Canada and the United States, then I can tell you that consumers should expect the same elements, and we should have the same, I guess, results from those companies. So I use the example of the Toyota software problem that they had for Prius as an example, because I think it's the primary one. So say, for example, in California, when the Prius had the software problem, California residents were often being picked up at their house, or their car was anyways, and taken to the dealership. That was one of the agreements that they had. Otherwise, the company would be fined. Meanwhile, in British Columbia, they would have to drive the vehicle in, and that didn't even come to months later after there was a number of different pressures applied, but it became so painfully obvious that they had to do something over here. And it's also resulted, Mr. Speaker, in the way the companies treat our country, allowing the administer and monitor penalties to be this complicated and convoluted is not good enough for consumers. We want simple laws in terms of the expectations and no escape clauses. I think that'll be one of the interesting aspects that committee members will be able to give it an opportunity with consumer rights groups coming in and to make sure it's simple and effective. And lastly, Mr. Speaker, again, to the examples of how we're treated versus that of the United States, we are the poor cousin in this situation. It doesn't matter if you are better off buying a vehicle, and that's why some border communities, you do have people purchasing vehicles in the other country into the United States, is because of consumer protection and, as I mentioned, the elements of auto repair previously in the last answer with regards to the right to repair in aftermarket service is much more prolific there, and that simply has to end. If the companies want to have the same market to sell an Apple and an Apple in North America, being Canada, the United States, then the consumers need to be treated that way as well. They just can't treat us different just because they don't want to, and this bill has to protect that.
Questions and comments? Questions et commentaires? We have time for a very brief question for the honourable member for Edmonton West.
Great, thank you, Mr. Speaker. I want to thank my colleague for his thoughtful comments. And again, on the history, it's not often you hear referring back as far back as the auto pact. So it was very nice. One of the issues we have with S2, I think we generally are all going to support it to get into committee, though, is how it underachieves, especially when addressing the many issues of the Auditor General report, including one that states over the last several years, the Department of Transport has only been making regulation changes after the U.S. has made their changes, perhaps leaving Canadians in a safety limbo. I wonder if my colleague can comment on Transport Canada waiting for the U.S. to make changes, leaving Canadians at risk, and the fact that Bill S2 does nothing to address this issue.
The honourable member for Windsor West in 45 seconds or less, please.
Thank you, Mr. Speaker, and I will be really brief on this. I thank the member for an excellent question. And that's it. At the end of the day, though, we can't be the dog's leftovers off the end of the table as we currently are right now with regards to the American consumer protection on automobiles versus ourselves. And that's what we really are. We get the scraps. We get what's available. When Toyota came and apologized to the United States Congress and Senate, our Department of Transport issued basically a congratulation remarks. They got investments of millions of dollars. Their consumers got better protection. We didn't. That has to end. We need full reciprocity. The bill needs to do that.
Resuming debate, the honourable member for York. Yes, on a point of order, the honourable member for Wellington Perth.
Thank you, Mr. Speaker, and I'm very pleased to rise today and raise a point of order. And in respect to the Chair's statement on May 9, 2017, concerning Bill C-343, an act to establish the Office of the Federal Ombudsman for Victims of Crimes and to amend certain acts standing in the name of the honourable member for Beauport, Côte-de-Beaupré, Île-d'Orléans, Charlevoix. And I know, Mr. Speaker, like yourself, I've spent all summer reflecting on the Speaker's comments at that point, and I'm now prepared to offer some comments on his provisions at that time. The Chair drew the attention of the House to the presence of a provision in Bill C-343, namely Clause 26 of the bill. And I quote, 26.1, subject to Section 2, this Act comes into force on a day to be fixed by order of the Governor and Council. 2, no order may be made under subsection 1 unless the appropriation of monies for the purposes of this Act has been recommended by the Governor-General and monies have been appropriated by Parliament. End quote. At the heart of the Chair's concern is Section 54 of the Constitution Act 1867, formerly the British North America Act 1867. Which requires the Governor-General's recommendation for appropriations. That constitutional provision is given procedural effect and thus jurisdiction for the Speaker through Standing Order 79-1, which is quoted in the June 20th, 2017 intervention by the member for Guelph. Indeed, as the English constitutional scholar Sir Ivor Jennings once wrote, quote, in approaching the subject of financial control exercised by the House of Commons, we reach the borders of the realm where law, parliamentary privilege, and parliamentary custom are all almost inextricably intertwined, end quote. Mr. Speaker, over the course of 150 years, a number of procedural precedents concerning the Crown's financial prerogatives have been accumulated. This is one area where we can more easily look back over the array of accumulated jurisprudence because that piece of constitutional law and the associated procedural rule have not substantially changed since Confederation. I would draw your attention to Beauchene's Parliamentary Rules and Forms, 6th edition, at citation 611, which provides that, quote, a bill from the Senate, certain clauses which would necessitate some public expenditure, is in order if it is provided by a clause of the said bill that no such expenditure shall be made unless previously sanctioned by Parliament, end quote. Reference is then made to the ruling of Mr. Speaker Coburn on April 5, 1870, page 155 of the Journals records the following, quote, the last clause in the first section provides that nothing in this Act shall give authority to the Minister to cause expenditure until previously sanctioned by Parliament, and this overrides the 8th section referred to by the Honourable Member. No contract could therefore be entered into under that section which could bind the government and necessitate an expenditure of public monies unless it had been previously sanctioned by Parliament. He could not therefore sustain the objection of the Honourable Member for Chateauguay, end quote. To be clear, Mr. Speaker, the statutory language reference was the proviso in Section 1 of an Act to amend the Act relating to lighthouses, buoys, and beacons, which was quoted by the member for Guelph. By its own terms, subclause 26.2 of Bill C-343 does not give the Governor-General and Council, in this case, the authority to pass an order in Council to bring the Act into force unless and until such authority for expenditure and appropriation has been given by Parliament. Turning back to Beauchene's, let me quote citation 614. Quote, a bill which does not involve a direct expenditure but merely confirms upon the government a power for the exercise of which public money will have to be voted on by Parliament is not a money bill, and no royal recommendation is necessary as a condition precedent to its introduction. No reference is noted, but looking back to the 4th edition of Beauchene's, the citation there numbered as 277-2 refers to a ruling on February 23, 1912, at page 240 of the Journals. In responding to Sir Wilfrid Laurier's point of order, the Prime Minister, Mr. Borden, as he then was, forcefully observed, and I quote, it does not appropriate any part of the public revenue. It does not appropriate $1 of the public revenue for any such purpose. It merely does this. It provides that if Parliament shall, at any future time, appropriate a certain sum of money for that purpose, then that money shall be expended by the Governor-General and Council under the provisions of the bill, according to the method now laid down by the bill before the House. The provisions of this bill are perfectly simple and plain and not to be misunderstood. Therefore, it is apparent that before $1 of public money can be expended under the provisions of this bill, a resolution must be brought down in Parliament, assented to by His Royal Highness the Governor-General, considered in Committee of the Whole, and be the foundation of a bill which will alone justify the expenditure under this Act. Therefore, to suggest, as the right honourable gentleman has done, that this is a bill for the appropriation of any part of the public revenues seems to me to be entirely a misstatement of the case. The simple answer is that without this bill, if an appropriation were presented to this House, passed through the Committee of the Whole, and embodied in an Act of this Parliament, the Governor-General and Council would be left without any machinery whatever for the expenditure of that money. This bill is solely designed to furnish machinery for the expenditure of a certain sum of money which may or not be voted by Parliament for that purpose. There is no question of the appropriation of $1 of the public revenue of this country for this purpose until an appropriation bill has been brought in founded upon a resolution which shall conform to Section 54 of the British North America Act, end quote. Mr. Speaker Spruill ruled in favour of Mr. Borden's argument. He stated, and I quote, my attention was drawn to the fact that when Parliament could vote any money for that purpose, the resolution must pass through the usual course required for all money but resolutions or bills. That, in my judgment, seems to be ample guarantee for the House that it would have the full consideration that all money bills have, and therefore I thought it unnecessary at the time that it should be introduced by a resolution. That was my opinion then, whether it was correct or not, and I still hold the same opinion. End quote. One further passage from Beauchene's 6th edition to offer, Mr. Speaker, is citation 615. Quote, a bill designed to furnish machinery for the expenditure of a certain sum of public money to be voted subsequently by Parliament may be introduced in the House without the recommendation of the Crown. End quote. That citation cross-references to Mr. Speaker Spruill's ruling on January 16, 1912, at page 118 of the Journals, based on an English precedent which is described as thus, quote, a motion for leave to bring in a bill to enable the government to acquire lands for public purposes, but not providing funds for the same, on objection being taken from the bill, involved a charge upon the public. Answer is made that the bill only proposed to give the government power to buy land, but for that power to be of any use, an estimate must be voted in the committee. That the bill would not enable the government to purchase any lands until the House in committee had considered the estimates and agreed to them. That the bill did not authorize any public money, although the expenditure was contemplated. The Speaker ruled that the object of the bill was to take ground for certain purposes. It did not give them power to purchase the property. End quote. What Bill C-343 does is establish a machinery, though one might more accurately say it merely confirms the existing machinery for the Federal Ombudsman for Victims of Crime, who currently works under the auspices of the Minister of Justice, whereby some future additional expenditure might, at a later date, be approved and undertaken to this end. The need for a later parliamentary appropriation to be separately enacted is clearly made out in subclause 26.2 of the bill. Moreover, to safeguard the financial initiative of the Crown, Bill C-343, if passed, would not become law until proclaimed by the Governor-General in Council, and then only if the condition precedent of necessary appropriations being made is satisfied, which of course follows a recommendation by the same Governor-General acting on the advice of those same constitutional advisors. As the Chair's statement noted, this condition precedent for a coming into force order is similar to provisions found in Bill S-205 and Bill S-229. Before the summer adjournment, the Honourable Member for Guelph tendered submissions on the latter bill. Without commenting on the merits of those two bills, it does not appear from a cursory search of Senate proceedings that this coming into force clause is an entirely novel approach in that House, although it may be the first such provision to make its way to the House of Commons in recent years. To that end, Mr. Speaker, it makes sense to explore how the other place has handled this issue. Through its Rule 10-7, the Senate gives procedural footing to Section 54 of the Constitution Act 1867. That rule reads, quote, the Senate shall not proceed with a bill appropriating public money unless the appropriation has been recommended by the Governor-General, end quote. That rule is more trite than our own Standing Rule Order 79-1, but it still applies the same principle. So how does that rule, addressing the constitutional principle in Section 54, intersect with provisions worded like Clause 26 of Bill C-343? Page 155 of Senate Procedure in Practice informs us that, quote, in addition to the factors outlined in the above quotation, rulings have noted that a bill that would otherwise require the royal recommendation can proceed if it clearly provides that it does not come into effect until funds have been separately appropriated by Parliament, end quote. In support of that proposition, footnote 181 references citation 611 Beauchesne's, which I earlier quoted, as well as two rulings of Mr. Speaker Kinsella. The first ruling, delivered on May 27, 2008, and recorded at page 1086 of the Senate Journals, lays out the Senate Speaker's logic in working through the question. The Honourable Member for Guelph quoted a portion of it. Allow me to quote further parts of that ruling. Quote, the key to this issue is, of course, Clause 52.2. Under this clause, most of the bill cannot come into force until funds have been recommended by the Governor-General and appropriated by Parliament for the purposes of the bill. No expenditure whatsoever would thus be incurred by the mere passage of Bill S-234. When the term appropriation is used, it is often used quite loosely. It does, however, have a narrower meaning. An appropriation is a sum of money allocated by Parliament for a specific purpose. As seen with supply bills, appropriations quite often fund entities whose legal frameworks have been separately established. One must therefore consider whether Bill S-234 actually appropriates money within this meaning. As already discussed, funds for the purposes of S-234 have to be separately appropriated or voted by Parliament on the Governor-General's recommendation before the bill can enter into force, end quote. And here comes this kicker, Mr. Speaker, and I quote, S-234 thus appears to respect fully the financial initiative of the Crown. Thus, no funds are being or must be appropriated, end quote. Continuing later, Mr. Speaker Kinsella said, quote, Bill S-234 respects the financial initiative of the Crown while allowing Parliament the opportunity to consider a new proposal. The bill in no way incurs actual expenditures. It merely sets the stage for such expenditures to be incurred if the Crown chooses to recommend them and if Parliament chooses to appropriate these funds." End quote. The second ruling, on May 5, 2009, found at page 564 of the Senate Journals, recalls the analysis in the ruling I just quoted and concluded, quote, "The ruling on Bill S-230 is the same. The bill does not require a royal recommendation, since nothing can happen following its adoption until and unless funds have been appropriated." Mr. Speaker, this line of logic is also followed by our former law clerk and parliamentary counsel, Rob Walsh. In his 1994 article in Canadian Parliamentary Review, he writes, which is titled, "Some Thoughts on Section 54 of the Financial Initiative of the Crown," he quotes a former Chief Legislative Counsel of the Department of Justice. Quote, "Sometimes bills are passed during a session for which no appropriation is made. In those cases, we will usually put an appropriation clause in the bill because there has been no appropriation. In other cases, we do not have to put appropriations in the bill. We presume that Parliament will appropriate the monies. If they do not appropriate the monies, effectively the law will not operate." End quote. Finally, I want to address the 1978 ruling of Deputy Speaker Gérard Laniel, cited by the Government House Leader's Parliamentary Secretary in his submission and answered by the member for Guelph. Mr. Walsh offered this critical perspective of the decision in the article referenced above. Quote, "It is difficult to see why this should be so when passage of the bill with a non-appropriation clause would clearly indicate that an expenditure of public funds under the bill is not authorized." End quote. Later in the article, Mr. Walsh argued, quote, "In respect of a private member's bill containing a non-appropriation clause, the Speaker need only ask two questions. A, would the bill in the absence of a non-appropriation clause require a royal recommendation? And B, if so, is the non-appropriation clause sufficient to dispense with requiring a royal recommendation? In respect to the latter, the test should be whether the non-appropriation clause clearly disclaims authorization by Parliament to expend public funds for the purposes of the bill. In the absence of an authorization by Parliament, no public funds may be expended, Section 26 of the Financial Administration Act." End quote. Additionally, Mr. Walsh advanced this thought, quote, "It is also argued that such bills constitute an indirect demand for supply and would, if passed, leave the Crown bound to make a demand for supply for purposes of the bill, and the Crown ought not to be in a position where its financial initiative is compromised. In this connection, it is pertinent to note that the Crown has been known to not proclaim into force an act that has been passed by Parliament. If the Crown is not obliged, and evidently does not feel itself obliged, to bring into force an act that Parliament has seen fit to enact, how can it say that enactment of a private member's bill with a non-appropriation clause leaves it obliged to exercise its financial initiative and to make a demand for supply? In short, this argument lacks credibility." End quote. In conclusion, Mr. Speaker, the authorities are clear that the legislative language used by the honourable member for Beauport, Côte-de-Beaupré, Île-d'Orléans, Charlevoix is an acceptable manner in which to proceed. It recognizes the government's exclusive rights concerning financial initiatives while offering something of a turnkey statutory structure for the government to bring into force at a time of its choosing, and in a manner entirely respectful of our constitutional rules concerning financial bills. And I may just add as a way to sum up, Mr. Speaker, that I think this is an important bill, and if we look at the human side of things, we're looking at an ombudsperson for victims of crime, and we need to, at all times, think of those victims, think of the impact that legislation like this would have. And so I offer the submission to you, Mr. Speaker, to take under advisement when ruling on the royal recommendation of this bill. Thank you, Mr. Speaker.
I want to thank the honourable member for his submission. It will be added to other input that has been given over time, and the Speaker will be ruling on it shortly. Thank you. Order is my duty, pursuant to Standing Order 38, to inform the House that the questions be raised tonight at the time of adjournment are as follows. The Honourable Member for Nanaimo Ladysmith on social development, and the Honourable Member for Windsor West Public Safety. Resuming debate, the Honourable Member for Oh, I'm sorry. We've got a change here. The Honourable Member for Lethbridge.
Thank you, Mr. Speaker. Mr. Speaker, I would like to split my time, and I will be doing that, in fact, with the member from York Simcoe. He will be going after me. Now, I'm pleased to rise in this House in order to speak to Bill S2, the Strengthening Motor Vehicle Safety for Canadians Act. This legislation will, in fact, better protect Canadians, their families, their children, their loved ones, as it will make sure that defects within vehicles are taken care of properly. Hearing that your family's car or minivan has a potentially dangerous flaw, of course, is absolutely terrifying to a family. Our cars, our trucks, and our minivans carry our most precious cargo, that is, of course, our children and our other loved ones. And this legislation applies to much more than just the family SUV. It also applies to vehicles manufactured, including service vehicles, buses, transportation trucks, etc., that might have an impact on our roadways and their safety, and of course other drivers on the road as well. Now, consumers do deserve to know that as soon as a defect is uncovered, that the company is required to make purchasers aware of the defect and to do everything in its power to fix the problem. As consumers, of course, we hope that this is in fact the case. Now, this legislation will accomplish this by granting the Minister of Transportation the authority to order a company to issue a recall if they choose not to do so on their own. It will also ensure that car companies repair a recalled vehicle at no cost to the consumer, and it will prevent new vehicles from going on the market, or from being sold, I should say, in Canada until the problem that has been identified is in fact fixed. By providing the Minister the option of initiating a recall, consumers can be assured that their safety comes before a company's profit, which of course is advantageous to everyday Canadians. Now, I'm pleased to see that this bill does have bipartisan support, as it should. Now, this bill was originally introduced in 2015 under our previous Conservative government. It was slightly different. It came in under Bill C-62 and had a few slight changes, but for the most part, we certainly see many similarities, and we're in very much support of this bill. We believe that this bill is a good testament to the incredible work that was done by the current Deputy Leader of the Conservative Caucus, who was, of course, the Transport Minister at that point in time back in the day. Now, why is this legislation so important? Please allow me to explain. The number of safety-related recalls that actually increased from 2010 to 2015, not just by a little bit, but actually by 74% in those 5 years. In 2015, 5 million passenger vehicles were recalled in Canada. That's a big number. Now, many companies have realized the risk of not issuing a recall, but still there are examples of companies delaying safety recalls because of corporate interests. One has to think back to the massive Takata airbag recall of 2015. This is certainly a prime example. Takata is a huge parts supplier to over 19 different auto manufacturers, and when defects were uncovered in their airbags, different manufacturers issued recalls at different times. So sometimes prioritizing a recall in the United States before getting around to issuing a recall in Canada, which of course puts those who drive those vehicles here in Canada at risk. The first of the Takata airbags were recalled in 2008 in Canada. However, because Canada relies on voluntary action from companies, few details were provided to Transport Canada. And as a result, it was difficult for us to connect the dots between numerous airbag recalls across several different car manufacturers. So it was government regulators in the United States in 2014, so quite some time later, who actually connected the dots and escalated the recall to multiple manufacturers. Now, instead of being proactive, like the U.S. officials, Canada was forced into a position where we actually had to be reactive, again, putting our consumers or our drivers at risk. Now, it took until 2015 still for the majority of recalls to be issued for these airbags in Canada. Now, Mr. Speaker, that's quite some time later, 2008 to 2015. And even in 2017, there continued to be recalls for these airbags. That's 10 years later still, or nearly 10 years. Now, why did it take almost 10 years for the recalls to be completed, 7 years for the majority of the recalls to be made? The answer is this: Canadian laws have actually not kept pace with other industrial countries. The United States has much stricter laws allowing the government to issue a recall. Until this legislation passes, that is currently being discussed in the House, the government is relying fully on the voluntary compliance of companies to issue recalls all on their own accord. The penalties for not issuing a recall are less than the United States, and punitive damages in court are significantly less, again, than the United States. Now, all of this adds up to a lower incentive for vehicle manufacturers to issue recall notices in Canada, or at the very least, to prioritize recalls in the United States first. Now, going back to the Takata airbags example, once the problem was understood, there was a global shortage to replace the airbags, which of course poses another problem. And so companies had to prioritize how much they were willing to spend in order to secure the parts needed to replace these airbags across multiple countries. Now, even though recalls had been issued, the biggest market with the greatest liability, of course, got attention first, which, as you can imagine, of course, was the United States and not Canada. Now, how will this legislation help with these issues that I've brought up today? I believe that it will help in a number of ways. First, we need better inspection and testing practices when the first signs of a potential defect come to light. This legislation significantly increases the power of the minister to order tests and studies of potential defects. It also includes significant fines, both against an individual and a company, that gets in the way of a government inspector who might want to do that test. Second, we need to increase the powers of the minister to force companies to take responsibility, even if they didn't manufacture the part that is defective. The Takata airbags were seen as a parts supply problem by many manufacturers who didn't feel fully responsible for the problem at hand. So this legislation now makes it crystal clear that car manufacturers are in fact responsible for their final product and, of course, the safety and well-being of Canadians. So if they picked a supplier with a defective part, it is still on the manufacturer to make the right decision on behalf of the consumer and to take responsibility for the problem at hand. Thirdly, I believe that we need to give the minister the ability to initiate a recall in order to strengthen our policy here within Canada. Now, this applies to manufacturers who haven't identified a defect in the vehicles that they sell, but could now be compelled to issue a recall if a substandard part is used in the vehicles that they manufacture. Even in 2017, a decade after the first recalls, there were still new recalls being made for Takata airbags. This legislation would have allowed the minister to issue a directive to all manufacturers in Canada to replace those airbags and to be able to protect the safety and well-being of Canadians. Now, instead, some Canadians found out years later that they had been at risk this entire time. Had they needed their airbag, it may not have been there as required. In conclusion, Mr. Speaker, I would argue that this legislation is long past due. It's unfortunate that it has taken more than 2 years for it to come back into the House since it was first introduced by the previous Conservative government. Now, this bill directly defends the safety of Canadians and the confidence that we can have in the vehicles that we drive. While the Conservative Party of Canada is a strong champion of reducing red tape, we recognize that there is a vital role for government to play in protecting the health and the well-being and the safety of Canadians. And this is where government can adequately and responsibly step in. Now, the new powers granted by this legislation will help Canada catch up with other industrial nations when it comes to protecting Canadian consumers. And of course, I want to find myself on behalf of the families across Canada, the consumers across Canada, those who get in their vehicles day in and day out in order to do their jobs across Canada. Speaking of which, I will also do all that I can to protect those jobs across Canada. All that to say, it is time for this legislation to pass. I'm excited that there is multi-partisan support in this House, and I thank you for your time.
Questions and comments? Question et commentaires. The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. And, you know, I find it interesting. The member spent a bit of her time talking about it's about time that we're seeing the legislation. And I think it's important to point out that the Harper government was very much behind in terms of just trying to get an understanding of what was happening in North America. And in fact, it was the USA that kind of nudged the former Conservative government to take any action whatsoever. within 2 years, this government has not only done the review process, but has also added on some other benefits for motorists or issues related to automobile recall procedures and so forth, giving our minister some strength and some authority. Something in which I'm a little bit surprised. I'm grateful, don't get me wrong, I'm grateful that the Conservative Party appears to be supportive of the legislation, and we look forward to it going to committee. But I'm wondering if the member could provide her thoughts in regards to the amendment that was being proposed by the Senate. Does she, in fact, support the amendment being proposed by the Senate?
The honourable member for Lethbridge.
Thank you, Mr. Speaker, and I thank the honourable member for his question. Now, I'm pleased to hear the honourable member acknowledge the great work that's been done by the Deputy House Leader. She certainly, has done a tremendous amount of work on this. And of course, we're once again very happy to see this piece of legislation come back to the floor and to support it going forward in order to look after the safety and well-being of Canadians. Now, that said, this government, it took them 2 years to bring it to the floor, and of course, the reason why they were able to do that within 2 years, though I would argue that that was still a fair amount of time and much more than was needed, because again, the hard work was done by my honourable colleague. And so I would want her to be acknowledged in the work that she did, rather than the current government taking responsibility and praise for her work.
Questions and comments? The honourable member for Edmonton Riverbend.
Thank you, Mr. Speaker, and it's a pleasure to rise and ask my colleague a question. She raised a good point. It took 2 years. We're now about 2 years into this mandate from the Liberal government, and we have yet to see, this is the first time we're finally going through the process of debating this. That reminds me that this summer, I spent hundreds and hundreds of people came to my office to talk to me about the tax changes that are happening right now. Yet there was a 70-day consultation period, and that was it from this government. So I'd like to if the member could comment on this, the lack of the hypocrisy, it seems, between the two, that we get 70 days to talk about an important issue in my riding that I'm talking to many, many constituents about, and this has taken 2 years to come here.
The honourable member for Lethbridge.
That is an excellent question, and I would like to thank my honourable colleague for asking it. So we have a piece of legislation that's in front of the House today. The hard work was done by the previous government, and yet it took this current government nearly 2 years to finally bring it to the House for debate. 2 years is a long time for this piece of legislation when all the background work was already done. However, I will tell you about another piece that is in the process or in the works, and that is tax hikes on small businesses across Canada. We're talking about hard-working women and men from coast to coast across this nation. We're talking about women and men who had a dream, had a vision, had a desire to provide jobs and to contribute to the well-being of our country. We're talking about men and women who stepped out and took a risk and put their houses on the line and put their families on the line and put their cars on the line, put their well-being on the line in order to supply jobs to Canadians. We're talking about the majority of Canadians who find their well-being in small businesses. That's how they make the money, the paychecks, that come home and put food on the table, that put fuel in their cars, that pay for the mortgage of the house that they live in, that put their kids into school and their kids into sports and allow them to live a good, healthy life as Canadians. We're talking about middle-class citizens of this country, Mr. Speaker, and we're talking about a government that is currently in power that is putting in 3 different changes with regards to our taxation, and it is going to rob Canadians of their jobs, and it is punishing our small business owners who create those jobs.
Resuming debate, the honourable member for York Simcoe.
Thank you very much, Mr. Speaker. It will be tough for me to be able to hit those heights that the member from Lethbridge just did in standing up for her constituents. But we in the Conservative Party have been standing up for ordinary Canadians for quite some time. That is what this party is all about. And our agenda of consumer protecting legislation, of measures to protect ordinary Canadians, which is reflected in this bill, which is essentially the Liberal government taking up our bill C-62 from the last Parliament and bringing it forward in this Parliament. That is one example of it, but there are many, many other examples of that, of course. We did a great deal to introduce more competition in, for example, the wireless sector so that people would pay less. It's an ongoing struggle to do in this country, but that tends to seem to happen in federally regulated industries for some reason. But we did that there. We protected consumers when we brought in a ban on biphenyls, on BPHs, which was a chemical in a lot of substances, in a lot of materials, plastic materials, to make it soft. So it was appealing to have in things that babies and children would be chewing on, and of course it was hazardous, and our government banned that so that children would be protected. We did something similar when, with the encouragement of myself and some other members around Lake Simcoe, encouraged a ban on phosphates in dishwasher detergent so that we could protect the health of Lake Simcoe and so many other lakes in which phosphate inputs were affecting water quality, and that was to the detriment of all consumers and ordinary citizens. We did it throughout with a number of measures under our chemical action plan, where we were methodically evaluating one after another chemicals that were being introduced into consumer environments, into people's homes, to assess, were they hazardous? What were the risks? And did we really need to have these chemicals in people's homes? How could we protect Canadians better? And we also did it in some of our rules that we brought in to ensure that there was greater truth in food packaging. Again, something to protect consumers. And I could go on and on and on, but what you saw there was an agenda where the Conservative Party, and what is our finest tradition, was standing up to protect ordinary Canadians, to protect ordinary citizens, and providing them the protection that they thought was a legitimate role of the government, of the state. And that is often a question because, of course, another element of our Conservative philosophy is that we are great believers in freedom and in liberty and in minimizing the role of government. But the question becomes, what is the appropriate role of government, and where is there a place? And what many of these things have in common are values that justify the government stepping in fact, places where people look to government to play that role. And as Conservatives, we understood and always continue to understand that difference between when government is the correct answer to the question and when it is not. And when it's the question, well, in the case like this, where we're dealing with safety, safety is paramount. There is no greater role for a government than to ensure the safety of its citizens. And in this case, when we're dealing with auto recalls, the dangers of something going wrong of a mechanical nature are indeed great. The consequences are great. And that is one reason that suggests perhaps the government has a role, one reason why Canadians expect government to play a role. Another is an occasion where you have that imbalance in information or knowledge, or between different entities, or in power. And with automobiles, that is certainly the case. I think more and more with specializations in societies, more and more typical Canadians don't necessarily know how to fix a car, what's wrong with the car, how to recognize if there's a flaw in a vehicle. And of course, they don't have those kind of resources compared with a very significant multinational corporation that has a lot at stake in that. And that's where people are looking for a government to step in on their side, on the side of ordinary consumers. And that's what we Conservatives were doing when we introduced the predecessor to this bill, C-62. And of course, as technology changes, as things become more technical, and we've seen that certainly happen with the auto sector, with automobiles, again, there is a place for us to step in on the side of consumers, on the side of ordinary Canadians, to make sure that their interests are protected, and that is, again, a legitimate role for us. Now, I talk about that imbalance, and that imbalance when you involve major corporations is sadly and unfortunately being an issue in the auto sector. And we've seen that recently. We've seen that on the international stage with some of the European manufacturers who got caught up in this very major scandal to do with diesel emissions and diesel emission testing, where these big corporations found ways to alter their technology so the vehicles knew when they were being tested and suddenly changed the way they operated to score better on those tests. And then later, on the efficiency test, went back to their regular way of operating. Well, obviously, that would raise a lot of questions of trust, but it's also a place where the government has to step in to defend consumers and defend their interests. It meant, of course, that the efficiency and the mileage advertised was not really what was expected by consumers and by citizens. And of course, it also meant that some of the other objectives of those emission standards and those efficiency standards were not being achieved. But we also have to ask ourselves, why does that happen? Why did those companies do that? And I think what we see is that that is also a response to government intervention, that the companies went there. Obviously, there are important questions of ethics and morality that are in play and incentives that we have to look at. But it's funny because it puts those two different tensions at play. And in Bill C-62, when our government brought it forward, and the member from Milton was the minister at the time, though there was much work done in the run-up to that by predecessor ministers. But that purpose was to find that right balance where we would stand up for consumers and make sure that their interests were protected. And we'd seen the same thing. Earlier today, we discussed recalls in the drug industry and some of the powers of big pharma. Another area where our government was very active in standing up for ordinary citizens, in an area where perhaps more still needs to be done to ensure that the interests of ordinary citizens are protected. We can see a little bit this, of course, right now with the spreading of the opioid crisis. Have we really looked carefully at whether all the incentives are right, whether we are ensuring all the protections are there for consumers? And I think that's something that needs to be addressed at the federal level, but especially at the provincial level as well. So these are all important values that are at play here. But the bottom line has been, for us as conservatives, for us as people who are standing up for our constituents, that we want to be there for those consumers when they face those imbalances and those risks and stand up for them. Now, when you get to the auto industry in particular, I've had my own personal experience with this. I've gotten recall notices, and some funny things can happen. My most recent recall notice, I went to a dealership, and oddly, the mechanic who was working on the car refused to do the recall notice, suggesting to me I had to get my car detailed first in order to do it, because he wasn't happy with the cleanliness of the area where he would have to go work on this airbag.
Shocking.
Now, I have a Honda. It was a Honda dealership up here in Ottawa. And I've got to ask myself, why did that happen? And there was nothing particularly unusual about the situation. But what troubles me is that either there were incentives in place where he's being told, well, if you sell 10 car details this month, you win a trip somewhere or something. And he was trying to upsell, and here was his leverage and his chance to do that. Or perhaps there is an imbalance on the pressure on the dealerships to provide these recall repairs, and they feel they don't have sufficient compensation to do it, which goes to the amendment that is before this House that the Senate has introduced. And I don't know whether that amendment is exactly striking the right balance, but I do know that that amendment is obviously addressing what may be a very real issue. And my own personal experience is telling me that it was a real issue. Now, I don't want to leave anybody with an impression that I've got a problem with Honda. My car, 470,000 kilometers on it, outstanding. Wow. I'd buy another one, a Civic Si, when the time comes, which is probably coming relatively soon. High-quality vehicle, manufactured not too far from my constituency, and the constituency of the honourable member from Simcoe Grey. And it's an outstanding vehicle that's performed very, very well. But this recall experience, to me, tells me that there are still very real problems here, that we do have to do things to stand up for consumers, to ensure their interests are protected, to ensure that we do get the balance right. And I'm of the view that C-62 was a great step forward in doing that. And I'm also of the view that perhaps some of the initiatives in the amendment that comes from our friends over in the Senate may be yet another element in improving that one step further. It's certainly an issue, I think, that we have to find out what the right answer is for it. So this, to me, is a piece of legislation I have no problem supporting. It's in the long tradition of what we in the Conservative Party have stood for, and it is in fact a bill, of course, that we presented in the last Parliament. I'm happy to stand here and speak in favour of it and vote for it when the time comes. Thank you.
Questions and comments? The honourable member for Winnipeg North.
Thank you, Mr. Speaker. The member across the way spent a great deal of his time just talking about the importance of safety, and that's in fact what the legislation is primarily here for. And when you look at the Act, and I want to refer specifically to the amendment that's being proposed by the Senate, in which ultimately it's important for us to recognize that part of the Senate amendment would actually have the Government of Canada play a stronger role in terms of regulating commercial relations. If you read through the amendment, that is a very serious concern. Knowing the individual as well as I do across the way, I'm sure he would have some opinions on that particular issue. When we think of the Act, the Motor Vehicle Safety Act, and how important it is, and that we keep to the scope within that legislation, I'd be interested in knowing if he feels that we would be going in the wrong direction. I believe so. If in fact we were to start looking at ways to regulate commercial relations within this particular legislation, would he not agree that even though the intentions might have been good, but this is something that should be maybe rethought out and possibly even suggest that the committee, the Standing Committee, do that role in terms of looking at it specifically?
The honourable member for York Simcoe.
Well, I have to disagree with my friend because using his logic, we would not be able to support this bill. Because the consequence of forcing a recall and the way that our auto sector is structured these days means that a dealer, the one party, as he's saying, which is different than the other party, the manufacturer, the dealer is asked to correct the defect that has been established by the manufacturer. So the government is already inserting itself in determining that commercial relationship through that order. And what has been stated, and my own experience tells me, is that there is perhaps not a perfect balance. Whatever contractual arrangements those dealers have with the manufacturers, and again, there's also a question there about who's got greater bargaining power in that relationship and how do we evaluate making sure that's a fair transaction. No, I think that there is a problem there. We have to make sure that dealers, the local small businesses, and I know this government does not place great value in those smaller local businesses.
That's right.
But those local small businesses have to be treated fairly. They can't be left holding disproportionately the cost of a problem that's created by the manufacturer and be told that you have to live with that if you want to be a dealer. Because that's simply not fair, because those are unknown costs down the road that they have nothing to do with causing, but they're being asked to pay for. So any normal contractual relationship, any normal legal relationship would suggest there should be something there to correct that and make those who are responsible for the cost have to bear the cost. Otherwise, I put it to you, more and more people will get my experience. They'll show up with their recall notice and the car dealer is going to find some other thing, some other reason, some other way to try and recover that cost that they're going to otherwise have to bear for doing the recall repair in order to be able to pay for that recall repair, forcing, of course, individual purchasers, consumers, to pay for other unnecessary repairs or other unnecessary services so that that dealer is left whole financially from what they feel they're otherwise being treated unfairly on.
Questions and comments? We have time for a very brief question and a very brief answer. The honourable member for Winnipeg North.
Yes, Mr. Speaker, I don't agree with the member across the way. If we look specifically, the minister can order a company to correct a defect and can also order the manufacturer cover the costs of the remedy. That's what this legislation does. This protection is available to owners, including the dealers. So the argument that the member across the way is putting forward, I would say, is faulty at best. Would he not agree?
The honourable member for York Simcoe in 45 seconds or less, please.
Well, certainly what's been heard from the dealers is that that way that it's written is not sufficient, and the way it's working right now already is not sufficient to satisfy the relationship. As I said, I'm not sure the amendment has the exact wording right, but it's clear that people are not satisfied with what the legislation proposes. So it's an issue that needs to be addressed and needs to be wrestled with. And I think that's an important thing for us to look at, and it's a good reason for this to go and be evaluated more closely at committee after we adopt it at second reading.
Resuming debate, the honourable member for Lambton, Kent, Middlesex.
Thank you very much, Mr. Speaker. And I'm going to be splitting my time with a member from. Yes, thank you. Sorry, I missed that. It's indeed, as always, a pleasure and have the opportunity to stand in this great place and debate legislation that, in this particular case, we sometimes don't think much about, quite honestly. We go and we purchase a vehicle, regardless of whether it's new or used, and we take for granted that with the technology and with the expertise and with the workmanship and with the professionals that develop and manufacture the parts, and then they take those parts and they assemble them into a frame and into a body of a vehicle that we just take for granted. That this vehicle, when we open the door and push the button or turn the key, whatever it is, that it is going to run as often as advertised for a few 100,000 miles, and there will be warranty for a certain amount of time. And just about in many cases, that is the truth. That's how it works. But I think all of us have, at some point in time, opened the mail up and saw from whatever manufacturer of the company that has made the car that or truck or whatever we're driving, and you open it up and there's a recall on a particular part. Sometimes it is a part that they think may dysfunction and cause an inconvenience or put you on the side of the road. But on other times, that recall will have a safety precaution attached to it. That because of an ignition switch or because of something that flows with the fuel or because of a hose that runs a fluid through it or because of some other thing that may malfunction, there may be serious injury possible to those that own that vehicle. And often, sometimes, Mr. Speaker, we have heard of tragedies that have happened because of faulty mechanisms within the automobile or within the vehicle that we're driving. So, Bill S2 falls on the heels, so to speak, of Bill C62 that was brought forward in June of 2015 by then our Minister of Transport and who is now our Deputy Leader. And I think I want to say also to the Minister of Transport this morning in his speech, the acknowledgement of the work that this House has done, but particularly that the Deputy Leader did in bringing forward that bill, and that this one comes on the heels of it, and it is really just trying to make it better. And I think what you've heard in the discussions today in this House, Mr. Speaker, is that we in the Conservative Party of Canada, as with all parties, I think, really are concerned to make sure that the vehicles, these highly mechanized technology outfits that we get into every day, actually carry a high importance on our list. And so with that, you've heard that in terms of S2, that we're going to be supporting this. And so what are some of the things that make it important of why we are? The amendments that are coming forward, as not just the bill, but the Senate amendments that have come forward, I believe, are significant amendments and additions to this bill that will strengthen it and gives more security not only to the purchasers of the vehicles, but also to those that sell them to us and take that risk of having a recall put on them and then having to come up with some way, particularly, and I'll maybe talk about it more, is it the funding that they get reimbursed to replace the parts? I don't think so much as it is that if you get a safety recall, and when I talked to one of my dealers, you get a safety recall, that part is not available. But because it is a safety recall, They obviously can't, and nor do they want to, turn around and say to me or to my family member or to any other member, well, you just get back in the car and then when that part comes in, we'll replace it. That isn't, quite honestly, the way it happens, and nor is that the way it should happen. But it puts an awful impact, financial impact, upon now that dealer that has the responsibility of a vehicle that the manufacturer made. And he then has to either, from my understanding, Mr. Speaker, he has to do something to accommodate his customer. He has to do something of give him a loaner, or in some cases, I know is that, well, they'll sit down and we'll say, we know there's a back order, and we keep asking, but because it may have been a large recall, the number of parts across Canada takes them a while to get produced. And so I think at some point in time you'll make a deal and trade vehicles so the customer has a vehicle now that they're safe in and feel that they can drive. But again, now the dealer is left with this vehicle he or she cannot sell because it has a safety recall on it. And so as part of that legislative amendment that is in front of us, I know that the minister was looking at it in a bit of a different way, that this is actually about safety, not really about compensation issues. I think one of the strengths that we have and the opportunity that we have in this bill, though, is to take it and give it the breadth of significance that maybe is allowable with these amendments. And so, Mr. Speaker, I would support some of those ones. In 2015, for example, 5 million passenger cars were recalled in Canada. Now, whether the government, one of the issues is that now the government can force the recall. And I think at some point in time that's going to be an important part of what happens. Right now it's voluntary. I think we've been very fortunate in Canada that we have not had a serious impacts by not having the manufacturers do the recalls on a voluntary basis that are required. But I think at some point in time, the government needs to have some sort of recognition and authority when there is a default, particularly a safety one. So I saw you reaching down. Does that mean I'm just about out? Thank you. So that I think some of those ministerial powers, as much as, quite honestly, I always get concerned when I see government wanting to put a lot of oversight over top of our business, and particularly our small businesses that have to force this, that eat up those kinds of costs. But I think in terms of safety, I think that we have an opportunity in this bill to make things better. So, Mr. Speaker, I'm just going to wrap up with that. I didn't get into a lot of details, but as one of my colleagues talked about, we have a number of issues in front of us. Thank you. We have a number of issues in front of us in terms of innovation technology with driverless vehicles of all kinds. We have issues when we're talking about safety of vehicles. We're also compounding the issues on the road with the use of alcohol and now the proposed legislation that's going to come with marijuana and the effects of that's going to have on drivers. It's not just with drugs, but with drugs and alcohol. And I want to emphasize, Mr. Speaker, that the department, if they're going to move forward with this, the department has to have the resources to make sure that they can follow through with the enforcement that will come with this. And so with that, I look forward to having the opportunity of supporting this bill, but mainly the support is I want it to get to the committee, and that the committee will have the opportunity to look at not just the bill, but also the amendments that come with it, and make this as strong a bill as we can to protect all of our Canadian peoples, our friends and our families on the road. Thank you.
Questions and comments? The honourable member for Whitby.
Thank you, Mr. Speaker, and I'd like to thank my honourable colleague for his speech. And I think we can all agree that this is a good piece of legislation. And as he said, everyone is pretty much in agreement. And as it goes to committee, I'm just wondering if I could ask the honourable member, what sort of things do you think that the committee should focus on in addition to the legislation and the amendments with this particular piece of legislation?
The honourable member for Lambton, Kent, Middlesex.
Thank you. Thank you, my honourable counterpart across the way, and to you, Mr. Speaker. Those of us that have, as we've sat on committees, as my friend across the way has, when you start bringing witnesses in and talking to you, sometimes things that you haven't thought about pop up, and that's why we go to committee. Sometimes issues that we hadn't thought about or they were secondary, when you correlate them with something else, they actually can become a priority. I really think in one of the cases, Mr. Speaker, is that I hadn't really considered until I got listening to the debate today the significance of some protection to our small business owners and our dealers. These, in my area of Lambton, Kent, Middlesex, these are all family-run. These are family-run car dealers and businesses, and they rely on having some being able to pass on this, and you know, not to be rude, but many of them I'm getting calls from now are really concerned about the small business tax that is being proposed, and so I look forward to. I think the amendments that were there, many of them will get a lot of debate because they were brought forward after the original bill was considered. So I'll just leave it at that. Thank you.
Questions and comments? Questions et commentaires? Resuming debate, the honourable member for Peace River, Westlock.
Thank you, Mr. Speaker, and thank you to my honourable colleagues for giving me the opportunity to speak today on this bill, S2. Bill S2 is something that I have some familiarity with in the fact that before I came to this place, I worked in a Chrysler dealership, and I performed many recalls over the years. The interesting thing about the recalls is that there's no similarity between any two of them, and we often, as a mechanic that was having tasked with correcting the issue, we often wondered, like, why was one thing recalled and another thing not, or why was the same part often recalled several times in a row? And that goes to some of the issues that is trying to be corrected here. And I'm not necessarily convinced that this will correct it, because in some cases you are just purely not able to squeeze blood from a stone. Particularly, we've seen this now with the recalls on the airbags. And many automotive manufacturers use the same supplier for the airbags, and so it crossed several different companies when it came to the airbag recall, and so it's going to be interesting to see how this goes forward. I know that there's some anxiety that comes with that. My own vehicle has that particular recall on the airbag, and you know that it's going to. You keep getting the notice saying, hey, there's a problem, but we don't have a fix or we don't have parts for it. So that's ongoing for sure. It was interesting, particularly from the dealership perspective on the recalls. So I see we're talking about like the 1% of the price and things like that. Now there's games that get played with that 1% of the price, because if the same part you were purchasing at retail would be $150, if it was a recall part, which you couldn't order for a retail customer, but if it was coming through the dealership, it might only be $10. So you get the 1%, but it's 1% of $10 versus if it was the exact same part and you were ordering it for a customer, that same part would be $150 or maybe even more. Because it's the percentages that you put on there, it dramatically reduces the price to the dealership. So particularly parts departments, they run on percentages. Everything's a percentage. Typically, they have an 18% handling cost. Every part that comes through their dealership, they just go, if we get a part in and we ship it back out again or we sell it, 18% of that sale was the cost of us storing it, the cost of our employees, the cost to keep the lights on, and all these kinds of things. So there is a good, in the amendments that we were talking about, there's a good initiative to put the percentage in there. It helps with the local dealership, but it's always interesting in how the games that get played. And I think to some degree, the free market will have to work this out. In a lot of cases, the dealers have these agreements already with the manufacturers on how they're going to get paid for recalls, because recalls have been happening for a long time now, and so there's a fairly easy way of, it's a lot of these things have been worked out through the free market, and so I commend this bill. I think it's supportable. There's no problem with that, but I would just acknowledge that we might be coming late to the party in the fact that most recalls go off without a hitch. There's already vast agreements in place for it, and the free market typically, through the court system, often will demand a recall for this or that, whatever else. And often these recalls are worldwide or global recalls. So if something happens in one jurisdiction, the company gets alerted to the fact that, hey, we got a particular problem with this particular piece. The entire fleet of that vehicle then becomes recalled. And so they might discover a problem in Mexico and the vehicles up in Canada get recalled. That the companies themselves do that just to limit their liability on these kinds of things. So they are facing a lawsuit in one country, they don't want to have to face it in other countries until they will recall it. Where it comes to the dealership level, that's always interesting in the fact that things get downloaded all the time, or downloaded. The costs of doing business typically end up getting downloaded to the dealership level. In terms of, it's relatively easy to announce that there's a recall for something, but it's the dealership that deals with the customer, that faces the customer. So the manufacturer announces that there's a recall on this and says there's no parts. Well, we at the dealership level have to deal with the fact that customer, every time they get a notice, they may come to the dealership and say, hey, I got this notice, what does this mean? The dealership there then has to outline what the notice means, and a lot of times there'll be one or two notices before we actually get the parts. At that point, each time that the customer shows up at the dealership, that takes resources from the dealership. That instead of that service writer being able to deal with a customer that's bringing some money in, they have to deal with a customer that is just there for a recall notice, which they're not going to be booking an appointment or anything like that. So they're going to leave again without any cash flow coming to the dealership. And so there's a significant cost that is associated with doing that. So we need to ensure that our dealers, which are the network across the country, do get paid for the recalls that are put in place. Now, it gets interesting if the minister is going to be putting the recall in and if the manufacturer is saying it's not. That gets really interesting in terms of who pays. They're saying, well, the manufacturer will pay, and that's great. But we need to ensure that the manufacturer or somebody continues to pay the dealerships in terms of when it comes to a mandated recall by the minister. That's I think what my reading of the amendments come into play anyways, because there's a lot of the whole system for a recall is in place already when a manufacturer declares a recall. It gets a little bit more interesting if the minister is going to declare the recall. Can the manufacturer then at that point just say, well, it's the minister's declaring it, so the parts will be made available. We'll pay for the getting the job done, but we won't necessarily reimburse the dealership parts department or ensure that they actually can make some money on this, particularly in recalls that take a long time to develop the parts or develop the solution. Those are a lot of things. Now, we've been talking a lot about recalls into kind of the abstract. We just say the word recall. So I'd like to just talk about a couple of instances where I've performed recalls that I can think about. One particular issue was on a certain vehicle. If the window was left open, the rain could come in and it could, in the window switch, it would flood the window switch. It would cause an electrical fire in the window switches, and so we had to replace thousands of window switches. That's what a recall looks like. a particular piece could get rainwater in it and it could cause a fire, and so we have to replace that piece. Another recall that I did many of was in the windshield wiper system. There was one piece that could fall apart at some point, and so we replaced a lot of windshield wiper motors on a particular vehicle. You get really good at, because you do lots of them in a short period of time. And so, yeah, there we were replacing windshield wiper motors to prevent them from failing on the highway and you not being able to see where you're going. Another one that I can think of was a shifter recall in a particular car where the shifter might not actually go into park. When you shut the vehicle off, push the shifter forward, the shifter would say you were in park, but the transmission might not actually be in park. It could actually be in reverse, which could be bad. So we had to replace the shifter, or in some cases reprogram the computer in order to prevent that from happening. So those are some pictures of what recalls look like. No two of them were ever the same. It was always, sometimes it was a really big job. Other times it took, like the window switch one, for example, that literally took minutes. Like it took longer to drive the vehicle into the shop than it did to actually replace the part. Other times it was a really big deal. I can think of one particular recall where the subframe could rust and break. And so you were replacing a subframe underneath the vehicle, doing a wheel alignment afterwards and things like that. This is kind of a big deal. So I thought, just from my experience, I thought I'd explain that to this chamber as to what a recall actually looks like in terms of the guy that has to do it. And getting paid for it can always sometimes be a little bit of an issue, like I explained earlier, when we're dealing with percentages and the manufacturer just lowers the price so that they give you the percentage, but it doesn't necessarily mean that you can get paid. So those are my comments. I look forward to the questions. I do come from a little bit more of a practical experience, and so I look for the questions for sure. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Edmonton Riverbend.
Thank you, Mr. Speaker. And it was a pleasure to hear the well thought out and articulate response of the member from Peace River Westlock in response to this bill before us. He talked a lot about how his past as a mechanic and how he's fighting for his constituents. I was curious as to if he had the same experience that I had this past summer, where this wasn't necessarily the topic that people came in and talked to me at the doors and at the office about. It was all about the tax changes that this government's putting in place. And curious as if he had similar conversations like that, and if this bill should be that the priority that we're focusing on, or maybe perhaps we should be focusing on what the rest of Canadians are focusing on, and that's these tax changes that the Liberals seem to be jamming down our throat. Thank you.
The honourable member for Peace River Westlock.
Yeah, thank you, Mr. Speaker, and thank you to the member from Edmonton Riverbend for the question. I know that initially, in the beginning of the summer, I had several, hundreds of farmers coming to me over the cash tax deferral or cash ticket deferral system. That's how the summer started out, and it deteriorated from there in terms of the outrage on the tax system, particularly when it came to farmers who are looking to sell their farm to their son or daughter. That came out loud and clear. Then right at the last week that I was there, we actually had the Slave Lake Chamber of Commerce put together an emergency meeting with me just before I left for Ottawa, just to outline their concerns with the new proposed tax changes. There was nearly 100 people in the room, and they were very concerned about where we were going. And their number one thing that they said is, can the government do this? Can they do this? Can they just come in without listening and do this? That was a very disheartening place to be in terms of the fact that, yeah, they can just come in and do this without listening to what you have to say and changing our lives in northern Alberta significantly when it comes to the tax changes. Farming is probably about a third of the economy up where we live, and there's a lot of concern right now as to what does their future look like? They've spent lots of money on their succession planning. Their succession planning is a big deal. Anyone that comes from Northern Alberta knows exactly what the term succession planning means. And they've spent the money on it. They've hired the consultants and these kinds of things to see how are they going to transfer their farm to their children. And now basically that entire plan is up in the air as we go forward with the new tax proposals that have been put forward. And so there's deep concern in my riding as to where this is going to go. A lot of them feel like the carpet has been pulled out from under them. So thank you, Mr. Speaker.
I'm afraid we're out of time. It being 5:30, the House will now proceed to the consideration of private members' business as listed on today's order paper.
Private members' business, report stage for Bill S-231, Journalistic Sources Protection Act. Standing in the name of Mr. Deltel.
Report stage, the House will now proceed without debate to putting the question on the motion to concur in the bill at report stage. Monsieur Deltel, appuyé par...
Mr. Deltel, seconded by Mr. Nader, moves the Bill S-231, an act to amend the Canada Evidence Act and the Criminal Code, Protection of Journalistic Sources, as amended, be concurred in at report stage.
Is it the pleasure of the House to adopt the motion? All those in favor, please say yay. Oh, sorry. Oh, I'm sorry. Carried. I thought. Troisième lecture.
Third reading. Mr. Deltel, seconded by Mr. Nader, moves that Bill S-231, an act to amend the Canada Evidence Act and the Criminal Code Protection of Journalistic Sources, be now read a third time and do pass. Debate.
L'honorable député de...
The Honourable Member for Louis Saint-Laurent. Thank you very much, Mr. Speaker. This is not the first time that I've had the privilege of rising in this House to talk about Bill S-231, but each time that I do so with great emotion. I had the privilege of being a journalist for 20 years, and so I'm well aware of the perils facing the industry if journalists are not able to be completely free. That's why Bill S-231 would allow journalists to carry out their profession in a noble and safe fashion. So we're now at third reading of this bill, which means that if all goes well, and if parliamentarians agree, we will, in the next hours, days, or weeks perhaps, adopt this very important bill, which has a very interesting history. Let's remember, Madam Speaker, that around a year ago, there were problems in the journalistic world in Quebec. We learned that seasoned journalists had been investigated by police officers, and in fact, their iPhones, their tools for their job, were being tapped. Now, the job of the journalists is to inform citizens, and yet they were being monitored to far too great an extent. When the Lagacé affair was known, many other well-known, well-respected journalists in Quebec also learned that they had been monitored by either the Sûreté du Québec or the Montreal Police Services or even the RCMP. So Patrick Lagacé, Vincent Larouche, Alain Gravel, Isabelle Richer, Éric Thibault, Denis Rissard, Nicolas Sayot, Philippe Séguin, Marie Néron, Gilles Toupin, David Renaud, and Fabrice de Pierrebrou were just a few of the seasoned journalists who had worked in Quebec for years and who worked to collect information and to carry out their journalistic professions properly. But we learned that all of these people had been monitored by the police, and so there was a huge backlash in Quebec among journalists. And that is why, Madam Speaker, Senator Claude Carignan took the initiative to write a bill that would allow us to protect journalistic sources so that these people would no longer be hindered in their work. And the real genius of Bill S-231 is that it sets positive, clear benchmarks for journalistic work. This allows Canadians to benefit directly from the free press.
Talking about here is one of the cornerstones of our every democracy. We're talking about free press, the liberty of expression here, the freedom of expression here in the House of Commons, but first and foremost, all from coast to coast in this country by the protection of the journalist sources. So this is why, Madam Speaker, the quality of this bill tabled by the Honourable Senator Claude Carignan in the upper house a few months ago cleared the way and gave a clear mandate and clear signal to every whistleblower in this country: when you will talk to a journalist, you are free to do that, and no one will interrupt you in the process. This is a cornerstone of democracy. This is a cornerstone of the whistleblower. This is a cornerstone of journalism. So this is why, Madam Speaker, I'm so proud to be the godfather, can we say that? Le parrain en anglais, en français, of this bill here in the House of Commons, thanks to the studious and very well done by the Honourable Senator Claude Carignan in the upper house. Donc, Madame la Présidente.
So, Madam Speaker, now let's get to the heart of the matter. Why is this bill so good for the future of the free press in Canada, in our opinion? First of all, it's based on 4 important pillars. The protection of journalistic sources. And when I say journalistic sources, I'm not talking about protecting the journalist. I'm talking about protecting the source, the whistleblower, the person who wants to signal a problem to the journalist. So we're talking about the source. We also define who is a journalist, because it's all well and good to say, oh, I run a blog, I'm a journalist, but that's not true. To be a journalist, you need to meet certain criteria, which I will lay out later. And if a police officer wants to investigate, now, of course, that's what police officers do, but we are going to have Superior Court judges be able to give a mandate for an investigation to police officers. We're going to make that the new reality. And then we're reversing the burden of proof. So now it's police officers who will have to prove that they absolutely need to tap such and such a person's phone and not the other way around. So we define journalistic sources, we require superior judge authorizations, and we reverse the burden of the proof. And those are the pillars on which this bill is based. Let's study each one. First of all, the protection of journalistic sources. I said earlier something that is very fundamental. In the world of journalism, journalists do sometimes make mistakes, but if you want to have a robust investigation, you need to have the ability to speak to a potential informant and to be sure that that person will not be investigated by anyone with bad intentions. So the source is protected, but the journalist per se is not protected. Why? Because the journalist is just the vector, and the key person is the source, and that's why we want to protect the source. That's also why, Madam Speaker, journalists will be able to do their job properly when the sources are protected. Now let's define who is a journalist. As I said, sometimes people claim to be journalists, and that can lead to a certain amount of conflict. Straight off, in section 39.1, journalist is defined as someone whose main occupation is to contribute directly to the collection and publication of information through the media, or anyone who works with such a person. So it's clear, you can't just become a journalist overnight. You need to be affiliated with a serious media outlet that is recognized and established. So we clearly define that journalists cannot be just any old person. Now for us, Madam Speaker, that's essential. having been a journalist myself for 20 years, sometimes I would be frustrated to see people who claimed to be journalists when, in fact, that was not the case at all. There has been a very amazing transformation of the journalistic world, but of course it's easy to publish a blog on the internet, but that doesn't necessarily mean that you have the training and qualifications to be a proper journalist. Also, Madam Speaker, I said earlier that from now on, Superior Court judges would have to authorize permits for that would allow police officers to investigate. Now, we never want to prevent the constabulary forces from doing their work, and we don't want anyone to act with bad intentions. We want to protect whistleblowers, but at the same time we want to protect police officers who have to do their work. The difference, Madam Speaker, is that these people have even more moral authority when they do their job because they would have obtained the authorization of a Superior Court judge.
In some cases, for example, the Montreal local police, the Montreal City Police, how many times did they get warrants from justices of the peace? 98% of the time. 98% of those applications were granted. So what's the point of going before a JP if you're going to get the warrant virtually automatically? But with it comes to wiretaps for journalists and their sources, we need to make sure that it's done with an experienced judge. A Superior Court judge should be the one making that decision. That will give even greater power to the police in the performance of their duties. And that's one of the beauties of S231, which was put forward by Senator Carignan. So the source would be protected, but if the police officer has to investigate, the police officer will have greater moral authority because the warrant will have been issued by a Superior Court judge instead of a JP. And one final point is on the reversal of the onus of proof. And allow me to read page 3 of the bill. It says that it is up to the section 3 says that it is up to the person applying for the warrant to prove that it is necessary. So that's another great feature of this bill. When this bill was tabled in the Senate, it garnered a lot of interest from the media, but also from other observers, and allow me to refer to some of the people who are excited about this initiative. The Le Devoir newspaper congratulated Senator Carignan for achieving a virtual consensus among journalists in Canada. And the executive director of the Canadian Journalists of Free Expression Association said,
April the 12th, 2017, quote, Senator Carignan bill is the beginning of a full legal recognition of the role that journalists play in servicing the public and protecting democracy. The Liberal government must offer its complete support. Jusqu'à maintenant, c'est ce qui est arrivé.
And that's what's happened so far, and let's hope it continues as this debate wraps up. Let's hope the support remains. The editor-in-chief of the Globe and Mail said,
An enormous threat et donc une menace très forte.
So there was a serious threat in terms of protection of sources, and the Globe and Mail is very concerned about protecting sources as well. So this is third reading debate. This is a very important exercise. It's important to Canadian democracy.
To many journalists who have to work correctly and to have to protect the whistleblower. Those people all across this country, in the public service or elsewhere, who can't can see bad things happening, and who want to call the shot, who want to whistle the blower, like we used to say. But they must say that to a journalist with the clear protection that belong to them. So this is why, Madam Speaker, this bill is good. This bill is correct for journalists, but first and foremost, this bill is great for Canadian democracy. C'est pourquoi, Madame la Présidente.
And that is why, Madam Speaker, at this third report stage, third reading, we'd like to get the support of the entire House of Commons. So far, this has been a constructive and positive exercise. The committee looked at this. People expressed their different viewpoints. I myself was a witness in committee, and that's the first time I've had that experience, and I enjoyed it. And Senator Claude Carignan was the originator of this bill, and another senator, Senator Pratt, Andre Pratt, who was a journalist for decades, and he was editor-in-chief at La Presse, and he still, if I'm not mistaken, or at the end of his career, was, he was a very experienced journalist. I think he was recognized as an editor emeritus, and it was quite a pleasure to work together with those two senators on this initiative and to argue in favor of this bill and the protection of journalistic sources, especially because, Madam Speaker, this bill is the incarnation of what needs to be done to protect journalists and freedom of the press, which is so dear to our democracy. Thank you, Madam Speaker. Questions and comments?
Resuming debate, reprise de débat. The honourable member for Oakville North Burlington.
Thank you, Madam Speaker, for the opportunity to speak in support of Bill S-231, an act to amend the Canada Evidence Act and Criminal Code, protection of journalistic sources, otherwise known as the Journalistic Sources Protection Act. I'd like to begin by thanking the Senate sponsor for his diligence and hard work on this very important bill, which aims to ensure that the protection of journalistic sources is given due consideration whenever they are at issue in Canadian courts. I would also like to thank my colleague opposite, the member for Louis Saint-Laurent, for shepherding this bill through the House and his commitment to journalistic freedom. The bill has moved swiftly through the House thanks to the broad support from all parties. As we all know, this issue was brought to the forefront a little less than a year ago, following events involving the use of investigative tools targeting journalists, in particular revelations that police in Quebec had obtained warrants to monitor the cell phones of several journalists. Following this incident, the Quebec government reacted swiftly and amended its guidelines and safeguards for obtaining warrants that target journalists. As a result, journalists are now listed alongside lawyers, judges, and members of the National Assembly, for whom added safeguards and special protocols are in place in relation to warrant applications. In November 2016, the Quebec government also launched the Chamberlain Commission to study the issue of the protection of journalists' confidential sources. The Commission's hearings have recently concluded, and the Commission's final report is expected by next March. It is in this context that Bill S-231 was introduced last November. In essence, Bill S-231 proposes changes to the Canada Evidence Act and the Criminal Code to enact special regimes to protect confidential journalistic sources. The Canada Evidence Act proposals would create a unique regime applicable anytime the media wish to protect a journalistic source. This new regime would codify the common law developed and interpreted through several Supreme Court of Canada cases, while introducing some added protections. For example, the bill would place the onus on the person who seeks disclosure of the information instead of the person seeking to protect the information, as is currently the case. The Criminal Code proposals relate to how investigative tools, such as search warrants and protection orders, can be issued and executed when they target journalists. Although the goal of these proposals is to protect journalistic sources, the procedure would apply any time a journalist is targeted by an investigative tool. The bill also proposes a triage procedure that requires the sealing of evidence collected and a review by a court before the information is disclosed to the police.
Finally, the bill proposes that only Superior Court judges can issue an investigative tool in relation to a journalist. While the merits of the bill were debated in this chamber at second reading, members expressed support for the bill's laudable objective and for its solid foundation. Members also expressed the view that the bill could be further improved, bearing in mind the complexity of the law in this area. This bill is being reported back to the House today with amendments adopted by the Standing Committee on Public Safety and National Security. It was a pleasure to study this bill at committee, and I'd like this opportunity to personally thank my committee colleagues from this side as well as across the aisle for their collaboration during the bill's study. The bill as amended truly reflects a multi-partisan initiative. I will focus the remainder of my remarks on the substantive amendments made to Bill S-231 by our committee. With respect to the amendment to the Canada Evidence Act provisions, firstly, the Public Safety Committee deleted the override provision found in proposed subsection 39.12 from the Canada Evidence Act portion of the bill. The override provision was problematic because it could conflict with other federal legislation, including matters of privacy and national committee. We also didn't think it was necessary to give effect to the protections for journalistic sources contained in the bill. The committee also amended the test found in proposed subsection 39.18 of the Canada Evidence Act portion of the bill for the disclosure of information or a document that identifies or is likely to identify a journalistic source. In essence, Bill S-231 has been amended to replace the reference to, quote, the essential role of the information or document in the proceedings, end quote, with, quote, the importance of the information or document to a central issue in the proceedings, end quote, as this more accurately reflects the common law as confirmed by the Supreme Court of Canada. The committee also improved the bill by moving the condition added by the Senate at committee at paragraph 39.18C, which relates to whether due consideration was given to all means of disclosure that would preserve the identity of the journalistic source, to a new subsection 8.1, separate and apart from the test for authorizing disclosure. I think this should strengthen the protection since it ensures that the source's identity is protected as a separate step, even when the document in question is admissible. The Public Safety Committee also made a few, but in my view, important improvements to the bill's proposed changes to the Criminal Code. First, the committee amended proposed section 488.012 so that it would not apply despite any other act of Parliament. As I mentioned earlier, such an override provision is not necessary to give effect to the protections for journalistic sources contained in the bill and could conflict with other federal legislation, including in matters of national security. Proposed section 488.03 was also removed from the Criminal Code portion of the bill for the same reason. These are sensible amendments, and I agree with them. The committee also added a knowledge element to proposed subsection 488.012. As originally drafted, this subsection would have required that a warrant, authorization, or order relating to a journalist only be issued by a judge of a superior court, regardless of whether police were aware that their investigation relates to a journalist. This is problematic because in practice, for example, in relation to online crime, police may not know the identity of the person they are investigating. And if police do not know they are investigating a journalist, they cannot be expected to follow these new requirements that would have been imposed by Bill S-231 as introduced when obtaining a warrant, authorization, or order. I therefore agree with the amendment of proposed subsection 488.012 to ensure that it only applies if police know that they are seeking a warrant, authorization, or order in relation to a journalist. Importantly, the committee also amended the bill to add a new process to confirm the validity of a warrant, authorization, or order issued outside of Bill S-231's new regime. In other words, obtained in good faith under the regular process, in the event that an officer subsequently discovers that the target of the investigative tool is a journalist. According to this new process, once they become aware that the warrant relates to a journalist, police would be required to 1. Inform a judge of a superior court, 2. Refrain from examining or reproducing the evidence, and finally seal it until the superior court judge disposes of the application. The superior court judge would have the ability to confirm the existing warrant, vary it, and impose appropriate conditions to safeguard journalistic sources, or revoke the order if the judge is of the opinion that the officer knew or reasonably ought to have known the application related to a journalist. The importance of this amendment cannot be overstated because it allows appropriate measures to be taken to protect the confidentiality of journalistic sources, even in cases where a warrant was issued in good faith outside of Bill S-231's regime. Finally, Madam Speaker, the last key amendment made by the Public Safety Committee is the addition of new subsections 4.1 and 4.2 to proposed Section 488.01 of the Criminal Code to ensure that the new test for the issuance of warrants, authorizations, or orders relating to journalists does not apply when the application relates to a journalist's criminal activity. This amendment recognizes that it should be more difficult for police to obtain a warrant against a journalist if that journalist is engaged in criminal activity. Madam Speaker, I believe that these targeted but important amendments are perfectly in keeping with the spirit and important objectives of Bill S-231, and I hope that all members support this bill as amended with bipartisan support by the Standing Committee on Public Safety and National Security. Thank you, Madam Speaker.
Resuming debate, reprise de débat, l'honorable député de...
The honourable member for Abitibi-Temiskaming. Thank you very much, Madam Speaker. I'm happy to have this opportunity to speak to this because there's a background in Quebec. Quebec media revealed last spring that some journalists had been subject to police wiretapping. Their phone calls were monitored. People were shocked to learn this, and the more you dug into it, the more it became apparent that Patrick Lagacé was one journalist who had been wiretapped, but others had two. So it wasn't just an isolated case and a short period of time. A number of journalists were wiretapped over 4 to 5 months, including Alain Gravel from Enquête. So it was a big problem. And it was widespread and ongoing. So many people were shocked by the news. And after some hesitation, the government of Quebec decided to strike a commission on the protection of journalistic sources. So on November 11th, 2016, that commission was set up. I think it's important to remember that other steps were taken by the National Assembly, including a motion, a unanimous motion, declaring that the protection of sources is a principle that the National Assembly believes in, an important principle. And so the commission was launched, and the Quebec Justice Minister said that the news was serious enough and the public confidence in public institutions was essential. So that's the very principle, the underlying principle. And I think it's important to remember that. We're talking about protecting journalistic sources. It's a matter of public confidence, public trust in our institutions. You have to understand that many scandals have been uncovered by journalists. They do hard work. They rely on sources. If they didn't have anonymous sources, if they couldn't guarantee their sources anonymity, the sources would have never spoken out, and we might never have, those scandals might have never seen the light of day. That's why it's so important. These things have to be revealed to the public. That helps us as a society move forward, to progress. That makes our democracy much more sound and healthy. Without journalists, unfortunately, there might be a lot more wrongdoing that goes unpunished and undetected. So journalists often rely on sources who put themselves at great risk. If their names were known, they would be put at great risk. And we know that police do surveillance, they do wiretapping, but that work has to be carefully limited. The commission I referred to has a mandate to make recommendations on police practices, on the protection of sources, and the ways of doing that. So I think that under that mandate, some interesting things will come out of that commission. And the bill we have before us today covers about 75% of the problem, but I think it will be important to follow up on what is learned from the Quebec experience, what that commission comes up with, so that we can really come full circle and perhaps some other protections and safeguards will prove necessary. So that's what was going on in Quebec, and you have to understand that given all that background, the federal government was called upon to react. The problem was a serious one, and since the federal government didn't want to launch its own commission of inquiry on the protection of journalistic sources federally, because they said, well, we don't have that problem federally, so I think it's important to react. It was important to do something about the problem. So this bill was tabled in the Senate, S-231, but you have to understand that it's based on previous legislation that was presented 10 years ago. Unfortunately, because of our parliamentary process, which at times is not necessarily very efficient. So 10 years ago, there was an attempt to fix this problem, but because bills die on the order paper with prorogation and so on, the bill never made it all the way through. And in 2007, there was unanimous support already among all political parties to deal with this issue, but unfortunately, it was never done. And then these revelations came out subsequently, and we learned that there was spying on journalists over a period of several years.
It's very unfortunate. However, I want to call attention to the work that M. Ménard did 10 years ago on the matter of protecting journalistic sources. The bill that we currently have, S-231, takes up most of the measures that had been suggested in C-426 10 years ago, but still adding certain other measures that are updated and that are connected to other legislation to ensure that journalistic sources were protected and that those protections are up to date. I would like to explain just how important it is to understand these revelations. Canada, after journalists revealed that they had been spied upon, fell to 22nd place in world rankings for freedom of the press. That was a reduction of 14 spots. That had an extremely negative impact on Canada's image, which was seen to be a country that is relatively free. And yet, sources were being spied upon. What really made me angry was the length of time. We didn't spy on people for a short time because we thought that maybe they were in contact with a few people. It was 4 to 5 years, 4 to 5 years, where people's conversations were being listened to as they spoke to reporters. We had the details of their lives. I think that that does not make any sense at all. We didn't target a certain period. It was basically a broad-ranging attempt to collect information. When we see what happened before, Well, the first thing we have to tell ourselves is maybe we should have pushed 10 years ago to solve this problem. Now, it is 10 years later, and really, I think it is essential to pass this bill. It's not going to solve the entire problem, but I think it will solve at least 75% of it. That is why we cannot allow parliamentary procedure to cause us to not act on this issue. It would have been good if the government had presented its own bill to solve this issue. That's not what happened. This is a bill that is a private member's bill. However, I think we can no longer allow ourselves, for Canada's public image, to no longer act on this question. The freedom of the press is a fundamental principle in Canada and Quebec. I think that reporters deserve to know that they can do their work without being spied on, that they can do it freely. I believe that the citizens in Quebec and Canada deserve to know that when they talk to a reporter, they are protected. When we recall that recently in 2013, it was because of a source that there were EI quotas, and that investigators had quotas to meet, money to go get from people who were unemployed. But if the reporter had not done that work, if the source had not been guaranteed their anonymity, we might never have known. And I think that the public good would not have been protected. That is why it is important to protect our sources. Otherwise, people will no longer dare to blow the whistle on certain situations. And when people are afraid to divulge what's going on in certain situations, that leads to consequences where we no longer advance, and democracy is the loser in that situation. Protecting reporter sources is intimately linked to democracy, and I think it is essential to act on this matter now, and I hope we will do it once and for all and not have another 10-year delay.
Reprise de débat. The Honourable Parliamentary Secretary to the Leader of the Government in the House of Commons.
Yes, thank you, Madam Speaker. And, there's a few thoughts that come to mind right away when we're debating this Bill 231. And one of those thoughts is that just, in reflecting on Arnold Chan, and some of the things that he advocated for was to bring people and bring parties together in terms of what sort of things and how we can improve things if, in fact, we work together. And this bill going through the committee process demonstrated just that, where we actually were able to take a piece of legislation and improve the legislation by individuals with respective parties working together, ultimately seeing an amendments brought forward, which has actually improved the piece of legislation that we're debating here today. Freedom of press is something in which we should never, ever take for granted. We understand that it is one of those fundamental pillars to good governance, to the whole issue of democracy. When I was first elected back in 1988, I quickly found out the important relationship between the media and politicians. And I won't go over the stories that had taken place, but there were some embarrassing moments. And at that time, I had maybe some different thoughts about the media, Madam Speaker. But I can honestly say today, with the experience that I have encountered over the years as a parliamentarian, whether it's inside the Manitoba legislature or even here in the House of Commons, just how important it is that we have an independent press, a press that feels that they have the freedoms to be able to do what's necessary in order to be able to ensure that there's a higher sense of accountability through the media on a wide variety of different issues that come, whether it's within the political realm or any other realm that assist in terms of things in which media representatives will report on. In fact, I know that when the issue first surfaced You know, this is something that I guess if we were to narrow it down, it's already been made reference to, was an incident where we had the police officers in Quebec which had obtained warrants to monitor the cell phones of a fairly well-known, respected journalist and a number of others. And the particular journalist that garnered a great deal of attention was Patrick Lagage, probably pronounced Lagesse. My French needs a lot of improvement, but it's amazing what I found on Google lately. But anyway, Madam Speaker, in looking at that, I think that there was an instant reaction from coast to coast to coast that something is wrong here. And, you know, it didn't take long for things to kind of come together where, whether it was inside the House of Commons or it was outside in the many different communities that realized that this action that was taken was a serious offense against a profession that we need to ensure has that sense of independence, that has the ability to protect our sources. You know, my colleague from across the way said he was a journalist, I think, for 20 years. And I'm sure, you know, he speaks from experience in terms of just how important those sources are. I can't tell you how many times I've had a journalist come to me and say, well, you know, what about off the record? What are you prepared to share with me? And sometimes it's important to have those off-the-record discussions to give some depth on the issue at hand, whatever it might be. Always be careful, I must say, if you go off the record, but you will find that there are incredible reporters over the years that will often approach individuals and want to have that because they want to be better informed, have a better sense in terms of what is actually taking place behind the story. Well, equally, when you take a look at some of the issues that are out there that are so critically important for the public, I would ultimately argue, to become aware of, well, those sources of information that have been provided are absolutely critical in terms of being able to make the public aware, and those sources do need to be protected. And I would argue ultimately that a vast majority of Canadians would recognize the value of a free press. It's one of the things that we should never, ever take for granted. And I think that's one of the reasons why, you know, when we take a look at our Prime Minister and one of the issues that the Prime Minister has is making sure that there's direction coming from the government through the different ministries, and he often will see that sort of direction being taken in those mandate letters that are issued to the ministers. And within the mandate letter that was issued to the Minister of Justice, and I know that I have it here somewhere, Madam Speaker, the Minister of Justice mandate letter, where the Prime Minister tasked the Minister to ensure that the rights of Canadians are protected and that the guarantees set out in the Charter of Rights and Freedoms are in fact respected. The Minister recognizes that the freedom of press is fundamental, a Canadian value stated in the Charter. Moreover, back, Madam Speaker, in the spring or late spring of this year, May 3, during question period, the Prime Minister himself made a fairly clear statement here in the House that the protection of journalistic sources is something that our government strongly believes in, Madam Speaker. So it should surprise no one that we have a government that very much understands just how important the issue is. And we are striving, and we saw good work done by the Standing Committee upon listening to possibly some of the reflections in the previous debate, reviewing some of the incidences that have occurred, including the one that I cited earlier, and coming up with ways in which we can improve the system. And that's the way in which I am looking at Bill S-231. And, for all of those individuals that I've named, and most of which I have not named, I applaud their actions because, as I've indicated, we should never, ever take some of those fundamental issues for granted, that we do need to stand guard and protect our whether it's democracy, our free press, those fundamental pillars that ultimately make Canada the great country that we are. Madam Speaker, we have seen a great deal of change in the journalists and the way in which media report. I made reference to the days in which I was first elected. I could remember sitting inside the Manitoba legislature and looking into the press gallery, and you would see representatives of all different Main Street media being there. And whether it was 3 reporters from the Winnipeg Free Press, 2 from CBC, CTV having a reporter there. At the time, I believe even Global had a permanent reporter, the Winnipeg Sun, and there were other media outlets that were there. Back then, you didn't have the blogging, the internet or social media. And I appreciate the member talking about what a lot of people question. What is a journalist? Because today, with issues like fake news and so forth, there is a great deal of concern about that. I appreciate the member across the way recognizing that, and even us within this legislation recognizing that there is an honorable profession of journalism that have very high standards. And when we talk about some of those very basic, ensuring, a journalist to me is someone that's their major source of income. That's an important component to being a journalist from my perspective. Another important component is that there is some sort of a main media outlet that they're actually employed by or owned and operated by, Madam Speaker. Those are important things. We need to recognize there's a difference between CTV National and Joe Blow on some blog that proclaims that that he or she is a journalist. So I appreciate the debate that we've had here today. We look forward to an ongoing debate on the issue, and I thank you for allowing me to share a few words. I believe my time has more than expired, possibly. Thank you, Madam Speaker.
Reprise de débat, resuming the honourable member for Hamilton West and Castor Dundas.
Thank you, Madam Speaker. And I as well am pleased to rise this evening to speak with respect to Bill S-231, which is essentially protecting the confidentiality of journalist sources. And I wish to commend the member from Louis St. Laurent, who I know is very passionate about this. And it was very good to hear him have the opportunity to speak today about this and to express his passion. Freedom of the press is a fundamental Canadian value that's protected by the Charter, and our government supports this and will defend Charter rights. And we know that journalists play a key role in ensuring that Canada remains a free and democratic society. And so, as my colleagues have said, we will be supporting this bill with the amendments made in committee. Now, what this bill does is it protects journalists and their sources, and that's the distinguishing factor here, Madam Speaker. In Section 2B of the Charter, we know that journalists are protected, but case law has demonstrated that their sources aren't protected. And so this is part of the reason why the need for this has come forward, because we do think it's important to protect the sources of journalists. Now, why is this important? Well, there's a number of reasons, but I think the main thing is that it enables us to get closer to truth. And we know that journalists have sources that are reliable, but that would hesitate to come forward if they knew that their names were going to be attached. And I think it's important to note here, that's not because it's sneaky or it's inappropriate. We have to recognize that certain risks and costs are taken that are not really fair, and that the person is coming forward really in the interests of truth, but they need to have that assurance. Now, how I could relate this to my own life, because I unlike the member, I was not a journalist and have never taken on that role, but I was a chaplain in a high school. And I had students that would come to me, and you know, over the years we formed beautiful relationships in terms of trust, friendships, and those sorts of things, where, you know, if there was any issues or anything that a student thought that needed attention, they may come to me. Now, the importance for them, Madam Speaker, was when they were going to share certain things with me that would be the interest of the community. Things like, okay, miss, a fight's going to break out after school. It's going to happen in the park, you know, a half a mile away. They could tell me that, but they would only tell me that if I promised that I wouldn't say where my source came from. Now, was what they're telling me important? Absolutely. Did I then notify the authorities so that the police would be there and there would not be a brutal fight? Exactly what I did. Did it prevent that fight from happening? Yes. And there's many other examples. And some of these examples are very serious. They dealt with mental health issues where there was self-harming happening. And students would come to me in the interest of protecting another student, in the interest of saving that other student's life. But they would say to me, they'd say, Miss, you cannot reveal where you got the information. And I could give them that assurance, and I could follow up, and I could reach out. And at the end of the day, justice was served, and help was offered. And it was a good thing because I had that right. Now, journalists, their goal is a little bit different, but they are after truth, and they want accountability. They want to have Canadians informed. And this is very important for a free and democratic society. We want Canadians informed as well. We as a government want to be accountable. To those constituents, I say, that have said to me, Phil, we want you to go in there and we want you to make a difference. We want you to be honest. We want to be able to trust you. It's exactly what I wanted to deliver. I want to deliver to each and every one of those constituents. I want to restore their faith. That's why I'm here today. So, with respect to this issue of ensuring that journalists get information that they need in order to keep us accountable, we as a government want to do that. We want to be held to account. We want to ensure that if an investigation needs to happen, that we have the information that will lead us to that investigation. We don't want that information to be held back, because at the end of the day, we know that all Canadians are going to benefit from that. Now, with this, there's many things this bill does, but the one thing I want to focus on next is the test. The test that is used. Now, essentially common law, we have the common law that would apply in the situation of where we're talking about a journalist's source of privilege. And the common law uses what they call the Wigmore test. The Wigmore test has 4 criteria. 1, the communication must originate in a confidence that they will not be disclosed. 2, this element of confidentiality must be essential to the full and satisfactory maintenance of the relationship between the parties. 3, a relationship must be one which, in the opinion of the community, ought to be diligently, deliberately, and consciously fostered. And 4, the public interest served by protecting the identity of the source in this particular case must outweigh the public interest in getting the truth. Now, what Bill S231 does is it, in fact, codifies and simplifies that legislation. So now we're not into conflicts and wondering what test. The test here is simple, and it's the administration of justice outweighs public interest in preserving the confidentiality. So it simplifies and codifies. We don't have to go back to the Wigmore test. The other thing is that this also applies to warrants. And what the bill does is it also includes conditions with respect to warrants. So now you have the opportunity that if a warrant is granted, that material that's granted can be seized and held until a decision is made. So this ability to build in conditions in the warrant is important because the warrant can be issued, but the conditions can be set. And the third thing I'd like to talk about here is, and this is a very important thing, and it's very different, and now is that the onus shifts. So now the person that has to prove this is the person that wants the information disclosed. And I know that journalists are going to appreciate this and value this very much. So at the end of the day here, what we have is that this bill puts in place a robust and unprecedented protection for journalist sources by clarifying the test, by preventing conflict of interest law issues, and by ensuring that new safeguards will only apply in appropriate cases. So I'm very pleased about this for journalists. I want to encourage journalists and impress upon journalists today how important that we as representatives, as members of Parliament, believe their job is. They are doing a very important job. We want to help them do their job well, and we think that this legislation will help them do that. Thank you.
Reprise de débat, resuming debate. Before I acknowledge the next speaker, I just want to advise him that unfortunately he won't be able to complete his full allotment. The honourable member for Newmarket, Aurora.
Well, thank you, Madam Speaker, and it's an honour to rise today to speak again on Bill S-231. And I recall the last time I spoke in the House, I think it was at second reading in May. My time was also truncated, so but perhaps we'll be able to get what I need to say in the short period of time that we have here. Madam Speaker, this bill came to this House by way of the sponsorship from my good friend from Louis Saint Laurent from the other place. It's being debated here in the last few minutes of private members' business on our second day back after we're being in our constituencies for the summer. But these facts, Madam Speaker, these facts shouldn't belie the importance of this bill, Madam Speaker. This is a fundamental bill. This will be a fundamental underlining of what we see as important to Canadians and as Canadians, Madam Speaker. This bill fundamentally is about democracy. And democracy, Madam Speaker, it has been said, is the worst government except for all of the other types. So what we have to hold it dear. We must cherish our democracy. And our democracy, Madam Speaker, isn't going to remain strong and robust if the good people here in this place and throughout Canada stand idly by and do nothing. Democracy, like all that we love, like all that we cherish, must always be nourished. It must always be improved, Madam Speaker. And I think this bill, at its essence, improves our democracy. And why is that so, Madam Speaker? It's so for many reasons, but let me take the brief time I have to elaborate on one or two of them. I believe it was the British Member of Parliament, Lord Macaulay, who first said, the media is the fourth pillar of democracy after the executive, Parliament, and the judiciary. The media plays just an important role. Well, none of us here today would imagine democracy could exist without Parliament. None of us here today could possibly fathom democracy without an effective judiciary. None of us here, Madam Speaker, would even dare to dream of government or democracy existing without an executive answerable to Parliament. Well, Madam Speaker, I suggest a robust media is as important as these other three branches of government. And without, Madam Speaker, the protection of journalists and journalistic sources, there can be no free media. Make no mistake about it. That is how democracies die in this world, Madam Speaker. When journalists can't do their job, when journalists can't speak truth to the people that send us here, when journalists are afraid of the state, when journalists fear for their safety and the security of them and their own families, Madam Speaker, this is what we're talking about here. We need to make no mistake about this. Bill S-231, at its essence, is the foundation of democracy, and I urge every member in this House to support it. It's a fantastic piece of legislation. It's been amended in committee. This is what we need to support. This bill highlights where democracy meets, where the law meets, where journalism meets, all important and fundamental principles of our free society. I professionally am a lawyer, Madam Speaker, and I am entitled to privilege. Lawyer-client privilege is one of the most sacred tenets of our law. I couldn't possibly have done my job as a lawyer without my client having the full and utmost confidence in knowing whatever they said to me, I could never tell another soul. That, Madam Speaker, fosters truth. That, Madam Speaker, is how people can be confident in the system, how people can be free to say what they need to say. Well, I, for one, Madam Speaker, as a lawyer, don't think that privilege is any more important than the same privilege a journalist has when they're speaking to their sources. How will the wrongs of the world be righted if good people don't have people to speak to and explain the wrongs, Madam Speaker? Those journalists take those stories of woe and corruption and fraud, and bring them to the people. Without journalism, these stories do not see the light of day, Madam Speaker. And not only will these stories die, Madam Speaker, not only will the people who want to tell the stories potentially die, but I suggest, Madam Speaker, democracy itself will die, and I, for one, will not stand by and let democracy die. I urge all members to support Bill S-231. Thank you, Madam Speaker.
À l'ordre, la période.
Order. The time provided for private members' business is now expired, and the subject will be dropped to the bottom of the order paper.
In accordance with Standing Order 38, a motion to adjourn the House is deemed to have been made and seconded at this time. Therefore, the question is that this House do now adjourn. The honourable member for Nanaimo, Ladysmith.
Thank you, Madam Speaker. I'm following up on a discussion with the Minister upon the announcement of their great pride in their new parental leave provisions. And my question, this is now at least 6 months ago, was when is this government going to implement legislative measures that will actually help women on the ground, help families on the ground? This was a measure that appeared to be targeted more at the wealthy parents needing extra parental leave, and it was a disappointment that it did not actually put more money in the pockets of young families. Today, I tabled an interim report arising from the evidence that we've been hearing throughout this year at the Status of Women Committee on the imperative to close the legislative gap for this federal government to do everything that it can to remove barriers to women's economic success, to bring economic justice for women. We heard a lot of testimony at this committee that has described a cycle that young families and young women in particular get into. Not being able to find childcare, affordable childcare, a family will have to make a decision about which parent will drop out of the workforce in order to accommodate that new family pressure. And because we still do not have federal pay equity legislation, it tends to be the female parent that is the one that earns the lower wage. And plus, traditionally, women continue to do a disproportionate share of unpaid care. And so it's the woman that drops out of the workforce generally, and when she re-enters the workforce, she is more likely to take on part-time and precarious work. for which there is no social safety net around unemployment insurance. We still do not have unemployment insurance that is designed for the shorter periods of work that part-time positions do. And we certainly know in Canada, with the loss of good manufacturing jobs and full-time positions, there's been a real movement towards short-term contracts and precarious work. It particularly affects young women and young people generally. And then we see later in life, women are more likely, because they have been lower wage earners throughout their careers, more likely to retire with less savings, and especially if their marriage ends, they are particularly vulnerable to retiring in potentially in poverty. Now, this is illustrated in my own riding. I heard this summer Samaritan House, which is a wonderful group doing very hard work in Nanaimo. The homeless women at their shelter, 50% of them are now over the age of 50. These homeless shelters are designed around bunk beds. The women cannot climb into them. In my own family, my sister Claire had to leave Toronto because for her and her husband, childcare was more expensive than their rent. We've heard these stories again and again. And so I ask again to the government, what is it that you are going to do with your legislative power in this House to remove those barriers to women's economic prosperity? If you're really a feminist government, please walk the talk.
I just want to remind the member that the questions are to be addressed directly to the chair and not to the government. The Honourable Parliamentary Secretary to the Minister of Innovation, Science and Economic Development.
Merci, Madame la Présidente.
Thank you, Madam Speaker, and I thank my honourable colleague for her question. My colleague has stated that our government is not keeping its promises and that it's not supporting Canadian families. My colleague, respectfully, is wrong. Since we came to power, we have implemented measures that have made all programs more flexible and more inclusive, including the Employment Insurance Program. Allow me to tell you about some of the improvements that have been made to employment insurance. Budget 2017 proposed a modification to the Employment Insurance Act to make parental benefits more flexible. Parents will, from now on, have two options. First, to receive parental benefits from employment insurance for up to 12 months at the current rate, which is 55% of their average weekly income, or receive parental benefits for an extended period of up to 18 months at a lower rate, equivalent to 33% of their average weekly income. Parents will, however, still be able to share the benefits. Furthermore, pregnant women, if they so desire, will be able to ask for maternity benefits up to 12 weeks before the due date. This represents an increase over the current standard of 8 weeks. Furthermore, Budget 2017 offers more inclusive benefits for caregivers. A new employment insurance benefit will be offered to eligible Canadians for a maximum of 15 weeks so that they can provide care and support to an adult member of their family who is seriously ill. This is offered in addition to the existing compassionate leave benefit for people who are caring for a seriously ill family member whose life is in danger. Madam Speaker, the most important thing in this debate is that Canadians themselves actually inspired some of these improvements. Last year, our government led a consultation with Canadians, and we organized roundtables with various stakeholders. So we were able to get their opinions about how parental and maternity benefits could be offered in a more flexible manner under the Canada Labour Code. And they also gave us their opinions about more inclusive caregiver leave and benefits. We listened to Canadians and we did what they said. That's the way we do things, Madam Speaker. we always make people our priority. It's also important to mention the Canada Child Benefit, which has been offered since last year. It's one of the most important programs of its kind in a generation. Thanks to this benefit, 9 out of 10 Canadian families now receive better financial support. There is no doubt that we are not only supporting Canadian families, but we are building a stronger middle class. Thank you, Madam Speaker.
The honourable member for Nanaimo, Ladysmith.
Madam Speaker, I would suggest that the extended parental leave provisions would have had more impact on Canadian families and Canadian women in particular if they actually had added more money into the fund. In this case, you are allowed to now have parental leave living on just 1/3 of your salary. It really only benefits the wealthiest Canadians. I also draw the minister's attention to a lot of the testimony we had from a huge range of witnesses at the Status of Women Committee, saying again and again that the EI system, because it's based on the number of hours worked, it's discriminatory to women that work on a more short-term basis. And so again, we call on this government to actually implement a true feminist agenda by legislating pay equity, by making affordable childcare universal, so that when you get the child tax benefit, you've got somewhere to spend it. To introduce the legislation promised to allow domestic violence leave for women in the workforce. We need to legislate to show we care.
The Honourable Parliamentary Secretary. Madam Speaker, we are keeping our promises and we're maintaining our commitment to help all Canadian families. As part of Budget 2017, we announced various measures aimed at helping the middle class and those working hard to join it. As an example, Budget 2017 proposes making maternity and parental benefits more flexible and caregiver benefits more inclusive. We know that it's not good enough to broaden the scope of EI benefits to improve quality of life in the country. That's why we are also investing in social infrastructure, and we're putting more money in the pockets of Canadian families thanks to the Canada Child Benefit. Madam Speaker, we are improving the quality of life for all families in Canada. Thank you.
The honourable member for Windsor West.
Thank you, Madam Speaker. I rose in the House Commons on September 19th of 2017. I rise again in the House to talk about the sale of Norsat, a Canadian-owned company, to Hytera, which was a Chinese company that has created many concerns, Madam Speaker, related to not only just foreign control and ownership, but also sensitivities of national security and also Canadian investment, with Canadian investment being tax credits and other types of investments to grow Canadian technological industries. It's important to note that these subsidies should be bearing fruits of jobs and innovation in Canada, and then for that to be plucked by a Chinese firm is an issue in itself. But most importantly, Madam Speaker, is when we had two former directors of the Canadian Security Intelligence Service, Richard Fadden and Ward Alcock, have said that the transaction should have been subjected to a full-scale security review that this government did not do, is very disconcerting. And Madam Speaker, this sale of Canadian company, I want to note important what they do. So Norsat, what they do is that they actually have communication solutions and provision of services for not only government organizations, militaries, transportation, resource, marine industry companies, news organizations, public safety and search and rescue operators, and others. Basically, they have two main segments, Sinclair Technologies and Satellite Communications. And, Madam Speaker, this is important because they were purchased by Hytera, a Chinese state company, that now has control over these advancements in technologies. The U.S. has very much expressed concerns with regards to this takeover. But I would add, Madam Speaker, what's happened in the meantime is that we can only see the challenges faced by the use of this technology and services and then the lack of leverage we now have with regards to issues for international developments. It is quite obvious the United States is concerned with regards to China's relationship with North Korea. We all have those concerns as well, too. But we do know now that Canadian technology is now again gone to a state-owned enterprise in the Chinese government. Having connections with their companies and being a communist nation, it certainly has control over some of the industrial development there. And it's important, Madam Speaker, this is not new for it to be raised. Interestingly enough, I raised these concerns and worked hard for a number of years to get a security review of these transactions related to national security lenses. The government failed to do so in this case, which has been suggested by many people within the industry itself and within experts in the field. So that actually was opened up because we actually launched a campaign in the past when we had Chinese investment and other non-government and non-democratic governments purchasing Canadian companies. And so the sale of this firm, being Norsat to Hytera, was interesting in the sense that, Madam Speaker, while it was going on, the Conservatives rejected it, the Liberals opened the doors for this, and also Motorola in the United States, there was hearings about a number of different patent and other infringements that took place. So my question to the government was to why we would want to allow Canadian companies to basically be usurped in this way without full security reviews.
The
Honourable Parliamentary Secretary to the Minister of Innovation, Science and Economic Development. Thank you, Madam Speaker, and I'd like to thank my honourable colleague for his question, as well as for his work on the Indu Committee, where we sit together and we cooperate well together. I'm happy to answer his question and comments from the member for Windsor West concerning the issue of the Investment Canada Act and national security. Let me first of all point out that foreign direct investment, or FDI, plays an important and positive role in the economy of Canada, contributing to the development of research, to increasing productivity, and creating better paying jobs for Canadians. In fact, trade and FDI go hand in hand and connect Canada to the world value chain. As such, Canada is and must be open to FDI, which contributes to job creation, growth, and long-term prosperity for Canadians. However, we will not compromise national security for investment, no matter what. The Investment Canada Act plays an important role in protecting Canadians against threats to national security. The Act allows the government to review investments made in Canada by foreign investors in order to limit the potential harm to national security. This government's practice is clear and consistent, Madam Speaker. Last year, we published guidelines in order to be transparent about how we enforce the law. All foreign investments, regardless of the size and regardless of the investor, are subject to a review to determine all potential national security concerns. This rigorous review is in a number of stages and is conducted by national security organizations and in consultation with Public Safety Canada, the RCMP, the CSIS, or the Canadian Security Intelligence Service, and CSEC, the Communications Security Establishment Canada organization. These are the organizations consulted on a national security review. The government takes this very seriously, and that includes protecting national security as part of a FDI review. The member for Windsor West has raised the issue about a recent national security review, which was covered by the media. The Act limits the amount of detail that can be revealed And those limits are important to prevent trade injuries to Canadian business and to prevent unduly compromising national security. However, I can answer the question in general terms. Let's shed some light on this. The current government did not revoke a government order, a cabinet order, or an order in council. After over a year of litigation challenging the legality of the previous order, if it had been struck down by the court, that would have left no measure in place to protect national security. So the current government consented to a court order which enabled us to proceed with a new review consistent with the Act.
For Windsor West.
Thank you, Madam Speaker. Thanks, the Parliamentary Secretary. He is battling a cold, so I appreciate him spending time here this evening for this debate, which is very important. And I would just highlight, though, Madam Speaker, a couple points that are important is that it seems odd in a country like ours that we're concerned about the court system and not winning in it to actually look at national security protection for Canadians and jobs against a non-democratic government. I think that's important that we look at that lens. And Madam Speaker, the concerns that I've raised, we're part of the U.S.-China Economic Security Review Commission that raised this in Washington. And as well, too, Madam Speaker, at the time of this, security officials had recommended against the takeover, saying the technology transfer would give China access to advanced military laser technology, would diminish Canadian allied military advantages. So, Madam Speaker, my concern is once it's out the door with China, their relationship with other countries like North Korea are things we cannot control. That technology should be under control.
The Honourable Parliamentary Secretary. Thank you, Madam Speaker. As I already said, because of the confidentiality provisions of the Investment Canada Act, I cannot give any detail on specific questions, but Canadians can rest assured that under the Investment Canada Act, foreign investments are subject to due diligence and a very thorough national security review. The review process was clearly set out in the Act, and the government respects it every step of the way. The current government welcomes foreign investment for the advantages that brings to our economy, as well as the opportunities it gives Canadian businesses to do business on international markets. Thank you, Madam Speaker.
Is now deemed to have been adopted. Accordingly, this House stands adjourned until tomorrow at 2 p.m. pursuant to Standing Order 24-1.